Good morning, everyone. For some of you, it's very early morning. After the morning, that's a great pleasure for me to see all of you here. This is the second time in a row we have such a conference, the round table that touches upon the matters of intellectual property. And today we deal with not only counterfeiting, but also the unfair competition. So our conference takes place in the place, one of the most important conference with respect of the trademark protection. We have the Association of Trademarks. Today, this association is difficult to mention, but there are 11,000 of association members from different countries of the world, almost from all countries of the world. These are the organizations that respect intellectual property rights. So today I inaugurate this event with a great pleasure because today we have the anniversary of 30 years for Kazakh companies. It's an impressive term, and that's a great event for our countries. And I would like to ask you to turn your mobile phones into silent mode for ensure the smooth conference. And I would like to start our conference with the welcome addresses, welcome remarks. First, we would like to welcome the representative of the Ministry of Justice, Rinat Kapyshev, Chief Expert of the Committee of Intellectual Property Rights of the Ministry of Justice of the Republic of Kazakhstan. Please, you're welcome to the microphone. Yes, you need to press on the button to make it red. Hello. Good morning. That's a great pleasure for us to see you. Thank you very much for finding time to come here and deliver the welcome addresses. Thank you very much, Yuri Albertovich. That's a great pleasure for me to welcome all the participants in the roundtable. On behalf of the Ministry of Justice of the Republic of Kazakhstan, I'm pleased to welcome you to the roundtable dedicated to the issue of combating counterfeiting and unfair competition in Kazakhstan and Central Asian countries. This topic is more relevant than ever as the level of threats associated with counterfeit products and unfair practices in the market continues to grow. Today, we are gathered here to discuss the contemporary challenges that companies and consumers face and to develop joint solutions and strategies to combat this phenomena. We have the opportunity to exchange experiences, analyze successful practices, and develop recommendations that will help improve the situation in this area. I would like to express my gratitude for this opportunity to attend this event to Molotov and Partners Company, as well as foreign guests from the INTA Association. I'm confident that our discussions will be productive and lead to constructive results. I wish all of you fruitful work, and I believe that the discussion that will take place today will be useful and informative for all participants. Thank you very much. That's a great pleasure for me to see you, and I will be eager to see your presentation. And I would like to tell you why the counterfeiting matters and unfair competition are important. If you compare the trade volume of drug trafficking, people trafficking, and counterfeit products, they represent the same ways, the same stakeholders involved in these processes. That's why when we talk about the fact that one needs to suppress and fight with counterfeiting products, at the same time, we mean that there is a combating drug trafficking, human trafficking, and other criminal acts. The same people take the same ways. They have similar
прибыльности торговлю ведут.
the same profitability, and This event takes place for a certain reason. It has a significant social importance. And now I would like to hand it over to Zauri Orenbekova, Director of Almaty branch of the Institute of Intellectual Property of Almaty. So, if you look at the number of branches and their importance, and as well as their size, that's a good evidence of what the Committee of the Intellectual Property under the Cabinet of Ministers of Kazakh USSR started. And after a few modifications, this branch is headed by Zauri Orenbekova. Thank you very much, Yuri Albertovich. That's a great pleasure for me to welcome all the participants of today's event. Dear organizers, dear Yuri Albertovich, I would like to express my gratitude for organizing this event. Today, it's a really important topic, the counterfeit products. And according to the agenda of this conference, I think this is a very important issue, not only for the property rights holders, as well as for the public authorities. They will find the reports and presentations interesting. All the insights that we cover today will allow us to share practices, and in future, it will help our further endeavors. When it comes to the work of the branch, along with the Department of Justice, and as well as dealing with the applicants, we perform the comparative analysis for the similarity, equivalence of the counterfeited products and the genuine products. This year, the number of applications increased dramatically. Before, there used to be around 15 to 20 applications per year, but this year, for this year, until September, we have 46 applications. It suggests the increase in fake products in the market. Yuri Albertovich mentioned that it's pretty early to mention it, but because I was given the floor, I would like to congratulate your team, Molotov and partner, on your 30th anniversary. Your team consists of extremely professional specialists, patent attorneys, legal experts. That's a great pleasure to work with you and your team. I would like to wish you future development, prosperity, and achieving best outcomes in your activities. I would like to wish all the participants of today's event a very fruitful work in today's roundtable. Thank you. Thank you very much. That's a great pleasure to see you. And now we would like to turn to the presentations. And now we will have the report on law enforcement practice in the field of protection of intellectual property rights. Again, the chief expert of the Committee of Intellectual Property Rights of the Ministry of Justice, Renat Kapashev. Good morning, everyone, again. And my report will have to do with the legal practice in the law enforcement intellectual property rights. It's well known that the spread of counterfeit products has serious consequences for both copyright holders and society as a whole, leading to economic losses, reducing competitiveness of companies, and deterioration of the quality of products and services, undermining consumer confidence.
Counterfeit goods often do not meet established quality and safety standards, which can pose a threat to public health and safety. In addition, violation of intellectual property rights undermines innovation and slows down the development of new technologies and products. Combating counterfeit goods is an integral part of protecting intellectual property rights, which requires not only cooperation between law enforcement agencies, copyright holders, and society, but also effective legal mechanisms and educational work. In accordance with the current national legislation, the legal use of the protected trademark is subject to a civil article number 9 of the Civil Code of the Republic Kazakhstan administrative and criminal types of liability according to Article 191 of the Criminal Procedure Code of the Republic of Kazakhstan in cases of criminal offenses provided for the Article 222 of the Criminal Code. Pre-trial investigation is carried out by the Economic Investigation Service of the Financial Monitoring Agency of the Republic. In accordance with subparagraph 33 of the part of the Article 804 of the Code of the Republic of Kazakhstan on Administrative Offenses, hereafter referred as the Code of the Administrative Offenses of the Republic of Kazakhstan, are empowered to draw up protocols of administrative offenses under the Article 158. The above protocols are drawn up based on the results of unscheduled inspections conducted on the basis of the Entrepreneurial Code of the Republic. The gradation between criminal and administrative liability is based on the amount of damage caused, i.e. the question of initiating a criminal case is raised if the cost of damage is 200 monthly calculation indices. In addition, the copyright holder also has the right to apply to the court independently in order to protect the violated right in accordance with Article 9 of the Civil Code. One of the priority areas of the Ministry of Justice is the formation and implementation of state policy in the field of intellectual property, along with the general coordination of the activities of the Ministry of Justice in this area and territorial bodies of justice, departments of justice of regions, sites, cities of national significance. There are departments for intellectual property rights, which within the framework of the Entrepreneurial Code of the Republic are entrusted with the control functions for conducting unscheduled inspections on the legality of the use of trademark of justice of region sites. Inspections are carried out on the basis of applications from owners of rights to trademarks protected in Kazakhstan, that is, they are of private public nature. Since the beginning of the current year, justice authorities have conducted 139 inspections of business and titles for illegal use of someone else's trademark. As a result, 132 violations of current legislation were identified. 133 cases were initiated and sent to court. 111 entities were brought to administrative responsibility. 9 million tenge was collected as a fine for the state. 250,000 units of counterfeit products were withdrawn from civil circulation for a total amount of approximately 47 million tenge. For example, one of the latest major results is an inspection conducted in the city of Almaty. The justice authorities stopped the sale of counterfeit products marked with the Lego trademark at one of the wholesale markets in Almaty during the unscheduled inspection, following of a statement from a representative of the company Lego Juris AS. Children's Lego construction sets were found in limited liability company B, which is engaged in wholesale trade. More than 3,000 units of counterfeit products worth more than 4 million tenge were seized. Today, the guilty parties have been brought to administrative responsibility under Article 158 of the Code of the Administrative Offenses of the Republic of Kazakhstan. The counterfeit products have been destroyed. It should be noted that the list of counterfeit products withdrawn from civil circulation is quite broad. These include household items, clothing, household chemicals, spare parts for cars, all kinds of gadgets, as well as children's toys and food products. The rights of trademark owners such as Toyota, KitKat, and Nesquik, Procter & Gamble, Henkel, AG and Company, KGaA, Chanel, Apple, Scepter, Levi's, Louis Vuitton, Lego, Puma, Toyota, Lexus, Nauris, Assam, Rajka, Alcom, Hugo Boss, and etc. from the local right owners. Criminal cases. What about it? Activities to protect intellectual property rights are also carried out by internal affairs agencies, the Economic Investigation Service, and the State Revenue Service. During the first half of the current year, the Financial Monitoring Agency registered two pretrial investigations related to the violation of intellectual property rights under Article 222, as I said before, in Articles number 198, violation of copyright and related rights of the Criminal Code, under which the amount of damage caused to the copyright holders amounted to 35.67 million tenge. In February of this year, financial monitoring bodies, with the involvement of justice authorities, conducted an inspection to prevent the illegal use of the trademark Mama's Nut, Mom Knows. This brand belongs to a Kazakhstani company, which is the first domestic manufacturer of diapers. During the inspection, more than 4,600 counterfeit diapers worth more than 25 million tenge were seized by the verdict of the Inter-District Criminal Court of Shymkent. Citizen D was found guilty under Part 1 of Article 222 of the Criminal Code for illegal use of someone else's trademark. She was sentenced to, in the form of a fine in the amount of 40 MCI, which is more than 147,000 tenge, and recovery of damages in favor of LLP Mama Znat in the amount of 25 million thousand tenge. In addition, according to the verdict, the convicted woman was additionally ordered to pay a state fee in the amount of 775,000 tenge. This example clearly demonstrates the inevitability of punishment for breaking the laws. On customs checks, to date, 1,025 trademarks of 332 copyright holders have been included in the custom register of intellectual property objects. Since the beginning of this year, territorial state revenue authorities have suspended the release of goods under 339 declarations for goods with signs of violation of intellectual property rights, with a total value of 18.6 million US dollars in relation to participants in foreign economic activity. 11 administrative materials were drawn up under Article 158 of the Code of Administrative Offenses were based on 8 materials. The court confiscated more than 400 units of goods with subsequent destruction and fines in the amount of 790,000 tenge were also imposed. I would like to give a few examples of law enforcement practice. In November of 2023, based on a statement received from a representative of the Toyota company, and scheduled inspection of IPA was carried out in the Almaty region. During this event, effect of illegal use of the Toyota trademark, sale of packaged motor oil, automatic transmission fluid was revealed. Counterfeit products in the amount of 520 units, 1,736 liters were worth more than 5 million tenge were seized. February of this year, over 48,000 units of counterfeit products, confectionery labeled with well-known brands such as KitKat and Nesquik, were seized in Shymkent. The counterfeit products were distributed by LLPB through wholesale distribution. In March of this year, also in the city of Shymkent, based on a statement received from a representative of the company Henkel AG and company KGaA, an unscheduled inspection of LLPG wholesale sales of goods was conducted. The seized goods, wallpaper glue with the designation Methylan, according to the conclusion of the expert organization, are similar to the point of confusion with the trademark Metelan counterfeit products in the amount of 14,000 units. Packages worth more than 7 million tenge were seized. To date, all persons have been held accountable under the Article 184 of the Code of Administrative Offenses. The seized counterfeit goods have been confiscated and are subject to destruction. As can be seen from the examples given, the sale and consumption of counterfeit products is a serious problem for society. I'm sorry, but what about the timeline? As a whole, in addition to work to suppress violations in the field of intellectual property, the Ministry and Territorial Division carry out measures to prevent and work against violation in the field of IP. As part of the campaign, national competitions, roundtables, internet conferences, meeting with entrepreneurs, arts, industrial sites, seminars in all regions of Kazakhstan with the involvement of territorial divisions at the national chapter of the entrepreneurs are helped to clarify the issues of protecting intellectual property rights.
Thank you very much for such an interesting statistics out of all questions and issues that we have. People ask us what are the most counterfeited products, and just anticipating this question, I would like to tell you that this is normally not a very expensive products. These are not jewelries. These are not cars. These are the products which the consumer, when he buys it, spends a few seconds just come up to the counter, buy something. These are home appliances, tobacco products, non-alcoholic drinks, and alcoholic products are also counterfeited. But this is the other group of the consumers that don't really care what they want to buy and what they want to drink. But this is what does not require careful examination before buying. These are the fast-moving consumable goods. Now we have another interesting report that will have to do with the establishing identity or similarity to the point of confusion. This is the product that can be different and not identical for some details that are obvious for the specialist and non-obvious for the consumers. Please, the floor is yours. Yes, could you please switch my presentation? Zaure Orenbekova, National Institute of Intellectual Property of Kazakhstan. Will I have a chance to switch slides myself? Okay, thank you. Okay, next slide, please. So the intellectual property rights are examined by the Special Institute under the Ministry of the Justice of the Republic of Kazakhstan. It is called Kaspatent. Kaspatent provides for expertise of all the industrial facilities, as well as holds the expertise of the patents, register and issue security documents, hold the state register of intellectual property, and publishes all the information in the official bulletin. The official bulletin is the open document publicly available at Kaspatent.kz. The state register is also a publicly available document where all people who are interested in can go to Kaspatent.kz and read these documents. The expert organization holds 9 types of state services that you can see them here. Among them, there is also the registration of the objects protected by copyright. So the intellectual property objects represent the inventions and utility models, as well as the prototypes. These are the objects of intellectual property. These are the trademarks, the places of origin of the trademarks. In 2022, the new object of the intellectual property was introduced. The geographical descriptions. Now let's talk about the trademarks. So, trademark is a designation used to individualize goods and services. These are the means of individualization. The stock company Rahat, Samsung. Rahat is confectionery, Samsung domestic appliances, Mega Trade Mall. This is the individualization of the business. Next slide. In order to provide the legal opinion to these designations of the trademarks, what kind of regulatory documents are required? The Paris Convention for the Protection of Industrial Property. This is the ancient convention, the ancient treaty, which provides the underlying documents in the sphere of industrial property protection, Civil Code of the Republic of Kazakhstan, Law of the Republic of Kazakhstan on trademarks, services, marks, geographical indications, and applications of origin of goods. Appellations of origin of goods. Next slide, please. So what kind of trademarks we have? According to the law, there can be the following types of trademarks like verbal, fine art, combined, volume, and letter. And there are also non-traditional trademarks. On the next slide, you can see them. The non-traditional trademarks can be a sound mark, a color mark, olfactory, positional, moving, Air Astana registered the olfactory trademark in 2022. These are the types of trademarks that fall under the non-traditional indications and designations. In order to register the trademark, the application is submitted to Kaspatent in the soft copy or in the hard copy. So the soft copy can be equalized as the hard copy. 90% of the documents are submitted in the soft copy. The only thing you need is the electronic digital signature of the applicant. What kind of documents are to be filed together with the applications? You can see them here. Okay, I wanted to dwell on this topic so much. Okay, next slide, please. Just in a nutshell, this is the name of the applicant and its location, claimed designation, and the most important thing is the list of goods and services for which trade registration is required. And attached documents are a copy of the document confirming payment for the examination service, copy of power of attorney in case of submitting application through business or its representative, or a charter of collective trademark in case of filing an application for a collective trademark. If the decision has been taken positively for the trademark, the decision or a certificate, as well as the extraction from the state register of the Republic of Kazakhstan are provided. As I told you, this extract from the state register of the Republic of Kazakhstan can be found in Kaspet and Gazette. Any person concerned can extract this paper from the CAS patent institution. This is the publicly available information. By obtaining the certificate for the trademark owner will have not the designation, but the registered trademark in this case, and will have the exceptional right to its trademark. Okay, next. And now, if there are different disputes for the registration of the trademark, if there is a dispute, then the appeal can be submitted to the appeal board. Furthermore, the challenging against the registration of the trademark can also be filed. I would like to note that the applications for trademarks are published in the official bulletin, and every person concerned can review the designated applications. And if someone has objections against the registration of the submitted file for application, the person can challenge it in the court. So these items, the data of challenging are forwarded to the appeal court. This is the pretrial resolution, and the court takes the decisions accordingly. If the applicant will not be agree with the decision of the appellation court, so the Board of Appeal will decide, and its decision can be resolved in the trial mode. So it includes all the disputes related to the protection of the intellectual property rights arising from the certificate, and all the disputes are examined in the trial proceedings. Okay, next slide. So the main topic is the setting of the similarity or identification. So, according to subparagraphs 1 and 3 of paragraphs of Article 7 of the Law on Trademarks, there will be done the comparative analysis by CAS patent, and I would like to demonstrate you different examples that were used to be in our practice for comparative analysis. In this slide, you can also see the verbal designations. So the trademark number 63682 was registered under the class of the products, class 2930. Xun She is the owner of this brand, is GSC Rahat, and there was a designation about Xian She. And according to the comparative analysis results, it was decided that similar to the point of confusion, because identical semantics, I'd like to draw your attention to the fact that when the verbal comparison is made, the three criterion are tagged identical semantics, the font, the writing, standard black font, similar phonetic pronunciation, and with respect to all these three criteria, the conclusion is made for the similarity of these things. For example, similar execution of writing, standard black font, similar phonetic pronunciation, Xianshi and O Xianshi. Following the examination, the following finding was made that Xianshi have the similarity of the class 30 of ICGS. The next example is the arts or pictorial symbols. Here the trademark number 63682, pictorial designation class 2930, All Food, Russian company, is the owner of this trademark. The comparative analysis was made with respect to the pictorial artwork. Based on the visual perception that is driven by the use of the single multiphotographic composition or similar color scheme with the provided set of the vegetables that are made in the natural form. They are shown in the stylistic cattle. It has the handles, it has the cover on top. All this leads us to the understanding that it may confuse the consumer because the designation of the same manufacturer of homogeneous products class, the ICGS class 29 cert. That's why it was decided that these designations are similar to the term of the to the degree of the confusion. Here you can see the combined designations. This is class 32 sprinkle products. Here you can see the combined combination of verbal as well as pictorial elements of the registered trademark. So the trademark was compared with the provided designation where verbal elements are present. For example, the word Buratina and stylistic image in the center. The head of cartoon Buratino wearing a hat with compound with all this. The color, the labeling, all of this is done in the single thematics, and the graphical execution of the label leads us to understand that this combined artwork are so similar, leading to the degree of the confusion according to class 32. So here you can see the combined of verbal and pictorial designations. Trademark 39523 Solpak is a combined trademark. The owner is to LLP Arena S. With respect to the given classes, there are several classes. I will not mention all of them. So these are the products and services. They are presented here. The comparative analysis was made with respect to the verbal designation Soul Park. It seems like one verbal vocal letter was added. And thanks to this, they are not identical, but very similar to the degree of the confusion, because the similar dominating word Solpak and similar font, similar color of the letters and transliteration of Solpak on the website of the compared brand was given as a Solpak in the Cyrillics. All these leads us to know that the combined verbal and vocal combinations are similar to the point of confusion. Similar dominant verbal designation of Sulpak of class 6, 1936 and others. Here you can see the example of combined designations, trademark N59 51678 for the ICGS class 3035 class of this nomenclature. So the owner is the Singapore enterprise. The trademark is my coffee, combined trademark. The comparative analysis was done of the combined combination you can see as Bass coffee on the slide. If you compare the artwork, the pictorial part, the single motive that the cup is full of coffee with milk, with the handle, and the fact that the full grains are scattered, the graphical representation of the fonts made in the Latin language, and single composition idea, and the location of all the graphical and verbal designation leads us to understand that these combined designations are similar to the point of confusion in terms of the products or service. So it leads the consumer to feel that this is the same manufacturer of similar products and services. So this is the way it is. Should I come back to some slides or? Well, all these works are performed to set the similarity to the point of confusion. All these works are done according to the rules of expertise of the trademarks, and all these works will continue in the same respect. So the Department of Justice always come to us when they have questions to define the similarity leading to the degree of confusion. So I think that in this respect, we will keep on working and developing our endeavors. Thank you very much for that. And now, thank you very much for that. So, unless there are questions, but we will put the questions aside for the later term. So, it's very difficult to moderate myself, and probably I will take time from someone else, but I will try to refrain from doing so. Please switch my presentation.
So before we talk about defending these things, let me tell you about what we need to take care and defend. We need to understand every company has its IP, but many people don't know about it. At least every company has its own trademark, trade name. At least it has a know-how. Basically, our meeting is dedicated to illegal use of trademarks. According to number of registered objects, is more oftenly met thing. If we talk about this, for instance, two trademarks in Kazakhstan, trademarks have been registered as innovations and inventions and places of the origins. That is why, in spite of the fact that firm names is more than 100,000, and it's more 170,000 firms had been registered. Nevertheless, we are talking not about firm names, but we are talking about trademarks and marks of service. Can you scroll it? To my point of view, to one of the key slides, I try to show it on all of my presentations because the main thing is not a material assets. It's a property of company. You cannot neglect it. You need to protect it. A registration of a trademark doesn't provide a rule to use the trademark. It's a very important regulation. Most of all, after the registration of a trademark, the owner has the right to prohibit the same or the similar trademark. Let me quote it. Establishing identity or similarity to the point of confusion. Before registration, anybody can use this trademark, but as soon as I register it, I have a right to prohibit the use of it. In Kazakhstan, there is no right to prohibit, but if we think about the sense of it, it reflects the essence of registered image. It's the only monopoly of the intellectual property which is defended and supported by governmental agencies against all others kinds of monopolies. There are very strict restrictions, but monopoly on the IP parts, it's needed to be we need to decide it. In Kazakhstan, when I first one gives an application for registration of a trademark, that person is right. And if you are late in this case, you will have difficulties in order to struggle with the owner. You need to prove that the trade, this object has an ability to be detected and defended. If you are the first person who filed the application for the trademark registration and you are in the law, so to say, you have an analogy with the real estate. If you purchased a plot of the land, you registered it. If you sold it, and you registered it, and all the registered property, all negotiations should be registered. Licenses, sub-licenses, and some sub-licenses are needed to be registered. If you do something with a registered property, you need to register it anyway. Territorial protection, let's talk about it. If a trade mark registered in the US, it's not kept by local legislation here in Kazakhstan. If you need to have a protection in a certain territory, for instance, it's Kyrgyzstan, the Russian Federation, or other lands, if it's not registered, there is no security and protection of violated rights is impossible to obtain, but it's difficult. If you need to register something, you need to register it in all countries where you suppose use of it. You need to use your trademark. If you don't use it in 3 years period, then it can be annullated in registration. During 3 or 5 years, you need to use it. For instance, if I like it, but you don't use it and you are honor it, then I can say this trademark is not needful for them, but I need it. And in most of the cases, if I fail to prove that it's my own trademark, it would be annullated. If I filed an application for the registration, then I can obtain this trademark. Finally, if you don't protect the trademark, then the value and cost of the trademark is non-material assets, not substantial assets. It will decrease. Its cost will be decreased. Other people will use your trademark not according to its purpose or produce goods of low quality, then my products will be sold in low volumes, and the cost of my trademark will diminish our basic topics. It's a counterfeit goods, a product and its packaging in which a trademark or geographical indications and name of the place of origin of the product or designations similar to the point of confusion. Жанар Turmargabetov will tackle this issue in more details, and he will set more definitions. And let's talk about the significance of a trademark. Let us not confuse with the parallel import or in the counterfeit situation when it's a concrete violation of a trademark rule rights. It's a writing or printing or trademark on the package or on goods. Counterfeit. Let's talk about the trademarks and their types, and let's move on. We have the similar slide. You see different kinds of you have a digital, pictorial, and graphical. Let's move on. In order to choose a right trademark, you need to understand the goal of a registration. What kind of services and goods do you need? What for do you need it? And what would be a territory of its use? If you want to understand what you want to protect, you need to answer these questions: what for, and what kind of services and products do you use it, and what would be a territory where you would use it. Here you can see choice of a trademark. If you remember the previous slides, I liked the first example with Rahat, and Rahat is inscripted in an oval in such a way that it could be read with difficulties in Kazakhstan. What about reading it in China? They would try to understand it at a hieroglyph. Maybe they couldn't understand it. Maybe in Cyrillic you can read it with difficulties. If you remember Bank Turan Alem in Kazakhstan, when they opened their branch in Turan Alem in Georgia, local citizens started to produce new wine, and with pleasure they brought it Kazakhstan, and nobody did anything against it. It's not a bank service. It was so kind of advertisement. It's a violation of rights. It was absent, and from the point of view of right owner, there was no rights violation. It's an area of private rule. I have a choice to struggle or not to struggle with these guys, or do I provide people choice to use it? It's anyway, it's my point of view. Whether they violate my rights or they don't. If you want to start working in other marketplace, is there any violation of other rights? If there is no violation, then I need to protect my rights. It's one of the parts when there is a you can define a violation of rights or absence of these violations. For instance, trademark of Zhiguli wasn't imported successfully abroad because Zhiguli reminds Zhigolo word, and Zhiguli were renamed as Lada, and the trademark was registered in different countries as Lada, and Lada and there was not so, it was a good automobile, and Gigolo and Zhiguli were sounded alike, and it wasn't good. I'm sorry. Let me increase my speed. Pajero was successful. I mean, in our country, because the name was received in English transliteration. In Spanish, in the middle there is a J. They wrote it as Ha, and in this inscription wouldn't be sold successfully. Let us scroll fast because I understand you. Okay, the phonetics in different countries, the same animals and the same insects, reptiles, creating the same sounds can be understood by different nationalities differently according to their phonetic range. These presentations will be uploaded in the internet. In different countries, sound of this animal can be croak in English, and the same sounds in different countries can be received in a different manner. This is my name. For instance, this is my name. In different countries, I do not promote any trademark now, by the way, and my name and the trademark will be viewed differently and will designate and differently and have different meanings in different countries. My name will view and will have different literal forms and phonetic, semantic, and graphic. There are three main components. My name in Chinese language means special insight if you write it in hieroglyphs correctly. It depends on how do you write your name in hieroglyphs. It will have a different meaning. In one of the conferences in Beijing, I worked with a notary specialist, and I chosen this type of inscription of my name. So semantic and usage in the movies would be attractive. Sometimes they call it, use it in Japan, it's a lily. In Korea, it's a glass. My name means glass. From practically in Korea, my name can be registered for production of glass, and in Japan, it wouldn't be registered for flower planting or something like that.
That's why the semantics is extremely important. This is how our brand names are formed in other countries. So here you can see the inscriptions that are similar to you and have different connotations. So they look differently, they mean different things at the end of the day. So, and now about Coca-Cola. If you just take Coca-Cola in Chinese, it means not this is the direct translation, but associative, like the bite of wax. Wax baby. So a huge amount of money was spent to develop a different name out of this trademark, and now it sounds like a Coca-Cola, a mountain of happiness or taste happiness. So this associative science in China are extremely important, because when you enter the Chinese market, just check how your trademarks will be sound. So, and now there are also issues with international registrations. Both the first and the second trademark in Kazakhstan have no distinctive capabilities. They must not be registered. The first sign means greeting to you, a distant traveler. And second, go to hell, random people. So for Kazakh people, in order for those who see those hieroglyphs for the first time, both the first and the second inscription are the same. That's why the basic registration of Kazakh trademarks cannot be used for display spreading to other countries. That's why you should always remember that in different countries, the sign will look differently, will mean a different thing, and will sound differently. And this is the reason why, in order to understand what and where you need to register, you must be in clear and you must be very conscious. Mm, You need to do the research because it will lead to the confusion or unfair competition. That's why you need to know what alphabet is to be used in the beginning. Um, so the next thing is Hon or Exon. This is the back language. It was seemed for me that it is Xon, but in Ha it's derived from Cyrillics. It is pronounced like Hon, but not Xon. BMW. So there were different requests. Either it is BMW or Becha or Boomer. Are they protected or not? Becha or Boomer? No, these are two different names and they have a different meaning. So I used to have a black Boomer that I colored in red, and I received red Becha, but not black Boomer. So this is the same Rahat. Does it sound Rahat or Raksat? So it's not clear. So for us, it's also unclear, but if it is exported to some other country, it will not be distinctable. So Coca-Cola is written in different languages. If you don't know the design, if you don't know the strips and the combination of red and white, we will never understand what is written here. Is it written Coca-Cola or not? So in order to protect from the customs point of view, Jonathan Nurbenbekov will talk about it. So one needs to register the trademarks, only the verbal separately, the verbal part separately, Cyrillic separately, and in Latin separately for the custom clearance experts to understand what trademarks to inspect, what trademarks not to inspect. And I think that is it from my side. Well, I try to squeeze myself in the timeline. Okay, yes, and please scroll down other things. And that is seemingly it. Thank you very much for your attention. And now. That's okay. That's okay. We will have time for the Q&A session. We will pass the Q&A session to the offline session. And now I'd like to hand it over to Saulia Kushembekova. She is the partner of Bolotov and Partners Kazakhstan. She's dealing with features of unfair competition using examples of disputes. All the issues of the trademark registration will go through the hands and through the desk of Saulia. Hello, everyone, dear participants of our event, of our roundtable. That's a great pleasure for me to see all of the familiar and unfamiliar faces in this room. That's a great pleasure for me in any case. Okay, could you please start my presentation? Well, when it comes to the unfair competition, regulating the using the norms of Kazakhstan, the use of the Paris Convention of the personal rights, but the key norms they are contained in the Entrepreneurial Code of the Republic of Kazakhstan. Next slide, please. Next slide, please. Yeah. Okay. So here you can see the edition that was in effect until March 7, 2022. If you can see on top, the unfair competition was any competitive action aimed at achieving or providing an undue advantage So in this case, please take in mind the provision of this. The actors of the unfair competition were not only the entities of the market, but also the public authorities. But in the new edition was provided in accordance with the regulation of the Eurasian Economic Union. The unfair competition is any actions of the market entity, group of persons, or several market entities, group of persons aimed at acquiring advantages in entrepreneurial activity. So the public authorities which are taken out from the unfair competition. But in my case, the public authority should also be the factors of unfair competition, because some bidding processes, some bidding projects are provided to some companies and for others not. In this slide, I would like to talk about the existing condition, what competition is unfair, or if it is an unlawful or dishonest act, unfair, contrary to business customs, or involved causing or threatening harm, or causing or threatening to cause harm to business reputation. In here, I'd like to draw your attention to the fact that the legislation provides for the causing or threatening to cause the damage. These are not mm, the real damage, proven damage, or the costs. As far as we know, with respect to the trademark, it's so difficult to prove the real damage because now we don't have neither the methodologies, guidelines, or calculation of the really caused damage with respect to the trademark. So here I would like to dwell on some articles of unfair competition with respect to the legal use of someone else's trademark. First is the Article 138, the use of the trade name or similar designation for similar goods. Here you can see the example of that VD40 is used, WD40 is registered in the form of the bottle, or sometimes HD40 can be also used, which is similar to WD40. Another example is that when a similar designation is used with the naming Coca-Cola, where a color combination as well as the way of writing is used, Cola Gazette. I would like to also draw you to the unfair competition with respect to the copyrights. Not all copyrights are included in there, but the use of something with no permission of the owner, so the use of the names of the artworks. So we didn't just the use of artworks. There were no examples. That's why I didn't give them here. So the use of the trademark on the packages that may lead to the confusion. Um, and mislead the consumer. So you can see the branding of Almaha or like Panda. So Coke and Panda. So these are the brands, the trademarks that are pretty known on the territory of the Republic of Kazakhstan. So one of the purpose of the infringers is counterfeiting Coca-Cola, well-known brand. The same goes to Panda. Panda fully copies the drink with the same color. It seems like the orange is on the background, but Panda is depicted here. It is something on the wedge of between. It's so difficult to prove whether the trademark is violated. And I would like to talk about the copying of external sites. Here are the examples of the packages that were found on the market of the Republic of Kazakhstan. So the first example of Haram were found many years ago. But here you can see the copy of Marlboro labeling, the same writing, the same depiction of the package. But because there were no supplies to the Republic of Kazakhstan, there were no legal lawsuits against them. But when it comes to Baltica, as a matter of fact, what we need to understand is that Baltica has always been using their own brand name, and they have the grading of the beer five, six, and seven. Recently, on the market of the Republic of Kazakhstan, in the Magnum network, we found Zatersky goes the same packaging of blue color, the same seven, but they don't have the grading there. But in this case, if you don't note the inscriptions and just if you look at the package of itself of the blue color, then there can be a misleading because the same elements are used. But I don't know to what extent they have some close relations between Baltica and Zatetsky Goose. But as far as the consumers know, Baltica is Russian brand and Zatetsky Goose is Czech brand. So in this case, either the consumer will uh, be led to believe that there is a interrelation between those, or under the permission, the similar um, labeling is used. And now I'd like to talk about the features of protection against unfair competition in Kazakhstan. First is that illegal use of a foreign mark, most often by foreign mark, the court means a mark registered or protected in Kazakhstan. So at the same time, this idea is being promoted by the legal and state authorities because when they say that some foreign trademark is used, they tell like it's not registered in Kazakhstan. That's why it's not a foreign trademark. But for me, the foreign trademark is the trademark that can be used on the territory of the Republic of Kazakhstan that is perceived by the consumers as the trademark of a certain legal entity. And when the same trademark is used by some other entity, is considered as the foreign one. But the legal practice is not is like ambiguous because when the trademark was considered as the registered and non-registered one. Another peculiarity is that according to the Entrepreneurial Code of the Republic of Kazakhstan, the unfair competition provides for the similarity of trademarks, after the use of the trademark or the similar trademark. But sometimes in the courts, the similarities and the identical are proven. Sometimes it happens when you can see the same goes with Baltic and Zatetski goose. They have the confusion or similarity because they have different pricing policy, different naming, but they are similar in from the general perspective, and this can be the act of unfair competition. But unfortunately, in the courts, even if the Supreme Court decides, there can be the similarities. And the next thing is that unfortunately the antitrust bodies do not perform well. Could you please show the previous slide? Because the antitrust authority shall refuse to satisfy the complaint if it is discovered. Sometimes such cases are pretty rare. Sometimes similar labelings are used, and when it comes to the quality of the registered trademark, the court just make the other party reimburse the cost, the damages. And the last one is that Kazakhstan has no norms that provide the canceling of the trademark, which is registered for unfair competition. So there was a case in our practice when an American company entered Kazakh market and worked here for 10 years with highly state-of-art equipment and sophisticated equipment. They had a trademark, and then this team of two people tried to participate in the bidding process, but they were rejected. And what they did, they registered the trademark on their name. And after registration of the trademark, they started to demand from American companies, the licensor of those companies, to recover cost. And it was the unfair purpose. The company knew that there is a trademark and the owner of this trademark is the US company. Unfortunately, it was not taken into consideration. The only thing that was taken into account that there was an unfair competition and misleading. The fact that they used their trademark for some developments and despite the fact that the American company used the equipment, it was also considered as a leading as a misleading. So there can be a pretrial settlement, there can be a settlement agreement, there can be administrative and legal methods of protection, appeal board, anti-monopoly authority. When it comes to not like the unfair competition, but also the misleading of the consumers. But actually, these things are the same. And another thing is the appeal to antitrust authorities. But antitrust authorities, they don't work well all the time. So, and now I'd like to talk a little bit about the competitive advantages about Ziva trademark, and a similar product of Eva appears the napkins with Eva name appears. When the claim letter was filed, they didn't agree that it was an unfair competition, but stopped the production. When it comes to unfair competition, there are some disputes, and when the claim letters work against the trademark, and they are effective in 70 cases, but sometimes when it comes to unfair competition, the claim letters don't perform at all. If you spend huge sums of money to inspect the brand and to find the similarities of products, so they will suspend it, and the claim letters don't work well. So in the next slide, you can see the case of the appeal court, Burger King Corporation, when it entered the market of Kazakhstan. It filed the application for the registration of trademark, and it turned out that the similar trademarks are registered to two Kazakh companies. You can see King Burger, and with respect to this brand, there was an appeal to the appellation court. We were appealing by referring to the fact that the Burger King is well-known company. It's a well-renowned company, and Kazakh consumer could have known about this trademark from the media, from the internet, and Kazakh consumers, they travel a lot and they could have seen this brand somewhere else. In this case, the appellation court and appellation council agreed with us, and it considered it as misleading and canceled this claim. And this is how King Burger was used on the territory of the Republic of Kazakhstan. You might have seen that. So the next one, the next one, when it comes to Burger King, after some time, the challenge was filed, but the appeal court decided that there is no misleading. So what it means that the practice of the appeal court, appeal council is not stable. In one case, it may provide for one type of the decision and ruling, in the other case, the other. So it depends on the members of this commission. So when it comes to Burger King, we have resolved this issue in the legal premises, the court premises. So here one can be one of the examples when we manage to discontinue the use of classics and prima. So here, when it comes to civil law methods of protection, as far as we know, there toffee chocolate. mm, uh, Toffee company found uh, the chocolate products, Chocodance, and when the Toffee company submitted the registration of trademarks of the Republic of Kazakhstan, there was a rule that there are some registrations that can be three-dimensional mark of the form of a candy cane. So Toffee company tried to challenge the use of choco cans, but because this company didn't have rights as it entered the market, it lose use the chance, and we as the company offered to use their brand as the globally known trademark. And when we filed the case to the court, the opposing party accepted our claim and discontinued the production. And another example is the use of Doshirak. This is the brand name that was registered by Doshirak And here, this is the Doshurag, the registered on the Kazakh companies first. So we have sent the appeal to the appellation court on the unfair competition, and only in Supreme Court of the Republic of Kazakhstan, they issued a ruling to satisfy the claims in full. And at the end of my presentation, I'd like to tell you that the practice of reviewing the unfair competition is unstable, because this is one of the most challenging lawsuits of the Republic of Kazakhstan that requires um, a huge evidence base. We need to review the testimonials of different consumers, different facts of the distribution of these products on the market. But there is a matter of norms of the existing legislation. At the same time, there are certain gaps. So in this case, I would like to tell you that for sure some of those cases are inspected, and we cannot guarantee you the definite result of the examination. Thank you. That's it from my side. Thank you very much for such an interesting presentation. Okay, Andrei Reznikov, British American Tobacco Kazakhstan, unfair competition and the fight against illegal products in the tobacco industry. This is when we go from the general to specific to the practical
Да,
one.
спасибо большое. Добрый день, уважаемые коллеги. Мне очень приятно быть приглашенным, иметь возможность
So, dear
участвовать
colleagues, that's a
в
great pleasure
таком
for
круглом
me
столе
to attend
в
such
окружении
a round
профессионалов
table
и
surrounded by
обсуждая
professionals and speak on
животрепещущие
the
темы.
topic of unfair
Я очень
competition and the
кратко
fight
хотел бы
against illegal
представиться. Меня
products in
зовут
the
Резников
tobacco
Андрей.
industry. I'd
Я
like to
возглавляю
introduce
департамент
myself. My name
товарного
is
вопроса
Andrei
и
Reznikov.
внешних
I'm the head
связей
of
British
the
Tobacco
Department
Kazakhstan.
for the
Я
Foreign
работаю
Relations
в
of
компании с 2010
British Tobacco
года, работал
Kazakhstan.
в
I've been
Беларуси,
working at the
работал в
company since
России
2010. I
в
worked in Belarus, I worked in
схожему
Russia
направлению
with the
деятельности.
similar
И
area
в
of
этом году
concern.
присоединился к
And
компании
today, I mean, this year I
Kazakhstan
joined
Professional
the Kazakh
Tobacco.
company. Okay, next
Да,
slide.
и, в общем-то,
Well,
переходя к
turning
проблематике,
to
вопросам,
the
с которыми мы сталкиваемся
issues
в
that
товаристве
we
отрасли
face in the
Казахстана,
tobacco industry of
в
the Republic
принципе,
of Kazakhstan.
переходя к нормативным
And turning
определениям,
to the
мы неоднократно
regulations,
говорили о
it
том, что
has been
такое
said
добросовестная конкуренция
once and again
и
about the
что
unfair
является ее
competition
частым
and
случаем, а именно
their
неправомерное
particular
использование
cases.
каким-либо
It means
индивидуализацией
that there
данного
are a lawful
товарного знaka.
use, ways of
И
individualization, especially the
в
trademarks.
табачной отрасли
In the
здесь
tobacco
мы
industry,
чаще всего
most
сталкиваемся
of
с ситуацией,
frequently
когда
we face the
правительство,
challenge
представляя
when
нелегальную торговлю и таким
the
образом в рамках нелегальной торговли, соответственно,
legal
являясь
trade is
контрафактом,
there, when
либо
there is a
недобросовестным
correlation between
использованием
counterfeited
данного знака
products and
для незаконного ввоза,
illegal use
то в первую очередь
of the
мы обращаем
products.
внимание на то,
So in
что
the first
в Республике
case, we
Казахстан
note the fact
все
that
производство
In the Republic of Kazakhstan,
товара,
there is no production of
практически весь он
counterfeited
приезжает к нам из-за
products. So we
рубежа.
receive
И
such products
это
from
первая
abroad.
информация.
And
Соответственно,
that's
мы
the
можем
first
видеть,
important
что
case.
все, что
And what we can
касается
see in here
контрафакта, оно
is that
попадает
everything that
под
has to do to
такую
the counterfeited
классификацию
products fall in
определенную.
the area of
И второй
the
важный момент, я
overlapping
еще
of the
посмотрю на
circles.
слайде,
And
здесь
the in the next slide,
и
there
второй
is a
важный
thing I
момент
just
состоит
want
в
to
том,
show you.
что
Another important thing
практически
about all
вся
this
продукция,
is that
которая
all the
производится,
products that are
она именно
manufactured
нелегальна.
here
То есть нет
are
такого
illegal sometimes.
прецедента,
So
по крайней
there
мере,
is
мы не
no
видели,
the
чтобы
case like
продукция, сходная
the
достижения
products
или
which is
обозначенная
similar
незаконным рекламным
to the
знаком,
point of the confusion, close to the
приезжала
point
в
of the
страну
confusion,
нелегальным образом.
enter
В двух
the
словах по
market of
примеру,
a
сколько
country in
мы
a legal way.
просматриваем в
But
таблице,
because we treat this issue
то
in
это
a
объем и
comprehensive
масштаб
way,
нелегального рынка
the
достаточно
volume
понимаешь,
and the
чем
scale of a legal market
представить.
is something we need to take into
Вы
consideration to
видите,
understand what we will deal with.
есть четкая
So you can
тенденция
see it in
в
here
товарном
that there is a
производстве
clear trend that suggests
нелегального
the
рынка
growth
в
of
Республике
the
Казахстан.
illegal
На
market of the
сегодняшний
Republic
день
of
эта
Kazakhstan.
цифра
As of
составляет
today,
9%
this number is
всего потребления.
9% of the total consumption, and it leads to the loss in budget, which represents 35 billion KZT annually. So that's an impressive figure, and I think that the government managed to could have managed the use of their funds if this money were credited to the state budget. And just a couple of words about the key issues of the legal rights of our services. And so these are the products that are designated unofficially with trademarks or other designations that are similar and that represent the similarity to the point of confusion. These products are considered illegal. So this is pro and cons, because the mechanism, the framework of legal involvement is provided, and the cons is that you cannot submit the claims to the owners of the trademarks, because those people who are involved in the circulation of this trademark, they don't know what they are doing, and they don't know what legal remedy methods they can use. And one of the example we want to show you is that during the trade of the illegal products, there are significant advantages that illegal sellers enjoy, and they cover the losses related to the liability and other damages incurred by these traders and sellers. So this is the price advantage, just in order to demonstrate you in an illustrative way what the picture looks like. So the market for the legal user cost of 150 KZT, and the legal product cost 820 or 1,100. Such a pricing advantage can be achieved by significant saving on the taxes that are not paid. So here you can see the number from 356 tenge per pack, but this figure may go up significantly. Well, the next slide. This is how we see the solution of this issue. Because we face the fact that this problem is a comprehensive one and it's widely spread, so we take every single effort to somehow bring the private sellers to the liability that are involved in this turnover. And as this practice suggests, it does not resolve the issue and does not even lead it to the state of the resolved ones. So here we can see the need to have the comprehensive ways of combating, and one of the effort provided is the enhancing the liability measures up to the criminalization of certain actions. And now we face the fact that the traders have the certain advantages in the turnover and the profits, and despite of the fines, despite of the risks that may incur, they know that they will be able to compensate them to a greater extent. And the next element is the increase of the motivation of the law enforcement agencies. And here we mean that the comprehensive and fruitful work with such authorities must be there, and it's needed to help and provide the relevant support for them to be more knowledgeable about this issue, as well as setting certain motivational solutions just to incorporate has those positions and to make them involved in all these processes, and the increase of the framework and mechanisms that prevent those facts. And today there can be the appearance of illegal products to the country, and it happens because of some loopholes in the law and violation of the laws. So it leads to the increase in prices, because the increase in prices will contribute to the pricing disparity that allows them to manufacture the products that can be attractive for the end consumers. So thank you very much for this opportunity to speak at your round table. Thank you very much, Andre, for such an efficient, for such a very concise, like the bullet points way of speaking. And now Anton Bankovsky, Gorodinsky and Partners, Kazakhstan. Gorodinsky and Partners is the largest legal company in the post-Soviet space, dealing specifically with intellectual property rights. And we have the representative of Kazakh division. Welcome.
Can I switch it? Do we have a remote control device? Hello, dear colleagues. My presentation will be in the common details. Combating counterfeiting and unfair competition in Kazakhstan and Central Asia. Disputations of unfair competition are considered in the court if there are infringements by the territory of the Russia or Kazakhstan, if there are violation of trans-border territories. These disputations can be matter of consideration of Eurasian Economic Committee. Traditionally, defendants protection of these kind of rights can have administrative responsibility and criminal liability, and this understanding of liability is why that intellectual property rights term. At the same time, it is included in protection of IP property. There are no identical things, but similar mechanisms are used in this case, and this part of administrative liability. Switch to the next slide, please. On this slide, you can see a civil liability. The burden of proof is on the plaintiff. There is a possibility to request evidence from government agencies. In some conditions, there is a possibility to request evidence from not only from plaintiff, but from the opposite side, from the defendant. Next slide, please. Pros and the NDS of case. When we look at the cases of anti-monopoly agencies, there are process. Governmental bodies can directly collect proofs, and they have special authority in this case. At the same time, the proofs can be used in the future if the right owner can go to this kind of civil right context. The liability during consideration such kind of cases of unfair competition means paying of fines to the state and end of the function of the activity in order to transfer to the budget's income received as a result of the violation, Part 3 of Article 31 of the law on the protection of competition. There is a possibility of mediation. National legislation has no right concrete details in this case. Next slide, please. There is either a turnover fine or income from unfair competition is collected. We need to say that Eurasian Economic Union has a fine in case of non-compliance is subjected to recovery by claim audit. It's a turnover fine, which means up to 1 million. Turnover is absence in this case. National legislation prescribes serious fines in this case. Next slide, please. Among kinds of unfair competition legislation and highlights using results of anti-intellectual activity means of individualization and results of intellectual activity divides violation of authorship rights and patent rights and the use of means of individualization. Next slide, please. Where do we need to contact? The administrative procedure does not exclude the possibility of filing a claim for recognition of action as an act of unfair competition and directly to court. It's a clause 5, clause 61 of the resolution of the plenum of the Supreme Court of the Russian Federation of 4 March 2022, number 2. If unfair competition has a border character, this can be considered by Committee of European Committee. Next slide, please. If Eurasian Economical Commission can be considered before application to Eurasian Economical Union, you can go to a pre-trial order and to regulate your dispute with the calling via consultation. On this slide, you can see procedure and subject of proof on a national level. This is submitting the application to the FAS, as in this case, initiation of a case of a refusal of initiation, one consideration of the case decision on the Federal Anti-Monopoly Service by a high-standing agency. Next slide, please. Fact of unfair competition practice and legislation tends to divide. Illegal use of someone else's intellectual property does not in itself constitute an act of unfair competition. Sometimes there are unsuccessful achievements. In this case, as a rule, courts they strengthen in their resolution standards in order to divide these definitions. This is clause 30 of the resolution of the plenum of the Supreme Court in the Russian Federation. Illegal use of someone else's intellectual property does not in itself constitute an act of unfair competition. As I said, in practice, issues arise about dividing about this unfair competition or other cases, or vice versa. Next slide.
Для признания факта совершения недобросовестной конкуренции, как правило, требуется наличие четырех признаков.
How to prove effect of unfair competition? You need 4 signs. All the signs are at once. So you need to prove that there is a competitor on the same marketplace of service and products, and action were directed to receive entrepreneurial activity profit. they contradicted the provisions of current legislation, business customs, requirements of integrity, reasonableness, and fairness, and it caused or were capable of causing losses to another economic entity, competitor, or damaged its business reputations. All these signs are needed to be considered during case of unfair competition fact. Now, on the next slide, I have several descriptions of concrete lawsuits. I want to go into details. In this case, you'll have it in the presentation. If any question would arise, we need to clarify it individually. As a recap, I can say that today anti-monopoly legislations provides effectual protection of intellectual property, as in Kazakhstan and other European Economical Union. Practice of violation of this kind of in this area is not a single division of governmental agencies can act differently in similar cases and consequences. We need to take it into consideration as earlier violation of direct right mark can be foreseen. The problem that this or that act cannot be qualified as the violation of a trademark. Often it's a unfair competition as it is. Sometimes penalty sanctions are connected in this case, and it's income for the state's sake in the case of unfair competition on the basis of proofs collected while investigation on unfair competition can be used other ways of civil rights protection, and you can ask from infringer losses, and you can use it in the cases for proving that compensation is needed in this case. And that's all. Thank you very much.
Thank you very much for the presentation. We have small slide for Q&A session. You have a chance to ask all your questions to the speakers. Anton, thank you very much. Sonata Turmagambetov, legal company, Molotov Partners. Thank you very much for your report. And I would like to know about the remedy matters, the security matters and measures of the antitrust regulation. So there can be certain measures like arrest or seizure of products. So according to the legislation, the arrest of seizures of products are not provided but by the antitrust bodies. Only antitrust bodies can do that. Only law enforcement agencies can do that, but not antitrust bodies. So these matters can be filed to the court and they can be challenged. Yeah. So if the fine is imposed in the certain volume, so this is not exempted from the citizens to the legal proceedings when they have the same rights to claim the same rights that were given in the administrative legal proceedings. So the court may recover the same amount for the second time, but now in the favor of the right holders, may it happen that the infringer bear hold liable twice, yeah, for the same action. Yeah, I think that it is a little bit excessive, but yeah, it may seem so. But here, I think you need to divide that one thing as public, the legal impact on the infringer or the public violation of certain grounds, certain bases taken by the government, and recovery of losses provides for the protection of the person suffered. And if you consider the far similarity, so the criminal action is the something that is punished by the government for certain losses caused to the state. Yeah, I just want to know the amount. I'm concerned about the amount that in the administrative proceedings, in the civil proceedings, in administrative and civil court cases, if the amount of the penalties will be 0.6% from the profit in the civil proceedings, the same amount can be claimed by the demandant. So we need to consider not only the valuation of the proofs and the size of the compensation, and we need to prove it. And then the court takes the decision. And when the defendant sees the amount of the compensation, one of the argument will be that it already paid this amount, and in the civil proceedings, in the civil code, the court may take it into consideration and set and decide about a lower fine, lower amount of fine. Okay, just introduce yourself and ask questions. Whom you will ask the question? Anton Bankovsky or to someone else, to the representative of Mr. Thank you. So my question is Birjan Kirkibayev, Kaspi Gazette. So I have a representative to question to the Minister of Justice. Okay, currently it is well known that after February last year, a huge number of events took place, and at least there is one big actor on the territory of the European Economic Community that allowed to do so. So we see a huge number of products that within the Eurasian Economic Union pass the borders and appear on the territory of the Republic of Kazakhstan. And it leads to the fact that these products are cheaper that are formerly imported to Kazakhstan. There is a matter of custom clearance. We don't have a border with Russia. Do you have any practice of protecting Kazakh producers from parallel importations? With respect to the parallel import, I would like to precise that according to the existing legislation, as well as the international treaties and obligations of the Republic of Kazakhstan, there is a regional principle of the coexistence of rights. We mean that there is no limitation with the Eurasian Economic Union. When it comes to the parallel import through the territory of the Republic of Kazakhstan, proceeding from third countries that are not the parties of the Eurasian Economic Union, we have such examples in my presentation. I showed that it has to do with Toyota Motors Corporation. We seized the oils. One of the latest example is that these oils were brought from third countries illegally. I already explained that we are in the Eurasian Economic Union. Thank you very much. It seems to be all clear. Now it is 11 a.m. sharp. We can take a few minutes from the coffee break, or we can go outside and we will play the democracy the way you want. Or if the ones who have questions now, you can ask them in person, but not they let those questions turn into the discussions and debates. My name is Gulmina House Rising. We have been there in the market for 14 years, and we are working actively, and we pay huge taxes every year and every month. But unfortunately, like we are working with the network of pharmacies, and we can see a huge trend that the counterfeited products are imported, even from such well-renowned brand. Well, I represent a not well-known brand, for example, condoms, the drugs for children, syrups, and others. So I wonder why people buy and companies by circumventing all those processes. They enter the market and they sell the products for the treatment of children. But these are the pharmacies. We are talking about the pharmacies. Every year, every month, we pay taxes. We register our trademark, our brand. So just tell me, please, do you have a question specifically to someone in this room? But is it a rhetorical question? To whom I have the question? To the custom authorities with respect to the protection of the trademark, because we have also registered the trademark, and many companies or register their trademarks too. And that's pretty relevant today. I would like to address this question to anyone in this room who is competent to answer my question. Well, I would like to ask Jonathan Magomedov to take this question, because he deals with these matters in the everyday work, but we have the representatives of the tax authority of the Republic of Kazakhstan. Hello. I'm the head of the department of the products declaration department. This is the second day I'm appointed to this position. And thank you, congratulations. I will try to answer this question. Yeah, uh, that's the onset, the good onset of your career. Well, I prepared myself for this seminar, and custom authorities, like many other authorities since 2018, undertook the electronic declaration through us. No one, it is submitted in electronic form. Earlier, before this system worked, had another one, two system that provided for 100% control of all the declarations for the products that are important on the territory of the Eurasian Economic Union. But because in 2018 a standard one system was introduced, there are certain supervisory methods like categorization of the products by product goods positions. It's divided into 4 corridors. Green corridor without the involvement of custom specialist. Red corridor is when the customs inspection or expertise is performed, and the yellow corridor is when the documentary control is done, and blue corridor is done after the issuance of the products. When it comes to your specific question, the customs authorities are guided by the code on the tax regulation article 193. It's clearly stated that when the declaration is submitted and when the inspection efforts are required, the custom authorities are only guided by the risk management system, where specific recommendations to the employee is given. And answering your specific question, when there is a recommendation for the intellectual property objects is provided, the employee who carries out the control should go and document and check the documents. And if this mechanism does not work, 70 to 80% of customs declaration passes through the green corridor. There are also the foreign trade actors when they submit the declaration pass the wrong trademarks, they change the designations and go through the green corridor. In this case, tax authorities may not stop such declarations because the person passes through custom clearance, so within 1 second it is allowed to the green corridor. And sometimes there are trademarks that are not included in the roster of intellectual property rights objects, and only 2% fall under the customs inspection. And in case if such products are not included, the tax authorities only in 2% of cases may perform the control. In other 98 cases, they may go unless without customs control. Some foreign trade activities actors are unfair. They didn't go through green corridor, and you need to understand that the Regional Economic Union has borders not only with Kazakhstan, Russia. There are also other countries. The borders are very large, and they can be imported from different countries by bypassing the border of Kazakhstan and brought to other territories. I think it should be a complex effort. And after importation of the bodies, I don't know which authorities engage that, but customs authorities with the third countries must perform the maximum control of these efforts. And from our side, we will be cooperating. And this is only the second day of my office. And if you have questions, please call me.
Вот сейчас мы уже отрываем время
So
от
yeah,
нашего кофе-брейка.
taking some time from the coffee break, there are some general questions and private ones. If there are private questions, please ask them offline because the audience requires the generic question without going into details of specific questions. But there are questions anyways. Yes, again, so please introduce yourself. Yeah, hello, General Director of Kercher LLP. My name is Kirill Kuleshov for the territory of Kercher LLP. So I have the general question. Do marketplaces and the whole liability for the products placed by by the players? Okay, the next session will be specifically dedicated to that. Then no questions. Yes, yes, to specific reporters maybe, and maybe to the audience. Yeah, I have one question. Yes, yes, please. Just a very theoretical question about to a specific speaker. So, which one you choose? Yeah. Yeah, I know who the real expert is. Okay. Apologies. So I have a specific question, a theoretical one. Can a certain intellectual property object be considered that pertains to a certain person or a certain individual as counterfeited product without the decision of the court or antitrust body or any other authority? So I think this is the question to Zanat, but in any case, any product is considered as legal until the decision of the court proves backwards. So initially, it's proven otherwise. So the counterfeited product is other products whose factory has illegally placed a trademark, legal or illegal. If it is legal or illegal, this is a matter of the product owner to be considered. So, can any product be considered counterfeited without ruling of the court? No, there must be the court ruling, but the law suggests that the counterfeited product when the labeling was placed on the product contrary to the will of the producer and manufacturer of this product with if the labeling is placed illegally, it is considered as a product. If the product is was legally manufactured and sold by the manufacturer itself, the owner of the trademark, or on his consent and permission, this product may not be counterfeited, cannot be considered as a fake product alternative to the Russian Economic Union. It can circulate freely, and the owner of the trademark may not have further rights to disseminate or to transship it through borders within the Russian Economic Union. Yeah, if the first import or first production of this product on territory of the Russian Economic Union took place in the counter of the will and wish of the trademark owner, the first distribution of this product is illegal. Thank you very much for this opportunity to ask question. I have a question to Renat Kapushev. Well, you demonstrated the case and the practice when you hold a specific sellers liable for selling fake products. Okay, did you have any problems of dealing with the fake products? To what extent was it difficult for you to prove? Well, the key things when it comes to the proofs, I don't think there are certain issues to prove it because the legal practice have been well established and there is the understanding of courts in examining these matters. But nevertheless, there are certain cases I know that there's some of the similarities to the degree of confusion when it has to do with the fake products when the trademark is used. I think those things are taken into consideration. Well, we will have another two sections of Q&A. I know. Okay, let's take one question. One more question. Okay, one by one. Good afternoon, everyone. My name is Rustem Akhmeniyev. I'm the legal expert of Sarman. We are the producers of the mid-range devices, domestic one, national one. Over 2 years, we have been seeing the unlawfulness because the counterfeited products were imported. I have a question to Falcon and Pia for the revenue of to the authority of revenues, state revenues of the Republic of Kazakhstan. So we found people, the sellers on the markets of the Republic of Kazakhstan and the Department of Justice experts worked well, but there was no clear reaction from these bodies. The police was not on our side, but we catched red-handed the ones who sold, and we even catch those who sold to them, and we even had to catch caught those who were on the origin of this but the state authorities are not that eager to search for the guilties and hold those people liable. So the problem is that 2000 MCI is 8 million. 8 million is like one container of fully loaded products, but you know that you will never find so much products on the counter of the shops. So when I tell them like, okay, let's make raid because you have the leverage to do so, but now we are analyzing specific cases. It's better that we discuss it off, um, offline. But I want to ask why the Minister of Justice worked that bad, and this is a private question. Why the Department of Justice did something bad, you know, didn't work well. So it goes outside our round table discussions. Okay, dear colleagues, Tigran Aliasov BP company, I have the question to Bolotov partners and to Renat Kartashev with respect to the regulation of gray and parallel import. So you already mentioned that the illegal products are counterfeited products and the use of the trademarks illegally and in some other way. The great importation, the parallel import when the original product is imported unofficially by unofficial representative or right holder. For example, there is a company with certain representatives in Kazakhstan, and some people buy from other countries and import here to Kazakhstan. So how is it regulated? And to what extent is it a violation? For example, if the trademark is registered in the trade register, it is considered a violation. It is one of the use of the trademarks as the first import of the product to the territory of the Eurasian Economic Union. I think we will talk about it more in details later on. And just to answer your question, simply yes, this is a violation. Yes, you know, that's high time to go to the break time to take coffee faster. There will be queues. We have very little time left.
Уважаемые дамы и господа, я думаю, что меня слышно даже в самых укромных уголках вот этого нашего помещения. Я с удовольствием передаю микрофон и трибуну партнеру нашей фирмы Жанату Нурмагомедову. У Жаната основная работа – это не охрана, а защита прав, то есть восстановление нарушенных прав. И я прошу всех сейчас очень сразу всех сюда подойти, кофе надо с собой, бутерброды с собой. Если чего, я сбегаю, чего-нибудь докуплю, но Жанату надо передать микрофон прямо сейчас. Жанат, пожалуйста.
Коллеги, всем добрый день, прошу присаживаться.
Dear colleagues, please take your seat. Good afternoon, dear colleagues.
Итак, мы продолжаем наш сегодняшний круглый стол.
So we continue for today's roundtable. So we have a panel discussion related to the protection of net and marketplaces. That's not a secret for you to know that the counterfeited products are sold on the marketplaces and counterfeited products migrate along with the consumers. And some time ago, consumers sold products in the open markets and we observed this product there. And then they went to the trade malls and we saw many counterfeited products there. And today, especially the pandemics, online products, online purchases started very popular and they migrated with the consumers. We used to start working with we held different talks. Whose mic is on now? So we held a different event with such marketplaces like OLX and Satu, and then other marketplaces attended these discussions. It was pretty efficient and effective. And today the topic is still there. And for you, this is not in your team. Okay, let's give our floor to the speakers, and then we will have the open mic at the end of the session. So the first speaker is Mikhail Kviring, a Rodel and partner, Kazakhstan. So this company is very close to our heart in every sense, as they are on the 10th floor of the same tour where we are. I would like to pass the floor to him. He will be talking about the international practice, legal liability of marketplaces for placement and distribution of counterfeit goods. Please, Mikhail. Dear colleagues, I hope that all of you enjoyed this coffee break and you had enough time to refresh. Zhanat, thank you very much for the outlining the topics, and I'd like to thank thank you for this cooperation. And I'd like to start with a small question to the audience who is there. Could you please raise your hands who use marketplace on a day-to-day basis? Raise your hands, the ones who use marketplaces in your day-to-day life. The majority of you. Okay, raise your hands, the ones who represent interests of marketplaces. I know that there are two persons, two, three. I haven't seen the third one. Yeah, I haven't seen the third one. Well, okay, I just wanted to share you with some superficial things about the opinion of the German Supreme Court related to the online platforms, the marketplaces. I won't tell you something incredibly new about the decision of the European Supreme Court with respect to Amazon and other marketplaces. And now I would like to highlight some of the peculiarities of the European directives of the example of German right. Here you can see a small agenda with respect to the principles related to the decision of 2001 and 2002. These rulings are used by the lower instance courts in the case of some controversial disputes. So just could you please go further in two slides more before this Supreme Court ruling? There is a case when the manufacturer of very expensive electronics counted that the presence of counterfeited products that online platform like eBay is liable for the placement of the products on their online platform, on their marketplace. So when we check the content of this violation, it was found, it was obvious that it was counterfeited products, and not to mention the rights of the trademarks of the products who were imported from other countries. We can use this case in this the similar way. So what it means by essence, if we talk about that in generic terms, the online platforms, the marketplaces are not liable, and even they don't have to check if there was a violation or not. However, the Supreme Court of Germany adopted two norms. The first norm says if the intellectual property rights are violated, by a certain way, the right holder has rights to make online platform rectify or terminate this violation. So this was the first conclusion about it. If we talk about the reimbursement of damages, so the norms of the rights are used that there is a certain if there is a certain case, so this damage must be compensated. As a matter of fact, the compensation of damages in this two rulings of 2001 and 2004 was not there because it provides for a strict liability. But in case of the elimination or suspension of the violation, the decisions were pretty clear. Okay, next slide, please. Okay, the Supreme Court of Germany sets certain framework to the benefit of the online platform, and the key issue is that the online platform must take every possible measure to reimburse the costs of the business model. It considered an important criteria with in favor of the marketplace, but the decision is supported by the argument that every single case must provide for the fact that the online platform or the marketplace recovers a certain fee for the placement of the ad. And if I start getting the profit from it, my rights and responsibilities change. They change in a way to what extent the online platform, the marketplace, should check this violation for the presence of counterfeited products. Such liabilities occur in any case, at least when the online platform, the marketplace, becomes aware of it. There used to be 25 cases of Rolex because Rolex claimed time and again about the violations that the counterfeited products were sold there. But it's really important to mention in this discussion, and I hope that this discussion will take place after our session, after my talk, that the fact itself of placing the product with the name of a replica, mm, it was not enough for the product to relieve the liabilities from the marketplace, not to do the checks and inspections. So if you talk about the second criteria, the decisions or the rulings of the court, everything depends on the specific case which this model provides for a specific platform. It can be different in respect of eBay and can be different in respect of Amazon. So if we check the question like what is to be done if you talk about the fact that the liability occurs, there is a violation and the the liability must be there, what a specific marketplace should do. There is a ruling that the infringer must recourse to all technical measures first to eliminate the violation and to prevent it. Okay, next slide. So there are also other types of limitations that, according to directives of the European Commission, on with the fact if the marketplace is liable for the information that the third parties provide. In this case, this privilege is not used by Supreme Courts and must not use it because there is an acute, urgent liability given all the facts that have been taken. So despite all of this, if there is a no need to control it, and the answer is no, and when specific violation occurs, this responsibility goes to the online platform. Okay, next slide, please. So here, I would like to skip that with my colleagues and legal experts. These are the proactive and reactive measures. Proactive means that I have to delete this seller from the marketplace, and within the German legislation, there are certain liabilities provided, and if I know that certain rights are violated, then they must inform about it, because it leads partially criminal and civil liability. So the Kazakh legislation is very similar to German one. And if you talk about the monitoring, the question I would like to ask to the public, maybe I'm not so technically prepared, but given the fact how the artificial intelligence is developed 20 years after this development, to what extent is it technologically possible to automate these processes to detect the violation after the right holder declares the violation? I think this is the question to audience after the session. Well, I think that on that I would like to wrap up. And it was my short teaser report. If you have questions, I'm ready to answer them. And it's a great pleasure and great privilege that the representatives of our amazing are with us now. And we are always in favor of the open discussion, and I will be happy to discuss some matters both from the legal and technical perspective. Thank you.
Mikhail,
Mikhail, thank you very much for your talk. You know, the case is now Kazakhstan is trying to explore the choice of the most optimum way to protect intellectual property rights on the marketplaces. In the beginning of this year, the Minister of Justice, together with the National Institute of Intellectual Property, held a web seminar for the development of proposals to improve the legislation that governs the selling of the products with the intellectual property content on marketplaces. Different practices of the European Union were started. Representatives of the European Union were there, and they started different practices. And Mikhail is talking about such practices, continuation of such topic. For Kazakhstan, it's extremely important to check the experience and best practices of other countries to understand where the gaps were, and just to avoid the same mistakes. Mikhail, thank you very much for your report and for the experience shared. Well, if you have questions to Mikhail, we can spare a couple of minutes from our section, from the Q&A session, and pass them to every speaker. And yeah, just to speed up the following discussion, just like a call how to regulate all this better, because these norms, German media are referring to these norms exist for more than 130 years, and this is the matter of construing. I'm confident we have discussed that with other colleagues, that these tools can be used, it can be applied with the tools of right construing. And another issue is that just in order to simplify the lawmaking activity, I think this issues can be raised. We saw different companies like Henkel and other. We understand that in certain cases, these distributors have different cases because one counterfeited product leads to huge costs of the manufacturer. So I think that within the self-regulation, I think the companies that sell these products, I would like to call on the joint discussions and finding the common ground to get it right. Well, thank you very much, Mikhail. As a matter of fact, in June we had a breakfast dedicated to the spread of counterfeited products. And this is what Mikhail was talking about. And now let's continue the work of our roundtable. And the next speaker is Lyubov Antimova, Lyubov Anatolievna. She's the IP head of Nestle Russia. Her topic is marketplace counterfeiting. The Nestle's experience. He has the precious and enormous experience in regulating the marketplaces on the territory of the Russian Federation. That's why she was invited here to share her practices. Lyubov, please, the floor is yours. So thank you very much for that.
Friends, I hope my today's narration about practices of our company and the regulation of the companies, which starts to function in the Russian territory, and the experience will be useful to all the participants. Please scroll to the next slide. And I want to say before my presentation, Janat introduced me. I've been working in my favorable company in the head of intellectual property and actively use products in my life, and you use it in your life too. The peculiarity of Nestle company that we are multi-categorical company, and this is food. It's starting from food, confectionery things, and cat food, so forth and so on. Food is in the focus of counterfeit products, and there is a threat to our life and to our health, to our users, including our children, who are our target auditorium, and to our pets, because we produce a lot of food for animals. That is why let's go to other slides. The new reality is here. Nestle has a lot of experience of offline with counterfacts, with open markets and shops of traditional trade, and now we have transfer of this kind of trade to online territory. I have interesting introductory statistics. It's a e-com trade, internet penetration. It is a rather fresh and interesting slide about statistics. Let's talk about internet penetration and number of users in the territory of Kazakhstan and Russian. I will be fast. There is interesting statistics, and the Bureau of Republic of Kazakhstan on statistics says that share of electron trade in 13% in 2024, and 23 you see 12.7%, and we hope the growth will continue. The statistic is very interesting, and food products are in the first dozen, and the average check is about 15,000 tenge. It means it's available to all consumers. Next slide, please. One more interesting tendency is this: from a statistic information in 2023, two marketplaces, Wildberries and Ozon, became in top 10 of marketplaces in the world. In my point of view, it's very significant the focus on the control of right owner needed to be very high. Next slide, please. Press 1, 2, 3 times. Oh, good. These are basic trends, which indicates that we need to work with marketplaces. Online shopping is a habit. Marketplaces are leading, and they are in advance of or usual places because of quality, is the opportunity to work with the change of products, and they have a shelf and the category of e-commerce grows. Let's go. Let's monitor the time. Next slide, please. Basic risk factors, which are evident to everybody. And the first one, and we need to work with these factors and to seek opportunities to solve the problem. When a user purchases it, he doesn't have a data that would allow him to identify the goods and other components. If you are not an expert, you don't know whether it's original product or counterfeit. When it's evident counterfeit, you can orient, look at the quality of printing material and package, make a mature conclusion, so to say. You see standard pictures. Moreover, in Nestle practice, we have a library of images, cards, which are accessible to our sellers and partners. They open source data in internet, so our products could be seen vividly in spite of any goods which is on the shelf. It will have a single picture, and you have come to right conclusion when you pick up the products. Other points are evident. Let's save the time and let's move on. I want to pay your attention on this complex system of interaction between process participant. If in usual violation we have violators and law enforcement or agencies, we have sellers, marketplace, and all of this, and everybody attracts its attention to itself. Let's move on. One more challenge is slow pace of work of traditional legal offline instruments of influence. If you want to stop and infringements in the IP area, it would be very long, because card of a product is on a marketplace and a product is being sold, and the risk to a consumer is high. We need to stop it in more fast pace. Let's go to Nestle practice. It's information on suspicion products from our consumers. The main thing for right owner to get an actual data about counterfeit selling. So how can they know about it? First of all, the source is complaints to hotline of our service. Maybe it may be phone call or internet message. After that, a reacting system is activated. In 90% of cases, we come back to a user, so the person could provide this image of it, and in its turn, in his or her turn, he receives a quality product, and the most of users give us these products they didn't like. Maybe they have a subject opinion, but anyway, it's a counterfeit goods because it's poor quality. Consumer reviews on the marketplace and the product card is interesting area. we sell our goods to marketplace, which sells it on its platform, and we monitor these reviews of these all the time, and with the critical number prevails, we understand that something is wrong with this card, and our team from Nestle, and he makes order, checks it, make an expertise, and see what it's sold there. And I want to tell you about the following criteria. It's alarming bell. You understand that when it's a critical low price, people attention is attracted. Next slide, please. What can help us? Maybe we will talk a lot about it. I want to tell about good practice of one marketplace. It's a zone. It's opportunity to start an office of brands for a right owner. Have you heard about it? Some of you know about it. Brands office, it's a special place in the marketplace where you are authorized as a right owner. You don't need to prove who are you anymore. And this office provides a lot of opportunities. I won't read about it. One of the key opportunities when you file an application through the office of a brand, and the marketplace will react properly in time and fast, and there is a situation where there is no lying and there is no risk of seller blocking. It is a real right owner who trained in a proper way, and marketplace could react because he or she provided an information during the right time. And let's make a connection. What about self-regulation? I want to share a practice which is on the territory of the Russian Federation, where non-commercial association of fair legal experts made a decision of interlegal and compliance departments. This initiative was supported by Federal Anti-Monopoly Service. This Anti-Monopoly Service task is work with counterfeits and struggle with unfair competitiveness. And one of the precautions on the marketplace is the second issue, and this open format gave an opportunity to launch this project. The white book is the second document. It's a handbook where you can collect good practices about good examples and how to provide a document for the consideration. Right owners marketplace were gathered together. It was a task group. Next slide, please. Our key marketplaces connected to it during 6 months. We discussed actual relevant question, what can we improve and how to keep the balance interests of marketplace sellers. Next slide, please. I won't read everything what is on the screen. Let me note the basic advantage for a marketplace. When we implemented these practices and the activity of anti-monopoly service, it is the best advantage is a right connection to a right contact to a marketplace. Sellers can exchange experience and understand how to work in a legal functioning platform. Let's move on. What is in the practices where task groups stopped? What were acute issues? What is a collection of documents for the complaining to give complaint? How to collect best proofs and how to start an office and what is the reaction of marketplace to complaints. Let's move further. I don't want to go and delve into details about needful documents. What about the first documents? You can track a chain of products if they are not illegal and not fake products. There is a certificates and declarations which reflect a chain of resellings, and these are documents seller needs to provide when he or she opens his magazine, and the documents he needs to provide to check, and maybe he needs to provide them to a right owner in the case of suspicion of counterfeit goods. Or a procedure for filing a complaint. There are 4 options to apply to a marketplace. First of all, it is the longest and less effective way. For instance, you have an application and you can provide it to a marketplace. You can make a soft copy and hard copy, and there is a form on their site from right owners. It's a digital port on the Wildberries, and a special form and personal account, and between marketplace and right owner, it's a fast and effective. It's a personal account of Amazon, and there is a owner of a brand gives a form about complaint on Nescafe with a link on seller, and he applies documents to it. Let's move on. Correspondingly, this office does not delete necessity to provide officially typed application, and they say about confirmation of the presence of signs of counterfeit, and all needed analysis according to expertise demand, they will be provided. Simply saying you need to upload to it one PDF file in your private office, and marketplace analyzes it and makes a decision whether to apply to a seller and to clarify and to prove is it a counterfeit or it's not. As a rule, we attach to it photographic recording of results of test purchase, visually purchased, its packaging checked, which confirms that it was bought in this or that part, and the documents which prove that it's intellectual property of this or that owner. Let's move on. Concerning the expertise, there are 2 types of expertise and practice of our company. We use the expertise of our manufacturer. We purchased a good and look at the barcode, and we look at it. Yes, now we see the date of issue is not according to the documents, and marketplace get this expertise on the basis of this data. Let's move forward. There is an interesting practice, maybe it's not widespread, but when you involve law enforcement agencies, when they are motivated and when they have a desire to support right owner, it is possible. We have several cases like that. As a rule, it is a company like investigation company, an authorized representative of the copyright holder. When they find a place where a product was manufactured and they track the floods of it, they make an order, and notary specialist fixated in some cases, and then they let the enforcement agencies know about the making of the order in the context of the criminal case, and you can come and apologies with the representatives of this agency our representative comes to a place where the product are delivered, it's a proof. You cannot say, okay, it's not a proof.
This is when we talk about the transfer of this case from online into offline, not just blocking his banking card, but also in unveiling the full chain of the product delivery. And another case that we study in practice is when how marketplaces respond to the complaint. All the marketplaces that were the part of our task force signed of the practice, and all of them gave consent that first phase is to check the correctness of the complaint. If all documents are available, they check the signs of counterfeited products. If all the documents are attached and they write the request to the marketplace, to the sellers. And if the seller does not challenge or has no proofs to challenge it, the banking card is blocked. Then the term is the deadline is 30 calendar days, but now partners have 10 calendar days. But I'd like to share with you that Ozone user's personal account can block the banking cards in 2 days. So the example of the answer of Ozone, when such requests were submitted through personal account, the inspection was made. We would like to inform you that the seller cannot provide the documents and his banking card is closed. And another disclaimers represent that they are not guilty. And another answer of Albert is it's more concise that the legal expert Alexander Vasilyevich provided full counsel in response to your request to inform you the following, that the seller did not provide the answer and the card was blocked. What we discussed here was the blocking of cards. Blocking of the seller seems to be an extreme result, and you can discuss on that pretty much. Did he know that he sold the counterfeited products or not? Probably some other products are regional, and there are many other factors that is used as a proof not to block the seller itself. How you can block it? You can block it by the tax identification number or personal identification number if he was registered there. What we agreed upon in the framework of practices, we block the users against which there is a court ruling, and this is the right of the right holder to pass such disputes to marketplaces and block the user. So within the 60 days, if the same violations occur, then the seller is blocked. Yeah, and now I will proceed to the final remarks. Well, I think I'm in line with the schedule, and some interesting cases we work with in response to our complaint. I will start with the average one. So we use the term replica. There is also the wording like I'm the official representative of the brand, and you can see the link to the original products. And if it was not the right way of doing thing about the counterfeit products or original products, it seems like there are some scammer actions against the product holder, and we are guided by our legislation about advertisement, and the request can be submitted through the personal account. And another interesting case is, so there is a banking card on the marketplace where the original products is offered, but this card is for 2 SKU. So in this card, it is offered both espresso and aromatica. And in case if you buy espresso and Nescafe Intenso by Nestle, and if you buy aromatica, it is a nice coffee manufactured by Vidny, Moscow region. And another interesting thing is that in many cases, even if you order espresso, you will get a nice coffee, and there is a certain like certain shuffling of the cards. It looks like well product, but this is obvious violation, and we sent the claim both to the manufacturer, a seller, and the marketplace itself. So another interesting case is not like a case, but a trick of the seller is that when a certain set of documents that they sold counterfeit products was submitted to marketplace, and they put the status not available there on the marketplace, and the marketplace keeps this card saying that this product is not available, it's not sold, and we have no grounds to block it. And the reason why the seller of the counterfeited products is doing so because the cards of the products are very precious for them, because these cards got a rating. In order to get the first alliance of the product, if our colleagues know what SEO optimization means, in order to be in the top of this displays, you have to take certain actions, and in the bottom I have mentioned some of them. In order to get more reviews and more feedbacks, there are special groups that create the reviews, and people are paid to give comments on the products, and the rating of this card is growing. If such popular faked card disappears, it will be very difficult for the seller to rise from the bottom into the top with such rating. That's why they take all possible measures after being caught to preserve these cards. They can keep these cards for many months, and if they will feel like the attention from these cards disappear, they may sell the products again with the use of these cards. Okay, let's move on. Could you click it one more time? Yeah. So this is what I wanted to mention about the red flag system. Next slide. So what really matters for us is that the marketplaces should develop their certain red flags when in combination with the claims of the seller, for them to with the buyer to sell, to see that if they're selling such products. This can happen in case of the selling which can be shared by the product holder, the product with the same article number, and the cases when the seller does not cooperate neither with the buyer nor with the marketplace. And the last slide from my side is the success factor that can combat the developing of such counterfeit products on the marketplaces. The personal account is a good tool. You should also provide the full set of documents from the marketplace, the good set of documents for marketplace, not to be liable for inspecting something or for the products placed. So the red flag controlled by the right owners and the possibility to establish both online and offline communication. The struggle related to the closing of the ads will never help our purposes to detect the logistics waste, and we also have the technique when we don't close the cards of the sellers, because we use the certain actions just to bring this case from online into offline. Thank you very much. Thank you very much, Lyubov, Sandra, for your talk. Well, as I mentioned, yeah, do you want to ask questions now, or how we want to do that? So I think, as far as I know, you will also talk at the end of the Q&A section, but we decided to blur a little bit. So I would like to have the Q&A session in a professional way, just on the topics of the presentations, and I would like to shift this to the offline mode because you will have plenty of specialized questions or what. Yeah. If you like, you can ask this question yourself. Well, I have two questions. Slide 16. Slide 16. Yeah, it was an outstanding phrase. The parallel import is not affected. So even in Russia, people don't want to fight with parallel importation. It seems like there is a huge flaws of import from Kazakhstan. And another question in the system is the following. Well, I just want, I don't think it will take a lot of time, but these practices are not actually parallel import. The parallel importation is a painful question both for Russia and Kazakhstan and for us as the Swiss company right holder is pretty painful. This practice is aimed at revealing the products that may hamper the health of the health of the population. The parallel import normally these are the original products, but not always the counterfeited products. So this is the way they work with the counterfeited products. So one more question. Okay, colleagues, apologies, but please be concise. Please be quick because we are taking time from other speakers. You shared the effective Russian practice fighting with counterfeited products. There are frameworks, there are certain techniques, and which practice in terms of violating the rights of the right holders when the products are original, but they are used without the rights of the right holders for the use of the trademarks. Okay, this is the question about the parallel importation. Or what? No, I mean inside the country there are unauthorized sellers that have no rights to use these products. Yeah, if the product is officially or is legally in the circulation of the territory of the Eurasian Economic Union, it can be freely circulated by any people irrespectful if they are authorized or not. That's why the legislation defends such sellers. It is given in the Article 15 to the Eurasian Economic Union Treaty, and it is given in the 443 law of the Russian Federation. For example, the factory manufacturer Nescafe coffee and distributory bought it, and small individual enterprises are reselling it. Because this is the how the legislation works. Okay, and the last question. So I will be quick.
Скажите такой вопрос. Касается системы
So it has to do
сертификации,
with the
системы
methods
вопроса.
of identification
В
and
России
labeling. So
эта
in
система,
Russia,
она
this
очень широко
system is
используется,
widely
захватывает все новые и новые категории. Я
um,
попытался сейчас сверить ваш портфель
e-
с тем, что
eating out new categories, and I just wanted to verify the portfolio which is in the scope of the labeling. The water and drinks
сейчас
are overlapping with each other. So some projects are being developed for the aggressive sales of fake products, including the introduction of such mechanisms as forbidding counter, forbidding cash, that the right holders may suspend the circulation of these products with the use of the labeling system. Do you believe that there is a potential in developing such mechanisms driven by the experience of the Russian Federation? Well, I just want to tell you that even more, there is also the system of testing of fodder for animals, and some projects have been started from July and we are the part of this practical project. So just as an example, with regard to the food for animals, we can use this labeling, but our production lines will work slower. So any project has both pros and cons. From the production processes perspective, there are many disadvantages, but I have never worked with the fact that the labeling would give us a certain advantage. This is my personal opinion. Okay, let's take the last question on the last rows. Yes, apologies, but okay, let's be quick because we are short of time. Did we understand that correctly, that the blocking of cards will be possible if only the product is available? Is this the only way? Yes, the only way is blocking, and there are no other efficient ways of blocking. If the products are not available, this is the practice of our marketplaces. Now it is still there, but if it is available, they don't block it. But now we hold the negotiations with different channels, and we try to make their legal experts understand this practice of the products are not available and then return to them. But it is still a manual mode where we try to explain and give examples, and if it will be, if it is possible to make it effective, then fine. With any further ado, I would like to pass the mic to Rusakov Dmitry Alexeyevich, Brand Protection on Internet, Gorodisky and Partners, Kazakhstan. Hello, colleagues. Hello, everyone. I would like to apologize if my part of the presentation will have some common ideas with the previous speakers from the way how marketplaces work.
I'm not a legal expert, I'm a mathematician. Several years ago, we made a decision to automate and implement mathematical methods. And in our system, we saw IT development in the space for the 6 years. We make development of trial methods of blocking of the decisions for a ruling of courts. For right owners, it's a long-term process, and we work with violators in the law of law. What about statistics about electronic commerce in the Russian Federation? My colleagues were right. 2019 was a driver of on the market and was a COVID, and there was a global lockdown. Our right owners were necessary, obliged to integrate their methods online, and as users, we actively integrated our activity on internet, and dynamics of internet trade in Russian has been growing. In 2013, it exceeded 6 trillions of rubles, and in this year the tendency is positive. To next slide, please. In the context of this growth, we understood the main risk was on the sites where users sold legal and counterfeit products and so forth and so on. Since 2019, we see active development of marketplaces. From the point of view of a positive factor overlapped on the marketplace. At the same time, we see the marketplace's counterfeit growth is symmetrical to growth of sales of such kind of products. Many people wrote about it, published articles about it, and several years ago there were systems who automatized process of from legal foundations, and it grows actively. Next slide, please. Concerning software, specialized software for lawyers, bookkeeping expert has their special software. What about IP protection? We understood that we didn't know what to do in the beginning of our project, and our portfolio is 10,000 right owners, and the volume of people who we needed to search was so great, and the number of cards is more than several thousand numbers. Without specialized software, it's impossible. Next slide, please. Correspondingly, we developed our own software, and any right owner and company or a legal expert and sales department can use it. It's an integral platform which affords to monitor everything what is in a real-time mode, graphical pictures, and the system monitors all the internet on a daily basis. There is a difference between online and offline mode. There is no place for trans-border stories. For instance, any good can be delivered to Kazakhstan and to Russia. If we use mentioned a trademark or a paragraph or other items, all these things are in the context of automation process in the internet. Before we started marketplace, the basic problem in marketplace, this domain names, when next slide, when in the site you use brands, such kind of things. My presentation is about Dyson only. It's just coincidence. I don't think Dysons will be offended. It's not a violation, or it's a violation. We will reach this part. It's more interesting. Pre-trial blocking practice was used. We interacted with the hosting owners and information providers, and we started to work out practices which allow to block it on websites in a pre-trial part. Next slide, please. And there are several illustrations of use of trademarks and domain. Now there is an example of a trademark, pictures, boxes on the sites. We monitor and we see it too. Next slide, please. We've reached marketplace part. The basic advantage for us, for users, everything is being collected. Here we can buy food and other things in the framework of one marketplace. It's interesting and explainable. When we needed to trade legal or illegal products, we purchased site and we purchased hosting. We had competitors in the area of budgets with the big right owners, so our site will be on the top, so traffic from internet will be ours, and right owner had the advantage. Now marketplace, they are in this case, like they go to our biggest price. Can we block sellers which are not authorized? They decrease their margin percentage, and they provide their goods on the marketplace, and traffic goes not a official seller, but to a third or a second party. Next slide, please. I don't see an example how to block it. Fantastic. and the price is not so high. It's fantastic. The original price is much higher than $19. We automated this search process because manual search is very long. Then you need to work out and analyze prices. If it's a legal or authorized sellers, these issues are in this case. We have several thousand violations in our clients' cases. We have our automated process, and Wildberries automated this process. Wildberries provide 10 days for providing documents to a violator, then viable Wildberries does not block it if there are documents. If the violator cannot block the card, and this card is out of the search engine, it means that violator can stop spreading of a product, and he can block it when the product is on the way. It's a working mechanism. Next slide, please. Yandex Market. You can buy it for $19. And it's a minimal percent on counterfeit. It's a Yandex Market. Yandex Market says that they have 30 days for consideration it with a right owner, and there are several thousand violations, and there is a consideration in the trial, and this mechanism needed to be improved. We insist on improvement of pre-trial blocking of violations of cards. AliExpress is a vivid example. They have a transparent and understandable procedure. They block the cards and then they clarify their relationship with the right owner. In the Russian marketplace, it is not the same. Unfortunately, it's not the same. What about a zone? What about private account of a brand? First of all, a zone has 30 days for consideration of the complaint. A seller can sell out all the products and provide illegal documents. We see it here too. If in the 30 days a person can provide documents, and when they say, okay, it's not legal things, and then there are 2-3 days to solve the problem. Additionally, in August of Ozon brand became payable. Okay, if you want to defend your rights, you need to clarify your relationships with them. The following slide, please. Let's talk shortly about AliExpress. If people purchased it on AliExpress, now we see not so expensive goods. They purchase it of the wholesale, and they brought in Russia, and on local markets they are sold cheaper than on that. Next slide, please. I already told you that there is a migration of violators, migration from a site to marketplace. They migrate to social media or to Telegram. Next slide. We automated process of search of a violator. We work with marketplaces. We insist of the improvement of methods of pre-trial blocking. So we couldn't wait for 30 days in the case of trial and purchasing of goods, and brief case on Ozon. We have a client which makes a product and there was a conflict, and sales department asked to bring more products for more turnover. Let's struggle with counterfeit because counterfeit cards are 60 or 70%. Unfortunately, there is a 6 month. We cannot come to agreement. So the department who struggled with the account which cooperates with other. We need to have a legal volume of products be sold, and they solve the problem with the counterfeit products. Next slide, please. I have finished. Thank you. I'm sorry for the delay.
Спасибо большое, Дмитрий. Я считаю, что это
Thank you very much, Dmitry. I think that you have delivered us the striking examples that are there in different markets. Okay, let's not waste our time. The next speaker is Ilya Khodakov, Alrut law firm, Russia. The topic of his talk is search for effective tools of protection algorithms of efforts in anti-counterfeiting on internet. I'd like to thank Janat as well as Bolotov and Partners Company for this opportunity to talk. I'm happy to welcome all of you here. A few words about myself. I'm senior expert of the intellectual property rights of Alrut law firm. We are in Moscow, in Russia. We provide services only for Russian legislation, but we also work with different legal companies for individual property for all CIS countries, including Kazakhstan, Central Asia. And now I would like to talk more conceptual about different means in fighting and combating counterfeit products. With regard to online tools, what kind of tools we have and what are the tools there in addition to marketplaces, and what kind of legal services are provided. Yes, in terms of what right holders are doing. Yeah, now we can move to the next slide. Well, I started my journey with marketplaces and automatic monitoring. I won't delve into details how the personal account and digital arbitration of algorithms are working, but from my legal experts perspective, there are difficulties. The products are not always deleted, and what was there before the pandemic 5 years ago, the product is deleted within 30 days. It was a positive practice because normally the court will review it within 1 year and a half, but they have a chance to delete it earlier and even come to blocking of the seller, but sometimes it requires extra money, extra time, but it works nevertheless. In this case, both Ozone and Valbrus are good examples on how the anti-counterfeiting efforts will work. Lyubov has very detailedly and clearly explained of how it works in this environment. And I confirm that there are many providers that can provide such services, and they allow to work with the different marketplaces as well as the data intermediaries with social providers and other so that allow us on the online level to turn into the pre-judicial work and delete a huge scope of counterfeit products. And coming to the next slide, I just wanted to mention marketplaces and online monitoring. So the legislation of information intermediaries was discussed. It turned from the international law in the US. There are different intermediaries, online service providers that provide the platform and the technical capabilities to share information. So they have dual status. On the one hand, their responsibility, their liability is limited if they take certain measures, and on the other hand, we can speak about the fact that in marketplaces, posting providers, social media as the key media intermediaries, they have subsidiary extra responsibilities in terms of interacting with the right holder. If we take social media as an example, and if the social media does not take any measures, like I mentioned at marketplaces, if the marketplace answers within more than 30 calendar days, more than it is provided by the term. So this is a grounds to bringing marketplace to the liability and compensation from this marketplace for disseminating fake products. If we take Russian practice as an example, this is 100% story, and marketplaces are brought to the liability. They are held liable for that. And again, if the hosting providers and social media have been time and again reported on that, and this is a grounds for liability. So if we consider some non-scam platform like social media and marketplaces that are located in Russia, they take place actions and they delete. You can go to the hosting provider and get them blocked if the counterfeit products are disseminated. And now about the domain thing, when the product is used with the domain name. And now I think with the use of marketplaces, there are less infringements because the content so many producers of counterfeit products, they went to marketplaces, but with that, we see that there are systemic infringements related to domain. But what we need to take into consideration is that, so for example, if the story in Russia is considered on the level of the national legislation, and such disputes are reviewed in the court. So we need to demand the forbid of the use of the trademark and domain name and the term when the site disseminates the products, homogeneous products to products and services of the registered trademark. Here we get this real ruling, and we can go to the administrator of the domain name and register the domain name on the name of the right holder. So in some cases, it may not work. The foreign registrators, some other procedures. Sometimes it's not a domain rule, but some other, they have their own ways of registration. And in this case, we can demand of the passing the rights on registration. Another thing we need to note is that in some cases, the domain names are registered not for the purposes for the sale of fake products, but specifically for getting the rights of a right holder for sale, for getting huge profits, and the right holder goes to the rights of unfair competition. They take this journey and they say that if you consider it from the legal point of view, what is in the legal procedures, when we seem that there are some um, unfair work. So one of the example I just wanted to tell you about the legal term when they were the part of it, when there was a site Puma.ru, when the information on Pumas was there, but had nothing to do with it. But they created the website because they wanted to gain certain compensation from the right owner. On the one hand, there are no infringements, but there is an unfair practices for the violation of domains. I just want to tell you that the requirements are set closer to the domain name and administrator and the person who registered the domain name for him or himself or herself, and another initiative is pretty rare and very questionable with respect to the requirements of domain names to delete the domain names. So the practice showed that there should be the sufficient grounds so that the person who registered acts illegally. He acts with the person who registered it, and it's difficult to set the requirements. When the information on the person was entered and they are not true, and we not just we just report the responsibility to the administrator of the site to being held liable. So another thing I'd like to talk about the administrative cases, administrative lawsuits, and then we will finish. So the administrative thing, Lyubov said that yes, you can try to raise administrative cases for dissemination of the counterfeit products on marketplace, on the websites, but the practice is not like negative, but if it is purely online dissemination, you cannot efficiently put the responsibility on someone else. You have to get the proofs, the notary protocols, and went to police. And only in this case, there will be the so, and then any administrative or other liability will not work well with regard to the changes. And Russian jurisdiction should be the option because the competence of police in fighting with fake products will be seized, which means that the administrative cases for counterfeit products on the internet of online points will not be efficient. So I think that's it from my side. Maybe if you have other questions, I would like to discuss them on fake products and other matters. Thank you. Thank you very much, Ilya, for your interesting experience that you shared with us and that you plan to pass the authorities with regard to the violations online. Thank you very much for your talk. I think it will be a fruitful thought for all of us. And now I'd like to hand it over to our next speaker. So fortunately, we have a small rotation of speakers. Aliyah was supposed to speak now with regard to marketplaces. But now the speaker from different session, Elena Bychkova, will speak the Association of Digital Kazakhstan. She will be talking us about the position of market places, the next three speakers that will speak. And now are the representatives of marketplaces, and one of them is Elena Bычkova. Thank you very much. Finally, the word of marketplaces is given that, well, people mentioned that marketplaces should be the regulators in respecting the rights of intellectual property. But me, as a person who has been working a lot in digital markets, I will try to expand the picture and show it to you in a different way. I'd like to introduce the association of which I'm the head of, the Association of the largest marketplaces. We have been attending different events since 2015, especially in lawmaking. We are representing different regulators of marketplaces. So I published the book, the lawmaking. So my intellectual property rights are digital markets and all the forums that regulate the digital regulations. I'm the part of, and now I'm developing the digital code. So I had two options what I want to talk about. There is a problem of factors where the fake products come from in Kazakhstan. So people talk about it a lot, and I will be talking about purely theoretical issues, and probably no one mentioned them before. So if there are questions, I will answer them. Well, the volume of fake products is similar and comparable in line with the sales of weapons, organs, etc. So the question is, to what extent here in Kazakhstan, given the fact that the volume trade is 12% from the total volume, to what extent we use the marketplace tools to address this issue. So the most importantly is that we need to understand what task we solve. If we solve the issue with counterfeited products, a marketplace places its rules, but solving this issue only with marketplaces, we need to realize that we cannot do that alone. And this is very imperfect. It will not be possible with the involvement of state. The previous speaker mentioned about the documents of fair practices. We know this document. We discuss it with all members who approved that, including Ozon was the initiator of it, but this document does not work to the extent that we wanted it to work. There is another document, and I'd like to ask those who are engaged in the intellectual property on the internet to read it. It was also initiated by a Russian marketplace. It's called the turnover of fake products in marketplace. This is an analytical work where we discussed the risks where the markets will go if the consulting some regulators what it will lead to. Some of the risks I will be talking about now. Why we don't see this, why we see this situation in a narrow way rather than only the protection of individual property rights. Why marketplaces should be only liable from this perspective. So the topic of our today's discussion is the practice of that on the internet. It is the biggest platform of sales in Instagram. Every seller who has every so it seems like sometimes marketplaces sell their counterfeited products. No, because Instagram is the place to sell fake products. Because Instagram is not a marketplace; it's a social media. That's why they're referring there. They reject the liability. So what I want to offer an add to the civil code is that the marketplaces must be liable for intellectual property rights. So this is the This is the key that sometimes it's not doable, sometimes it's not possible. We're talking about Instagram. So to what extent Kazakh regulators can ensure the meeting of this requirement by Instagram? There was a law of online platforms, and I criticized that it will not work because there are no measures that would bind the foreign marketplaces to do so. The next is why it's all about the soft trade. Where is the biggest place where the fake products are sold? In Baracholka, there is also a website, Baracholka KZ. They try to digitalize it, but I read many initiatives that the same products like in marketplace are sold. If you want to solve the counterfeited products issues or marketplace issues, this is then not the only place where these issues must be resolved. The next that is, can marketplaces be subject entities or that should bear the responsibility or not only the intellectual responsibility? I'm the developer of digital platform of digital code. What a marketplace is. Marketplace is a model of business. It's not the legal entity. So I'm not talking about us, right? We should not extrapolate all other approaches to our legislation. We have all our own legislation. Marketplaces are the objects of informatization. What marketplaces are? Marketplaces are digital platform. What about digital platform is the apparatus complex. When we talk about the responsibility of marketplaces, so let's have a clear understanding. Many legal experts, owners, operators, and proprietors. The marketplace is not only about selling products, but also selling services. But why the responsibility should be borne by marketplaces and not the seller? That's a simple question. As a matter of fact, there are many models of a marketplace. We mentioned that partially where marketplaces perform purely intermediary functions. One of our leading marketplaces is the intermediary platform where every seller has their own account where he uploads the products, and marketplaces they cannot upload anything themselves. And from the anti-monopoly perspective, if we don't talk about unfair competence, I don't agree with this is not the civil case. No, this is the civil relations. There is an ad to the court on the fair competition. They don't want as they're being responsible for unfair competition. This is purely the relationship between the competition. In this case, a marketplace is not a competing seller. They have different legal relationship between and places where marketplaces act as the seller. There are also the places where products are delivered from warehouse. There are also other models before entering into the agreement with the buyer, the products are transferred, but the marketplace must be held liable for the respect of the property rights. In a few words about unfair competition, we understand that marketplaces created the market, the market where there is an opportunity to compete among equal sellers. But this market is subject to the same rules on the competition, and the regulator is there. The regulator is the anti-monopoly, antitrust body, antitrust authority. But unfortunately, we don't have the Ministry of Trade, who is the key regulator with respect to marketplaces. Lately, there are so many requirements imposed to marketplaces that we act as the state authorities. I represent the platform Kolesa, Grisha, and state public regulators tell us that we need to keep a roster of agencies. We need to issue licenses to brokers, but state authorities must be there because they have certain competencies and certain authorities to perform these efforts. When we talk about the regulation of the liability, we should not only use the foreign practices, but we need to understand the state of the development of our legal culture. Okay, what the Ministry of Trade expects from us. Elena, apologies, I will have to push you just 2 minutes. So the officials expect us the following way, the following thing: the marketplaces are the key drivers of the trade, and we realize just a simple example. If we implement the liability of marketplaces for intellectual property rights, there will be three sellers of iPhones distributors. I'm sorry, where other sellers will go? We will create the war between sellers. There is a committee. We discuss all this, and there is a clear understanding of what is needed. But where all those people go, the ones who wanted to transfer it to cashless transfers and others. And now we have another job to do. But the Ministry of Justice probably doesn't think of it. Unfortunately, not all authorities are here. Either we use the marketplaces as a tool to protect intellectual property rights, or we use marketplaces for the development of e-commerce. These are pretty different objectives that must be solved very carefully. And when it comes to discussion of self-regulation, I can talk for an hour with these details that I provided. Maybe there are so many questions and many of them are not resolved. So we agree with the fact that marketplaces must be held liable, but the balance must be there. It must be agreed with the consideration of all the parties. That's why the entities of the market that represent marketplaces, we as the association, we will initiate this discussion in the coming future about this liability of this platform. This is not a matter of consulting. Consulting may raise this issue, but nevertheless, the representatives of this sector should address it. And in the coming future, I think in October, we will create such a platform. Thank you.
Спасибо большое, Елена.
Thank you very much, Elena. Now I'd like to hand it over to Elia Adiljanovna Zhusan Mart, Kazakhstan.
Выступлением на тему «Текущий вопрос с
Current
маркетплейсами».
marketplace issues, counterfeiting products, and scam. Aliyah, we are jumping a little bit in the Q&A session. If it's not a big deal for you, could you please be a little bit fast? I'm the representative of Jasan Mart, is a trading platform that runs on Jasan Banking app. As a matter of fact, I want to talk about the current legal aspects, legal expositions, what we face in every day's work.
Now we talked a lot about counterfeits and about manufacturers. Let me tell you this. Are we ready to adopt our mentality for things happening with counterfeits? What I'm talking about, I will clarify to you. We have a counterfeit word. It's pleasant for our hearing. We have other words for forgery, and our sellers have a replica word, looks and whip, and these are three short words which legalize the word counterfeit, and our society accepted it, and people are satisfied. They have counterfeit products, and there are pretensions on the level of manufacturers, and I mean basic old people. What is happening on the marketplace? As a rule, in the marketplace, we have no difficulties with work with fake products. If we talk about bags and other and clothing, what about technical equipment? And there is our pain point. What do we ready to do in order to struggle to with it. And is to be precise, we check certifies invoices, and it's for the moment when we express our hospitality to ourselves, then our practice stops. When we have a problem with a fake product, we ask for documents for it. We warn about the blocking, and I don't know other platforms. We block it for a half of a year. It's a pain point for sellers, but for me, it's a joy, and it's only way we struggle with it. Nothing hinders to our sellers to sell it until the next unpleasant situation. When we talk about a lawmaking activity, let's turn to uh, Article 203 about selling of goods without permission documents, and the article reacts to small providers, small entrepreneurs, but on the small level, it cannot be used. Let's take it, it's a failure, a law clarifying in legislation part, and sellers don't know about this article because it cannot be used for small enterprises, and our entrepreneur society is under the moratorium of the checks, and counterfeit has its best time now because of it. And our we know about the law which protects rights of users. What a person knows about laws which regulate trade activities. The basic demands about certified of coordination and about the consequences about counterfeits, they know about it. I'd like to tell about positive moments. It's about 2024. It's my private experience. For today, a number of requirers of copyright had been increased, and sales of a copyright decreases in 2023. Similar requirers came during 5-6 months. Now requirer comes in 1-2 months. Sellers started to get this position, to understand it, and then know about the potential threat that their account will be closed. They are ready to provide documents and have a dialogue. In the comparison of the previous year, we can say there were conflicts, and you receive a application, you see and read it, and your account is shut down. And we need to have this on a mental level, because we need to persuade people, but people cannot be persuaded. My favorite section is counterfeits and Scrum. And let me share with the results on the trade platforms. We see Scrum, and it's inevitable, and facts of Scrum are more sophisticated with the development of platforms. And now touring businessmen, tour operators, they sell you consultation services, and person who purchases this does not notice it, and we say to people, read the documents. The second of the scam is cash. There are a lot of people who exchange money, and our people who violate the law have more and more sophisticated plots, and we have similar trade platforms. They are in Kazakhstan. On the screen, you can see advertising of cash. You can exchange And administration of these sites didn't take any measure to stop this kind of promotion, and our informational and law enforcement agencies are silent, and they ignore this problem. And we faced one problem and we solved it. Last year, I said that I filed the applications in the context of Jusan Mart. For today, they are still investigating. For this 1.5 year, our files stopped 21 times, and they started to be considered by the court for 21 hours. And the Ministry of Internal Affairs, we met in General Procuracy and head of department started to consider it. It's a great victory for us. I want to share data with you. We get a specialist of safety. If a trade platform has is a secured, and we took and we received a specialist. He interrogates people, and enforcement people organize the function of follow-up. We found the first chain and the second chain, and we discovered some gangs, and some people are imprisoned. Other people are ready to reimburse the cost of a damage, so their punishment will be lessened. In IT area, criminal code is being used. Frankly speaking, I thought about new methods because our part is okay with the law enforcement organs, and they can work with these kind of crimes and solve the problems. On the beginning of it, they need to delve into a software project. I wanted to share it, and platforms are ready to start a dialogue. We are ready to share our practice and experience, and we to get a feedback from us purchasers, from the clients, because we face the following situation. A client purchases fake products, and they silence, and their silence just spoils everything because they are out of date. Aliyah, thank you for your just flamboyant presentation. I'm being a moderator, very pleased with it. I have no time.
Oh, we have another speaker, Sabajan Berkenbaev, the representative of LLC Kaspi Shop.
Сабыржан, я заранее предупреждаю, что мы уже зашли во
So I
время.
just want to tell you that we have already entered in the lunch break. You don't have that much time. And there are also some questions from online listeners, specifically to you. My name is Sabarjan. I'm in charge of the practice of for Kaspi in Kazakhstan. So we received the invitation to our to this event from Bolotov and Partners with regard to our trade companies that are presented here in order to bring our efforts into pool of Kaspi. So I just wanted to answer all those questions that Bolotov and Partners have. We respect you very much. What Kaspi KZ is, I think many people know what Kaspi is doing, especially when it comes to the e-commerce companies. These are marketplaces. We have a slightly different model rather than a zone of libraries, and this is not like an Amazon D in Germany that occupies 60% of the e-commerce market. in Germany. That's why this German and Russian experience are so-called irrelevant. So my offer is the following. So why our model of the shop is this way? We have cards. So the cards are from not the seller. Some companies like Spare Market and other companies started to build the cart of the products, but not the cart of the people. You can buy the same product from 1,000 products, and all sellers will have different prices, and how to compare guarantees, etc. It was not clear. When the market was launched in 2016, the model was based on the cart of the product. So this is just to anticipate especially when it comes to counterfeited products. The counterfeited things are a huge problem. We, as the Kaspi shop and Kaspi as the bank, we are guided by the interests of our clients. If the client buys something what he didn't expect, there will be serious consequences for the sellers. So this is what has directly to do with the products. For example, if I want to buy iPhone, but I will get a piece of a brick, piece of something, yeah. So sometimes there are many sellers like this, and we got used to deal with this fraud. And we also work with related and associated parties that deliver products through different company name and through different illegal entity. And when it comes to food products and pharmaceuticals, so this is very crucial. That's why on certain phase we decided that it's better that we deal with it. The companies themselves, Magnum and other companies, are the part of these companies that deal with the food products. So they buy products only from certified dealers, the food stuff of high quality, and the minimum percentage of the issues can be the following. For example, they're extracted during transportation. Let me shorten the slide, and now let's talk about the indictment practice. Elena spoke a lot about it. I will not talk about it. When it comes to fake products, I mentioned that. And another important issue is how to deal with this. So according to Article 8, the fair and unfair competition, what unfair competition means. So there are also the sellers that sell these products, especially when we take certain measures that would go beyond the terms of the agreement, or would supersede or pertain to the public authorities' powers. Cannot afford that. So whatever we are doing within the requirements of anti-money laundering. What it means? It means that the seller should have the product, and he has the certificate of conformity for selling this product. And these documents are enough, because we don't check the whole chain. If the product is located in Kazakhstan and this product is supplied with all the documents, he has all the legal grounds to possess these documents, this product. And this is the matter of that go beyond the faded products. On that, this is where the control analysis of the intellectual property ends. But what I want to tell you about the problem of the application of law in Kazakhstan. And this is not a mere chance why I asked two questions to different speakers with regard to parallel import. They are more well known, but carefully ignored by our state authorities. It has to do with the Ministry of Justice, Ministry of Trade, etc., and also large businesses they incur huge cost. One of the largest companies in Kazakhstan that was selling the cosmetics. So the foreign companies, foreign marketplaces, they sell products themselves. They don't shy to enter the products from other companies. For example, Brazil or some other products. For example, they write the product name in Cyrillics, and this product is twice or thrice cheaper, and people buy it. It is the same product manufactured on the same plant. Yeah, we won't go into details of politics, but we know what it is related with. But this is one of the key issues because as a result, our sellers, our Kazakh businessmen suffer because only Kazakh businessmen may sell products on Kaspi. Foreigners cannot register on Kaspi market and sell products abroad. Nevertheless, there is also the problem of open borders, pure smuggling. We have the open borders with the Eurasian Economic Union. We also have the issues with custom clearance. We will have to deal with this. And furthermore, everything is sold there on the Baracholka, on the wholesale market, but is there below Tashkent and Street. Almaty residents know what we are talking about. So by doing so, we face the following thing, that the market has already been shaped, and the attempts to blame the government and public authorities with all of that. So we have even held a roundtable on this topic. So the Ministry of Justice even agreed to attend, but unfortunately we were not welcome. And so the attempts to put such blames on the government are very dangerous. One of our companies in the group is the bank. It must comply with the regulations of the country, but there is a clearly defined scenario. There are certain requirements for what and how should be done, and there is an entity of finance monitoring, and they have already mentioned these facts. The Department of Economic Intelligence of Kazakhstan that holds the work to the fight with these issues. And we, as the Committee of Finance Monitoring, we hope this. It may work with this way, but until the decent public policy for the protection of intellectual property rights is there, we will not be able to shift responsibility from one entity to the other. We also have the problems with scrammers, and not those which our colleagues mentioned, but the scrammers that register trademarks for themselves. We have 50 trademarks. He doesn't manufacture it, he doesn't deport them, but he want to create a nightmare for others. I believe that it's your partner or client. And we also have we even face this trolling, for example, the innovative pattern for SMS notifications. For example, he created the innovations. He claimed himself to be the first SMS inventor in Kazakhstan, and we had to have the legal hearings with him. And so the Ministry of Justice is not that fast in fighting with the registration of trademarks. Anyone could register a trademark that is not registered here. Even if you haven't registered a trademark, you can also register the domain name. For example, Kaspi Bonus KZ or Kazinvest or some other domain names appear. And we wrote some letters to those domain companies because it is in contrary to the signed convention and the agreement. So we must check, we must verify domain names. Some people in Europe do, even some people in Russia do that. So it is an issue of registration. So this way, everything is done with no help of others. So, for example, there's an idea of marketplace, some things work well. It's not, some insights appear for the supervision of bank transfer, but we are talking about the entrepreneurs. And another important thing is the issue how to forbid foreign marketplaces to enter. There is an international private law, and they know about it. And there is also the right of the seller. There is also the right of the seller, so where you can sell whatever you want. If you import something to Kazakhstan, then the Department of State Revenues will be in charge of it, because some things go to Kazakhstan. And the huge company is building a pipeline of products from China to Kazakhstan, and the products will appear here even faster. So what I want to tell you in the general, when it comes to this procedure, we are meeting the procedures of counterfeiting products pretty fast. So we are executing all these matters. When it comes to the issues of intellectual property rights protection, so if you talk about strictly in the legal from the legal perspective, if there is a court ruling, if there is a certain document from the law enforcement bodies, the legal act which will be enough for the protection of the competition to block such a seller on the platform. Why? Because there should be the control from the agency side. That's it from the well. And I already answered to some guys in the chat box. Thank you very much, Sabarjan, for coming to our conference. Furthermore, thank you very much for agreeing to speak here and for offering this opportunity to the audience to ask this question. I understand that this question sometimes tricky, but uniform people who are with you will have a chance to talk to you outside and somehow review this matter in a different way. But I'd like to add that to the online. There's a question. The situation with the marketplaces as follows: the right holder sends the claim to Kaspi and receives one or two answers. In case of there is a violation of the exclusive rights for trademarks, Kaspi does not review the claim of um, right holder and proposes to resolve this issue directly. Whose um, whose bank details are closed. There is only the name of individual property or LLP, which is not enough for the claim. And secondly, in case of violation of author's rights of Kaspi for author's rights, Kaspi closes the data of those who create the account of the product and use fully protected content, depriving the right holder to protect his rights. So the question is, does it mean that Kaspi created a perfect scheme for the violation of the intellectual property rights with no consequences? We as the company having a dominating market of e-commerce in Kazakhstan can demonstrate such poor civil position and the lack of the responsibility. Sabarshan, sorry, you mentioned our clients for the second time who allegedly act that may avoid this mentioning, and I don't know why we are doing so. Apologize. So he mentioned himself that he's your client. So the thing is, we received these letters that were sent to our partners, and this is the one reason for this. Okay, let's do it this way. We are the marketplace. Kaspi magazine is a marketplace. We don't sell the products. we must not control, and we are not able to control the execution of different laws by the buyers. Today is the tax regulation, tomorrow is the proprietary rights. So our concept is that everyone should protect his or her rights and his or her personal interest. We are not to blame. They need to engage in lawsuits with the sellers, with the one who sold the fake product. We are not selling products. In this regard, you should send the claims to a specific seller. Okay, let's split the matters that arise. So I think is it clear about it or some other comments? So there is always a strange situation when there is a feeling that marketplaces are always to blame. So why marketplaces are always to blame? So I would like to ask audience to take it with with respect marketplaces. It is their business. This is their business model. They provide the platform for selling products, and if we always put the question in the accusing mode, just to blame someone, that will be different. So the question might be raised to the following way, like, can we develop a certain tool together with you tool for counteracting something? Then it will be better. Okay, let's do it this way. So we will not supervise the fulfillment of the legislation. We are not entitled to do that. We need to put the responsibility of marketplaces maybe on some other sellers or the shops, but not on us. And another thing, what is in the official receipts? But Kaspi Pay provides the official receipts only for the clients who are registered themselves as the company, and they have a Kaspi Pay and they use services. So that's why the receipt contains all the requirements. So if it is all about them, then our official receipts are fully in line with the legislation. Otherwise, we were supposed to be blamed. And another question is what, that we are supposedly or allegedly violate something that is a requirement of the Republic of Kazakhstan of the entrepreneurial code and protection of personal data. And another important thing, we don't want the products to be sold directly. So in this case, any communication which you can have, there is always a mobile phone of every seller. So this is right example of Sulpaka. How many people of you learned that Sulpaka is a trademark of ONS? I mean, the ones who learned that. Well, what I mean that if we put that the salaries are in S, many people will have no idea about it. For example, the salary himself would ask to put the trademark instead of the name of the registration of the company. I think this question consisted of 3 points, and I answered, and I addressed all of them. Yeah, and the last question with regard to our civic position, we are doing everything in the interests of people. So we have taken a lot of time from our lunch break. So just a couple from the audience, dear participants of the roundtable. Aishan, thank you very much for this talk. Sabajan, I think this question goes to you. Not long ago, we faced some of the problems like fake products, and especially when it comes to the fake products in marketplace like Kaspi KZ. We went to Kaspi KZ, we received the rejection that this is a civil right of every seller to register there and sell the products. But however, there are still issues. So I have a wish. Can we add the button to the marketplace like verified dealer, verified seller? Yes, because we as RG, because we have many fake sellers that sell the products lower than the market, and this is what we faced, and now we want to have this thing to be resolved. Okay, we have mentioned that many times. Fake products are the counterfeited things. So for example, this is something what is we don't understand what is what by this logotype of LG, or this is a official LG product where our trademark is applied and it is sold cheaper than the market. It is this is not the home appliances of LG where the trademark is applied. Yeah. Okay, so this is a fake product with LG on top. So we have the registered facts, proven facts that this seller is doing that. So it is all supported by the legal acts. We went to the Ministry of Justice and the um, persons of the owners of these companies were not identified. So we are the uh, business entity which are sometimes to blame. If someone acts as a competitor to you, this is the law of the antitrust authority. For example, if you block the person, why did you block his person? But for counterfeiting product, but counterfeiting is the legal, it's a criminal liability. I think there should be a jurisdiction saying that this specific seller sold fake products. For example, you tell that someone was selling counterfeited products, but you tell like, do you have a proof of that? You say like, I have no proofs, but let's be guided by the proofs. We are all legal experts, but we need to understand what be the legal grounds if we claim that this person faked some product before. Just the case that someone just seemed to be that this is a fake product. Just to give us the legal document, legal certificate that it was the case. Okay, so what if it just seemed to you? It seemed to someone that no, it seemed there should not be like that. It should not be like seemed. Yes, but so give us the legal act at the end. So, colleagues, apologies. So someone who are trying to blame are not constructive. Maybe we will have a separate meeting or separate talks on this, but not in the blaming, not in the from the blaming perspective, but just like to solve it, but not to blame the others. Yeah, could you talk to the Barclays because foreigners are listening to us? Yeah, we have passed all this ourselves, but we haven't completed this journey. This is what will be the Department of Justice doing their job, and the administrative punishment is the other thing. So if a person comes and finds the container batch, they will not find it. Yeah, I'm just explaining you the way it works. So they are not to blame. They are no, they are out of this game. They have nothing to do with this. And if you find the businessman who registered there, you can bring him to the liability. And yeah, there is already a practice like this. There are court rulings we faced that. Some people say that you have no rights to sell it, and there is also the court rulings, and we have the legal acts, and we would like to express our wish from the manufacturers, from the sellers, like authorized seller. There is a global practice like the blue flag system. This is what it's all about. This is not the indictment, this is not the accusation, but it may solve many issues. So without limiting the number of players, the number of products, pricing, etc., the ones who need that. Okay, the question to the speaker. Okay, anti-monopoly body, anti-monopoly authority, antitrust authority tell us that you cannot say that these five sellers are the authorized sellers because you violate the competition environment. There can be 100, there can be 1,000 sellers who sell the same products, but there is a but the use of trademarks. So let me try to answer this question. So the same thing goes to iPhone or LG. You know, there is an idea of recommended retail price. So why iPhone in or LG vacuum cleaners? Why it costs cheaper than in Technodom or in Sopak? Do you know how it works? So there is an idea of recommended retail price, and the company sets this price for the official resellers, authorized resellers. I didn't have enough time to prepare this presentation in details. For example, why iPhone 15 or LG vacuum cleaner or for example, should cost 100,000 tenge, and the official resellers always had a price, for example, 99,990 tenge, and the trade networks cannot sell cheaper in retail, cheaper than this price, and this is only the requirement to a retail price, but not a wholesale price. So this official iPhone and LG domestic appliances, they are sold officially with VAT, with official documents, sold to wholesale buyers who sell those products as retail products for the price of 107,000 tenge. This is not the fake product. This is the official product bought from the official reseller, from the official representative, with all the follow-up documentation, and this is how it works. Okay, what the factor of official reseller gives us? Okay, you are the buyer, right? You are the buyer. Okay, most of us are buyers. Okay, so what does it really mean for you? That this is a original product. It can be any product, but yeah, it's original. That's not a counterfeit product. The guarantee. No, the guarantee for the product. No, they get guarantee. Okay, the ones who have apologies. We are far away from the Q&A session. We are going too much into debates. Thank you very much, Sanjar, for answering very pressing issues. And I hope that we will have a chance to establish a constructive dialogue with you of the relationship of the right holders, resellers, and the marketplaces. And thank you very much. I'd like to thank all the listeners for today's session. I'd like to express my gratitude, and now we will have lunch time. It will be short, 45 minutes. In 45 minutes, we will be seeing all of you here again, and we will have another interesting topics. The next panel session will be delivered by myself. I will speak personally. Thank you very much. Enjoy your meal.
Ivan, hello.
Hello, everyone.
We can hear you very well. So
You can hear me?
yes, the previous two sessions were quite hot.
Yes.
I believe now it will be a little bit smoother. But the word is to you. You are moderating.
Yes. Thank you. Thank you very much. Hello, everyone, and welcome to our third session of the day. All of you attending the event in person, I hope you had a good lunch break and that you are ready to continue with this INTA 2024 policy dialogue, anti-counterfeiting and unfair competition in Kazakhstan and Central Asian countries, organized by INTA and Bolotov and partners. I hope you are not sleepy after lunch and that you had your cup of coffee after the meal. Before we start with panel discussion, issues of protecting trademarks, I would use this opportunity to thank Bolotov and partners and their whole team for organizing this great event. The first part of the day went really well, I believe. I know Dmitry and Yuri Bolotov and also, of course, Zhanat Nurmagomedov. We collaborated on several cases in the past, and it was always a pleasure working with you guys. Let me introduce myself. I'm Ivan Matic, and I'm a senior associate at MSA IP, Milovic Ekolic and Associate Office in Belgrade, Serbia. Prior to joining MSA IP in June this year, I was working with another reputable IP regional firm for approximately 14 years, and before that, I was a customs inspector in the IP protection department of the Serbian customs for over 5 years. When it comes to INTA, I was a member of several INTA committees, for example, Government Official Training Committee. Then I was 4 years in the INTA Bulletins Committee, of which the last 2 years I was one of the 3 co-chairs of the Europe Subcommittee with 50 plus members. I was also a member of the INTA Europe Roundtable project team and the previous 2 years of the INTA Customs Global project team within the Anti-Counterfeiting Committee. This is my second consecutive term with the Anti-Counterfeiting Committee, Eastern Europe and Central Asia Subcommittee, and I'm the chair of this subcommittee for this 2-year term, 2024-2025. I'm happy to say that several members from our subcommittee is speaking at this event, like Zhanat, who will present during this panel session. I believe Anton Bankovsky spoke earlier today, and I think we will have Anastasia Kuznetsova, who will speak at the next session. So I thank them for their contribution, and in the end of this initial addressing to you, I hope the first day was really good, and now we can move on. I will provide you with some information first and updates on the Anti-Counterfeiting Committee. Let me just can you see this? Is this okay?
Yes, we can see you, Ivan.
Yeah. Okay, so this is, of course, just the first slide that we are here on September 24th. of this year. A few words about INTA, International Trade Association. It's a global association of brand owners and professionals dedicated to supporting trademarks and complementary intellectual property to foster consumer trust, economic growth, and innovation, and committed to building a better society through brands. Members include 6,400 organizations representing more than 36,000 individuals, trademark owners, professionals, and academics from 181 jurisdictions. INTA was founded in 1878 and is headquartered in New York City, United States, with offices in several cities around the world, like Beijing, Brussels, Santiago, Singapore, Washington, D.C., and of course, representatives in Amman, Amsterdam, Nairobi, and New Delhi. We have here some statistics in the previous from the previous years. You can see the sources like OECD, World Customs Organization, Michigan State University Center for Anti-Counterfeiting. Trade in counterfeited pirated goods on a global scale represents as much as 2.5% of world trade, or $464 billion US dollars. Over 60% of customs seizures of counterfeit and pirated goods involve small parcels, increasing pressure on customs authorities. That's according to World Customs Organization a couple of years ago. 52% of consumers in 17 countries have intentionally purchased counterfeits. In the year preceding this Michigan State University Center survey of last year. According to World Health Organization data, 1 in 10 drug packages in developing countries is counterfeit. In Kazakhstan, for example, the share of such counterfeit drugs exceeds 10 to 12%, posing, of course, a serious threat to the nation's health, first of all, and second of all, economy. When you speak about Kazakhstan, it's both a destination and a transit country for counterfeit goods originating in China and en route to Russia and the rest of Europe. During the period from 2022 to 2023, the good thing was that Kazakhstan succeeded in seizing over 2,000 kilos of different counterfeit products. Let me go to the next slide about our committee, INTA Anti-Counterfeiting Committee. Is dedicated to the enforcement of anti-counterfeit procedures worldwide. The committee's mission is to evaluate treaties, laws, regulations related to anti-counterfeiting and enforcement. Committee develops and advocates strong policies to protect against infringement, creates guidelines, resources, and research on counterfeit-related issues, and promotes counterfeit education and awareness with all relevant stakeholders. The ACC is divided regionally. We have 9 regional subcommittees. We also have 4 global project teams. As I said, in the previous 2-year term, I was a member of the Customs GPT, Customs Global Project team. We have 349 members, and can probably say that this is the largest INTA committee with 70 countries represented and 80 corporate members. You can see on this slide the Anti-Counterfeiting Committee leadership. Tara Steketty, anti-counterfeiting expert, is the committee chair for this 2-year term, and Christina Montanaro Schroeder is vice chair in this 2-year term. You can also see people from global project teams, leading those teams: Pamela Hernandez, Erika Joger, Eva Choa, Julien Dudois, Davide Bresner, David Lipkus, Marco Vazdar, and Pietro Gagliano. They are chairing or co-chairing the 4 global project teams within the Anti-Counterfeiting Committee for this 2-year term. Moving on, we have, as I said, the 9 regional subcommittees. Monique Cho is the chair of the US subcommittee. Zorita Pop is the chair of the Western Europe subcommittee. Lorca Toar is the chair of the EAP subcommittee. Then we have Anomi Vanagasekera on the South Asia subcommittee as the chair. Lynn Scanlon Hernandez, Latam subcommittee chair. We have Godfrey. We have Tamara Weingast, and we have Sophia Ho. So these are, including me, of course, these are the chairs of the 9 regional subcommittees within the Anti-Counterfeiting Committee. I would like to use this opportunity to thank our INTA-staff liaison, Alistair Grade, who is Director of External Relations and Anti-Counterfeiting. He covers Anti-Counterfeiting and Unreal Campaign. And we have Valentina Salmeiraghi, Senior Advisor, External Relations Anti-Counterfeiting. She covers Anti-Counterfeiting and Internal Amicus Asia Pacific Subcommittee. Thank you very much for everything you did for our committee in these previous 9 months, and we are happy to continue working with you and all, of course, the INTA staff until the end of our 2-year term. INTA staff liaison team, again, they work with certain subcommittees within the ACC. You can see Monica Su for China subcommittee, East Asia Pacific subcommittee, Tat Lembe. Hi Tat, he's working with our subcommittee. Eastern Europe, Central Asia. Then we have Carolina Belmar for Latin America and Caribbean subcommittee, Gauri Kumar for South Asia, Charles Shaban, Middle East and Africa, Hazel Lockhart, Middle East and Africa also, and we have Fernando Diaz for Western Europe subcommittee. They are always providing our regular monthly calls and leadership calls with updates of interesting and important meetings and events that happened in the previous period and are related to anti-counterfeiting issues all around the world. Just a second, yes. Priorities of Anti-Counterfeiting Committee in this 2-year term, 2024-2025. Online counterfeiting, organizing policy dialogues and stakeholders meetings with different platforms, government officials, different agencies, addressing the sale of counterfeits on the internet, and preparing inter-board resolution on protecting consumers from third-party sales of counterfeit goods via online marketplaces. Regarding cross-border enforcement, we are aiming to develop custom service to build a map on global counterfeit routes, to gather as much as possible border enforcement information from various jurisdictions, and to share best practices on border enforcement, so people can learn from similar experiences in different jurisdictions. In terms of capacity building, we aim to provide as much as possible customs trainings to develop forums to enhance sharing of best practices, as I said, and there is also the World Customs Organization Private Practice Consultative Group. Emerging trends and technologies. We should identify impacts of new technologies on anti-counterfeiting efforts worldwide. This is something that is going on in all the in every part of our societies wherever we live. So we have to identify that impact. Of course, to develop and publish up-to-date resources for INTA members and external stakeholders, so they have something handy when they are trying to protect their brands and to protect the markets and to fight counterfeits generally. One of the 9 regional subcommittees within the ACC is our Eastern Europe and Central Asia subcommittee. As I said earlier, one of the priorities is holding policy dialogues with key stakeholders on anti-counterfeiting priorities. This is one of the 8 objectives that we have set out in the beginning of our 2-year term. This policy dialogue that is being organized by INTA and Bolotov and Partners is exactly that. So it falls under the objective 1 of our subcommittee. Then we have objective 2 to monitor transshipment hubs associated with counterfeit goods and engage with border enforcement authorities. Objective 3 to identify relevant stakeholders, government officials, brand owners, consumers, and raise awareness on anti-counterfeiting through meeting engagements, trainings, and to support the WCO, the World Customs Organization training activities in the regions, if any, of course, or deliver training to national customs offices in the region. Objective number 4, to discuss strategies based on voluntary practices for combating online counterfeiting with the cooperation of international and local online market platforms in the region, identifying various stakeholders like online marketplaces, social media sites, influencers, registrars, logistic companies, and have at least, if possible, of course, 1 meeting per year to address online counterfeiting. Objective number 5, to develop a report for analyzing local laws on border enforcement measures and ex officio actions in consultation with the Customs Global Project teams, one of these 4 GPTs that we have within the Anti-Counterfeiting Committee in this 2-year term. Objective number 6 of our subcommittee is to expand the collection of data for the mapping routes of counterfeits project across the jurisdictions of the subcommittee. Objective 7, to evaluate treaties, laws, and regulations related to anti-counterfeiting and enforcement in our region, Eastern Europe and Central Asia, and to provide ad hoc inputs and comments to contribute to INTA's official legislation submissions. The last, objective 8, is to support, when possible, if possible, INTA real campaigns in our region. This is what is important for all of you who are members of INTA, International Trademark Association. Of course, these are some resources that are available. You can see on the slide. It's best practices for working with customs around the world. Interpol resolution establishing a framework for protecting consumers from third-party sales of counterfeit goods via online marketplaces, anti-counterfeiting issues and positions inventory. These are all resources that are made in 2022, so it's quite fresh, if I may say so. We have anti-counterfeiting benchmarking survey, white paper on metaverse and NFTs, also from 2023. And then just a bit older, best practices in addressing the sale of counterfeits online, board resolution on remarking as criminal counterfeiting, and again from 2021, board resolution on proceeds of counterfeiting. So these are all resources available to INTA INTA members. This is what is also interesting for our anti-counterfeiting committee, anti-counterfeiting toolbox, and trusted flaggers, union customs code revision, and engagement with OECD on free trade zones. Then understanding the barriers and opportunities for sustainable destruction of counterfeits, counterfeit and fraudulent advertising, which continues to be a persistent challenge for the right owners, for the brand owners, expanding individuals in the Unreal campaign, expanding to pharma, scams, careers, and trying to make these Unreal campaign events more applicable to particular markets. What is always important, especially me being a former customs inspector, law enforcement training, and capacity building and intermediary engagement. Focus on ACC capacity building initiatives is to advocate for stronger anti-counterfeiting enforcement and raise the profile of the need to combat counterfeiting through awareness raising and targeted engagement. Also to, as I said, provide, I'm repeating here myself, but this is really important, to provide customs and local enforcement agency trainings and workshops to help them in their everyday work on discovering fake products. To develop forums to enhance sharing of best practices in cooperation and with private and public sector, and INTA participation in the WCO private practice consultative group of the World Customs Organization. Main issues you can see on the slide: customs recorder procedures, ex officio actions versus voluntary seizures, small parcel procedure, mainly relevant in the EU, bond payment requirements, destruction of counterfeits. So these are all issues that are interesting throughout our region. And of course, in all the other regions, collaboration and coordination among customs officials for cross-border enforcement, collaboration between customs and brand owners. This is very important in terms of information sharing, product verification, and responsiveness on the other side, usage of customs portals, etc. Product verification trainings to facilitate transparent communication between brand owners and local contact points. In case of the seizure, local external counsels, authorized porters, and authorized distributors. Education and awareness raising to customs and local enforcement agencies of emerging economies and of less developed countries is really important, because in these jurisdictions, probably to the lower standard of living, it is a good environment for counterfeiters to produce and sell their products. In terms of public and private sector collaboration, it is important to participate to meetings with relevant stakeholders to identify and address respective challenges and limitations encountered. Efforts to continuously improve communications among all the stakeholders. So this is what is really important for everybody involved in fighting counterfeits to talk together, to exchange information, to share intelligence in order to fight fakes in the best possible way. If you have some questions, this is the email address of INTA. You can send it over there. Okay, thanks for this. These were some updates on the INTA as an organization and anti-counterfeiting committee, and of course our regional Eastern Europe and Central Asia subcommittee. Yes. Okay, I'll stop sharing the screen. I think this is all good now, and we can now move on with our panel. This is the third panel of the day. I hope that my presentation after the lunch didn't push you more to sleep. I hope that maybe it had the opposite effect, and I'm sure the other side that our speakers will give great presentations and that you will be very, very active. So, panel discussion issues of protecting trademarks. The plan was to have 6 speakers today. Jelena Bičkova, Digital Kazakhstan Association, Alessandro Bura from LGV Avvocati Italy, Jean Nurmagomedov Bolotov Partners Kazakhstan, Xavier Vermandele from WIPO Switzerland, Rumi Hashimoto, World Customs Organization Belgium, and Timur Berikmoinov, Union of Patent Attorneys Kazakhstan. However, Ms. Jelena Bičkova already spoke in one of the earlier sessions. So our 5 remaining speakers will have a bit more time, 15 minutes or so for their presentations. And after the presentations, we'll have a short Q&A session when you may pose questions if you will have some after you hear the presentations of our distinguished speakers. So according to the agenda, our first speaker was supposed to be Ms. Jelena Bičkova from Digital Kazakhstan Association, but as I said, she already gave her presentation. Our second speaker was supposed to be, according to the agenda that I believe you all have, was supposed to be Mr. Mark Chizenok. However, he will not attend. He informed the organization that he's unable to, unfortunately, to participate. And we have, instead of him, and we will hear from Mr. Alessandro Bura from LGV Avvocati, Italy. The title of his presentation is Anti-Counterfeiting Measures Focused on the Italian Territory, and the presentations will be about civil and criminal seizures during fairs and exhibitions, online ADR systems, customs blocks, EU regulations, and criminal procedures. Alessandro, you have the floor.
Hi everyone. Good morning. Thanks, Ivan, for the presentation, and thanks for INTA and Bolotov to inviting me today to provide you with a brief presentation on anti-counterfeiting measure during fairs. Try to share the screen so I have the presentation with me. Okay, great. I think it's working. Okay, great. Thanks to all. I'm Alessandro Bura. I'm a senior associate in, as you can see, LGV Avvocati, which is actually a boutique law firm specialized in IP in Italy. I'm a senior associate in this law firm, which is a boutique one. So we mainly deal with IP issues in the Italian and European territory. For today, I prepared a presentation in relation to anti-counterfeiting measures with the aim to focusing on the Italian territory in relation to specifically an issue which is actually trade fairs in the Italian territory, but however, this could also be included in all European countries. As you can see, as you can know, Europe is a well-harmonized territory in which we have almost all the protections in relation to IP rights and specifically with trademarks, as we have the enforcement directive in relation to protection and active measures in order to protect the trademarks and counterfeiting, and also a regulation in trademarks in protecting them and registration. Okay, So my first aim and my first focus for today's presentation is to spot on specific issues on trade fairs, in particular in trade fairs whereby the exhibition is not like an exhibition itself, for example, art exhibition, etc., but fairs whereby customers and companies usually get together in a specific area to exchange, for example, orders and, for example, market trends, and also products to exhibit beforehand in order to beforehand to enter into the market. This is a quite important specification because in trade fairs usually you think about fairs or exhibition instead, but here we are dealing with a specific fairs whereby the industry partners are meeting together in one premises in which they have offering of products or usually an advance of production of trends and competitors can examine recent market trends and opportunities. As we discussed, the fairs might be held in place and could be open to the public in which companies attending and exhibitors are exhibiting their products in order to have the customers providing orders or buy them, or in any case, see by customers itself, or the exhibition is just open to the company's operators and press. This is actually two type. I'm sorry, this is an error on slide, but it could be B2C or B2B in the sense that business to business or business to consumers. In this case, it's not open to the public, so that the market and the customer won't be allowed to attend, so they won't see the counterfeit products, if any. And on the other hand, there will be only providers by attending by market leaders and companies. Another important distinction between fairs could be also that the fair could be in person at the fair premises, meaning that the premises are open so that every visitors need to go physically there and then attend the premises, and also for online modalities. I mean, there will be during the COVID-19 pandemics, there will be some fairs that whereby especially in business to business fairs, they were together during an online exchange. There will be no physical presence in one premises, so that they will only exchange comments and maybe orders, pictures of counterfeiting products during via a platform. Usually platform provide the possibility to get one. This was usually made during the COVID pandemic, through which no one were allowed to travel and to access to the territory. Nowadays we have also some fairs in hybrid modality, meaning that they were in person and online, so that the catalog of the products is uploaded usually to the platform, and visitors can also access prior to the actual fair, the actual days of the fair, the opening, can also access to the catalog and request possible products or see some possible products. This is important also for the next consequences that we will see after that. So also the measure that we can also adopt in sense of IP right holders can also address in a different ways the possibility to combat counterfeiting products entering into the territory or just exhibited online. Okay, so as you can see, whether an IP right holders can see or is able to gather the evidence of a possible presence of the counterfeit products at the fair in Italy, and this is specifically for Italy, but also we have an urbanized law during in all the European territories, is to have a civil protection. mainly the civil protection. As you can see, you can request a search order or a seizure. We can see also it was not actually harmonized in all European countries, specifically with Italy, because so far before the civil reform of the Italian Industrial Property Code, there were just the possibility for IP holders to address the search order and not the seizure at the fair. But so far, after the reform, we have also the possibility to request the seizure as a civil remedy. Instead of civil protection or combined to the civil protection, we also have the criminal protection, because as you can also know, usually counterfeiting products entering into the territorial states is also a criminal offense under the Italian criminal code. And I think it's also some other countries. We know that not all countries requesting the countries protecting the counterfeit has a criminal offense, since we have some issues dealing with the China territory, through which some Chinese companies were introducing into the state of Italy counterfeit products, but the Ministry of Justice of the China Ministry requested say that there were no criminal offense under the criminal code of China, so that the request of a service provided by the Italian authorities were not granted. In any case, in Italy and Europe, almost is harmonized this kind of protection. So you have civil and also criminal protection for our trade fairs. As you can see, discussing first in relation to the civil protection, the main thing is important to understand is that usually in fairs usually last 3, 4, 5 days at least, especially in relation to, as you know, Italy is the main country in relation to clothing, to fashion, and also to sportswear and shoes. Usually fairs in this kind of particular trend market usually last 3, 4 days, in which the exhibitors are bringing into the territory state all the catalog and possible infringing products, and then they leave after these 2, 3 days. So it's important for IP holders to act quickly during the fairs in order to block and gather the evidence, or to seizure the products that could be possible counterfeiting of the trademarks or other designs IP. So we discuss the possibility for IP holders to act into the fairs while they were gathering the evidence was always limited to the search order. A search order means that you can request to the court, the particular court, the relevant court of the territory whereby the fair is held, to request an order to make a photography of the evidence of the counterfeiting products, and just it. After the reform, the possibility, as this is the reference of the law amending the Italian Industrial Property Code, introduced also the possibility to request a seizure. So you don't need to act criminally, but you also can request the civic court to seizure the actual products that are infringing your IP rights. This is actually an important reform. However, this may raise some kind of issues. For example, the first issue is relating to the modality through which the fair is held. As you can see, the seizure or the search order or the seizure can successfully provided only if we have an in-person fair, meaning that you had to enter into the premises and gather the evidence of the counterfeited products, and not on the online platform through which we have other possible modalities to fight against counterfeiting. As we said, the importance of the introduction of the seizure into the Italian civil law is to request an order through which the seizure and also the possibility to make all the evidence a photography of the state of the art in relation to the counterfeiting products. As you can see, the search order is typical in IP asset protection measure, which is not invasive in the sense that the bailiff through which the court operates is just requested to provide a photography of the counterfeited products and possible chain of counterfeiting, meaning that all the evidence that you can gather is also provided and also requested. Also, the seizure, on the other hand, is a judicial holder through which we can stop the circulation of a specific goods and making them unavailable to their possessor, to the counterfeiter, so that the plaintiff and the order can also request this kind of protection. The criticality of civil protection, as you understand, as you can see, is that the timing, maybe, because the obtaining and enforcement of the provision imply that you are requesting some measure to the court, to a relevant court, and the court shall issue order of description of the seizure during this kind of fair and to be adopted in the last days. So assuming that the fair is held into 2 or 3 days or 4 days at least, maybe you don't have the right timing to enforcement and to have the order already done to be suitable and conformity to carry it out during the fair, meaning that in 3 days it's very unlikely that a court can provide you with a granting of a seizure or even though a search order. In any case, this is something which need to be discussed. Is like this is a quick overview of the procedures. We need to file an order. We need to enter into the case registry made by the court. We need to assign the case of the judge, and then the judge examination will be granting. And then you have to contact the bailiff's office, and then you have to organize the civil seizure or the civil search order. All these kind of activities need to be done in 2-3 days, usually also during the weekend, in which courts are almost closed. So that means the civil order, maybe even though it's just entering into our code, maybe it's not more effective on that. The most effective orders and the most effective action to be carried out during fairs in presence is always the criminal path, in the sense that, as we discussed, the counterfeiting entering into the state, in the sense the counterfeited products entering into the states also represent a criminal offense, meaning that this is the articles of our internal criminal code, which requested that the counterfeited products is entering into the state and is just exhibited to the public. This might be allowed the IP right holders to act under the criminal path. The criminal path is more quicker than the civil one, in a sense that the complaint could be filed the same day of the starting or the beginning of the fair before the tax police. The tax police validation of the documents is requested, but then the execution could be of the order of the seizure can be done at the same day of the filing of the complaint. Then we have the seizure carried out with a report with a picture of the counterfeited goods and all the other evidence that the tax police can gather. Then it's transmitted the minutes of the operation to the public prosecutor office, and then shall be validated by the public prosecutor, and then a criminal proceedings will start. I'm trying to go quicker, Ivan, so I don't know whether we are running out of time. I'm trying to provide all the overview there.
Thanks, Alessandro. Yes, please, if you can within a minute or two, that'd be great.
Okay, that's fine. That's cool. Okay. I'm gonna skip something. Okay, so just the criminal offensive, we have alternative measures that could be, for example, on the online enforcement. We have also the possibility to send notice and take down to the fairs who would be handling the notices and then taking down all the products in the catalog. As you know, in Europe, there will be the Digital Service Act, which has been enforced, meaning that what is illegal offline shall be also illegal online. So these are being introducing new transparency, disclosure requirement, and accountability question. The duty is just to report to the fair that its illegal contents are uploaded on the platform, meaning that the IP owner shall provide the platform and the fair with the certification of registration and the evidence of the exhibiting on the platform of the counterfeited products. The platform and in this case the fair who is responsible for the platform shall provide immediate removal of illegal contents. These are the framework of the custom protection and in general for the European countries. Just to know, since the products are entering into the territory of the states of Italy and also are entering into European territory, the IP owner shall also provide with a custom block protection could be applicable in all European countries and especially also in Italy. The custom procedure is quite quick in the sense that customs, as soon as they understand there is a counterfeit product entering into the state, shall block the shipment and then shall discuss with the IP owners to the possibility which is counterfeit products or not. But even said before, unless you are a well-known trademark or you are a well-known company, the possibility that the customs need to be trained and need to be help in detecting the products is very crucial, in the sense that unless you are not very well known, your IP rights and especially trademarks or patents could be more difficult to detect and to block. This is the proceedings and that's it. Thanks, everyone.
Great. Thank you, Alessandro. This was really interesting, and thanks for.
Thank you, Alessandro.
Thanks for stepping in for this event. I'm sorry you didn't have more time to.
No, it's fine. I mean, the presentation you have, if anyone is interested, I can provide the presentation or whether question or answers, whether you need to.
Yeah, great. Thanks again.
Thanks so much.
Our next speaker is Mr. Zhanat Nurmagomedov from Bolotnov & Partners, Kazakhstan. His presentation has an interesting title, The Dark Side of the Moon, Tricks of Violators. Zhanat will be talking about the tricks and cheats that the infringers are using in order to overcome the law and various types of watches, customs, web, on ground, and how they are trying to quit from the liability. Nice to see you, Zhanat, and you have the floor.
Nice to see you as well, Ivan, and thank you for giving me a word. Уважаемые слушатели, участники круглого стола.
Dear participants and of a round table, dear listeners, I want to greet you one more time. My presentation will be not so complicated, so yeah, I want you to relax. It has a joyful story, funny story. Right owners often think that when they file an application and in police and in law enforcement part and custom clearance, and then this protection of intellectual property mechanism will function, and then all the violators will be in
ожидаемо,
trouble.
но, к сожалению, на
Unfortunately, in real
практике это так не
world,
работает.
it doesn't
Поэтому,
work like that.
э,
That is
нарушители
why
всячески пытаются уходить от
violators and
ответственности, принимают различные
try to
меры,
avoid
которые
criminal responsibility,
которые позволяют им
and they
уйти от
take
ответственности.
to
Вот, например,
avoid
Любовь Алимова в своем выступлении
responsibility.
говорила, что
Любовь Алимова told in
распространенным
her
таким
presentation
триком,
that widespread
распространенной уловкой на
tr-
маркетплейсах является
trick
указать,
or loophole
что товар не
is to
продается.
point
Вот
out
один,
that
одна из уловок.
the product
Я почему решил
hasn't been sold
рассказать
anymore.
про то, какие уловки принимают
Why I decided to
правонарушители,
tell you about these
чтобы вы, как
tricks,
правообладатели, как представители правообладателей,
violators. You
могли
are the
заблаговременно принимать те или
representatives
иные меры,
of
чтобы в максимальные случаи
copyright
такие уловки
owners, or as a copyright owner,
максимально расставить свои
you can
инструменты защиты,
prematurely,
выстроить их
I
таким
mean,
образом, чтобы
to build
минимизировать
your
количество
tools
уловок.
of
Вот
protection
на
to
следующий слайд.
minimize
И сегодня мы
number
поговорим
of
с вами
these
об уловках
tricks.
на
Let's talk about
таможне,
tricks
об
in the
уловках
custom
при административных и
clearance,
уголовных
on,
делах,
on
об
tricks
уловках,
during
которые применяют нарушители в
administrative
интернете,
and
и о
criminal
некоторых
cases and
особенных
internet cases.
иных уловках,
And let
которые на
us
сегодняшний день
me
являются
talk about
трендом, к сожалению,
of
в
some
Республике
tricks which
Казахстан,
are
и
unfortunately are
это является правдой.
tendency in the
Следующий слайд,
Republic of
пожалуйста.
Kazakhstan. It's true. Next slide, please.
Вот примерно так моя дочь Айлин
This is
свои
my
11
daughter
лет видит
Aileen. She's 11
тему
years
моей
old,
презентации
and
«Темная
she
сторона Луны»,
sees this
уловки
topic
правонарушителя.
of
Она нарисовала,
uh,
переработала
trick of
одно произведение
violators
какого-то
of the law.
известного
That's the dark
художника,
side of the moon.
профессионального.
She
Вот примерно так она видит
drew
эту всю картину.
this part
Итак,
of the
продолжим.
picture. She
Уловки на
changed it.
таможне. Что
Let
мы
us
видим чаще
continue.
всего,
Let's talk about this
каким
kind of
действиям прибегают
loopholes
правонарушители,
in
чтобы
the
избежать
custom
ответственности,
clearance
чтобы ввести
of
спокойный товар. Вот как
violators
раз здесь
in
был
order
вопрос
to
от
import
одного
their
представителя отечественных
counterfeit goods
товаропроизводителей,
safely.
почему товары до
We
сих
had
пор
a
поступают
question
в Казахстан.
from
Ну,
the
это
auditory
это
today.
челночные
Why
перевозки. Это
this
ввозы через
kind of
Кыргызстан и Россию.
goods
Сейчас
are
Кыргызстан и Россия
penetrate
сопоставлены
our
в одной
territory? It's cargo.
единой таможенной зоне.
Now our
Это и
countries
указание
and
товарного
Kyrgyzstan and
знака,
Kazakhstan are
произведенного
in the
где
one
или не в том,
trade
и тому
zone or
заведению.
changes
Сейчас
of
я все это буду
trademarks.
прояснять.
I will
Это и
clarify all
ввоз
of
через
this.
так называемых
It's import
полномоченных
through
экономических операторов.
economically
Давайте начнем с самого верха.
operators. Let us start
Ввозы карго.
from the top part.
Или, иначе говоря, сбор
Let's talk
Как
about
говорил здесь
collective
представитель
cargo
таможенного органа,
import. As a
только 2%
representative of
всех поступающих грузов в
custom
Казахстане
agency said that
подвергаются
only
физическому
2%
досмотру. То есть
of any
98% товаров, которые поступают в
cargo
Казахстан,
delivered in
они не
Kazakhstan,
досматриваются. И
they
особенно не досматриваются
undergo custom
сборные
clearance.
грузы. Потому что
There is no
представьте себе,
undergo
в
custom
одном
clearance
40-тонном
of,
траке
for
заводится вот
instance,
такое огромное
4
количество
tons
разных
track
элементных коробок,
and
в
different
которых присутствуют
size
самые разнообразные
boxes
товары. И контрафактный, он и
contain
оригинал.
different
Но досматривать
counterfeit
каждую
and
коробку, вскрывать,
genuine
делать ее
products,
опись
but
и направлять
prescribe it,
уведомления правообладателям, это
uncover all these boxes.
проблематично
It's
достаточно. Это
rather
необходимо иметь большой штат
problematic. You
людей,
need
это
a
необходимо
lot of
иметь
staff of personnel.
большое количество
You need to
сканеров и
have
так далее,
a
и так
lot of
далее. Потому что на
scanners, so
сканерах
forth
многие
and so
товары не
on.
показываются на
Scanner
самом деле,
cannot
не видно
identify
товарных знаков.
some
Следующий слайд, пожалуйста.
trademarks.
Челночные перевозки
Next
до сих
slide,
пор
please.
развиты, до сих пор
All the
популярны
time there
в
is a
наших краях.
popular
В
this
Центральной
kind
Азии
of
люди до сих
delivery
пор
cargo from
физически
one country to
ездят
other
в
country,
соседние страны,
formerly the
закупают
US
товары
countries,
и,
visit
будучи
other
физическими
country,
лицами, не
purchase
декларируя товары,
goods,
пересекают
they
границу
sign a
на поездах, на
declaration, they cross
автомобильном
the
транспорте и
borders
так далее.
on
Здесь
by
показан пример того, как
automobiles and
завозятся товары
by
с
trains. There is an illustration
международного
of a
центра
delivered
приграничного
from
сотрудничества
from
Харгос, НЦПС
Khargos
Харгос. То есть
International
вот люди покупают
Center
там
of
китайские товары,
by border
привозят на пункт
collaboration.
выдачи и спокойно забирают
They
свои
go
товары. Это до сих
there
пор у нас
and they
развито.
purchase it. It's
Следующий
still
слайд,
developed in
пожалуйста.
our country.
Еще
Next
один
slide,
трюк,
please.
самый
One more
популярный и
loophole
распространенный, это ввоз
is
товаров через Кыргызстан и
widespread,
Россию.
is deliver cargo
Дело в том, что
to
во всех
Kazakhstan,
странах
to
Евразийского
Russia,
экономического
in
союза
all
существуют так
countries of
называемые
Russian
таможенный реестр объектов
economical
интеллектуальной собственности. Как только туда
union.
внесли
There is
товарный знак,
s-
таможня получает
custom
возможность приостанавливать
register. When they
товары с
receive
этим
a
товарным знаком.
trademark,
Это вот
the
как бы идеальная картина мира.
custom agency has a
В
right
казахстанском
to stop this
таможенном реестре,
trademark.
например,
It's in
порядка 1000
ideal
товаров. Мы с вами
situation.
здесь вот
In
нам
Kazakhstan,
статистику давали.
custom
В
register They have more 1,000 trademarks. In Kyrgyzstan, custom register is more than 100 trademarks. It would be easier to delivery and to bring a cargo from through Kyrgyzstan, Russia, and to other countries, including Kazakhstan. Next slide, please. According to a rule of court, and without a plaintiff, defendant brought cargo to Kyrgyz Republic territory. They import products to Kyrgyzstan, then they spread it on the border territory. The next slide, please. It's secured on the Kazakhstan territory. A lot of people ask questions. I mean, people from auditory. It's often we see a protection of importing products, and it's highlighted that it's original product. Now the case in the courts and protection is possible. Nevertheless, it's one of the risks or loopholes to import products from Russia. The next slide, please. Change of trade mark in the changed shape. On the right, you see it's they notice they don't write Galaxy, they write down GAL semicolon, and they can and then they type other part of it. A representative for legit and law enforcement and through that's from 2017 we changed the way of this procedure. They scan all the declarations, they get as a corresponding information with the products, and then they analyze whether they have trademark on the declaration or they don't have. If Galaxy, the program will miss it that there's a spare semicolon in this case, and this spare symbol won't prevent a program to stop this cargo. On the right, you see a trademark as it's registered. After the registration of the product, a right owner put it in the custom register. What do you think about it? What it written for the software? And you know, it's a picture. Software sees it as a picture because a custom register received this information as a picture. We perceive this as a text, Alex Butler, and software engine search, it's a JPG picture. We needed to register trademark as two words and to put it as a inscription in the form of two words. Next slide, please. Economical operators, which has authority. Let me tell you about it. In the Kazakhstan and in the territory of Eurasian Economical Union, they have a term and authority, economical operators, this kind of operators that import products on a regular basis. They import it and they are trustworthy from the point of view of custom bodies. And the peculiarity is the following: they import product until their place of destination, and only then they provide a declaration. And cargo delivery and other transport companies use authoritative economic operators in order to deliver and import any kind of product on the territory of Kazakhstan. In most of the cases, it's China, and then they organize a custom clearance. Then they bring electronic devices, then the custom clearance, as for instance, potatoes. Then they declared their products after the delivery. They have no time to bring and to keep it on the temporary warehouses. It can be spoiled. They explain it and motivate like authoritative economical operators bring a lot of fake products. According to Kursiv KZ information, these kind of operators do the most of the harm to economy of Kazakhstan. They don't pay custom fees. Next slide, please. We observed custom clearance process. What about administrative or criminal cases rates? In administrative procedure, it's a case. In criminal procedure, it's operative measurements. The most thing loopholes, it's a refusal to provide receipts, or they close warehouses and they try to drive away products, or they gather a lot of people, and this crowd prevents to provide these police measurements. All administrative checks are carried out on the basis of legal and physical entities. If they have special documents, and these kind of documents are receipts, invoices, which prove that this or that entrepreneur or a physical entity sells counterfeit products. As a matter of the fact, this is a receipt by SAT Marketplace, or row 13 and booth number 6. What was the product and who was the seller? We don't understand it. We don't know it. There is just a signature of a physical entity. We need to point out, we need to type out this individual entrepreneur sells this kind of products. In practice, we get this kind of receipts, invoice is provided, and provider is Danela. There is no other information from governmental bodies, but she sold the products for 50,000 tenge, and the received deliveries from trade representatives. And Lipinski House 9, it's a address, it's a living, it's a private house. Where do we need to check? In the marketplace or in the private house? This is a loophole or a trick, and to just allows person who violates the law to sell or to sell products. And there is a warehouse packed with counterfeit products, and police was on the place, and they identified all infringers. And take a look at this, and security workers. You see, they film, they take part of the fence, take out, and through this hole they brought out counterfeit products, while police and I tried to be in the warehouse. Fortunately, the truck was captured by a lot of efforts. We uncovered this truck, and to see this one more slide, it's a banal physical resistance. They gather a lot of sellers, and booth is surrounded by people, and they prevent police to penetrate the booth. Sometimes we see serious conflicts. It's one of the active measurements of resistance from the assailants. The next kind of loopholes, it's internet tricks. I'm sorry, I'm out of time. Next slide, please. Basically and generally, in internet, while registration of domain names, the people type owners of domain names probably in Egypt. One more, skip this slide, one more slide. Last tendency in Kazakhstan is covering of domain owner. Next slide, please. One more slide. Uses images of the original products in order to sell counterfeit products. Pay attention to three pictures which are below. It is the same product, but allegedly different containers, and a violator of the law used different images from different products. Please scroll it down on the presentation number 33. Next one, next one, next one, next one. Let's go. There are other infringements. There are imitations of different trade marks. They use its similarity. For instance, there are toys, conditioners, air conditions, I'm sorry, kitchen utensils, dishes, establishing identity or similarity to the point of confusion, selling of products in the form of a local cargo manufacturers. In Kazakhstan, we see the tendency to have a exception in some cases for local manufacturers of goods. It's carried out in the closed mode. For native manufacturers have so-called industrial certificate, which is issued by National Chamber of Entrepreneurs at Amican. You see the tender. They provided the notebook. I've underlined the country of production, Kazakhstan, and manufacturer plant is limited liability company. So they provided in the close mode. It's provided, and no one of the right owners can take part in it. Next slide, please. Next slide. This is kind of take a look at this, which a local manufacturer produced. Nevertheless, local manufacturers of product, they cover their industrial certificates, and many of the state procurements, and they just make other manufacturers from the marketplace, and there is a loophole like this. Thank you. I will be glad to answer of any of your questions.
We're done.
Thank you, Janat. I'm sure this was a great and interesting presentation with overview of the situation in Kazakhstan, and I'm sure that there will be questions for you sessions from the attendees of the in-person event. Moving on, our third speaker of this panel is Mr. Xavier Fernandele from WIPO, World Intellectual Property Organization from Switzerland. Xavier is a senior legal counsel at the World Intellectual Property Organization, where he is primarily in charge of technical assistance to member states regarding the enforcement of intellectual property rights enforcement. Prior to joining WIPO in 2009, he was an attorney at law in Brussels, specializing in IP matters, and later served as a legal officer in the Europaid Cooperation Office of the European Commission. Xavier will briefly discuss WIPO's work and initiatives that contribute to fight against trademark counterfeiting, his topic being IP enforcement and building respect for IP. Xavier, welcome to this panel, and you have the floor.
Thank you very much, Ivan, and good afternoon to you all in Astana. To start with, I would like to express my gratitude to INTA and to Board of Partners for having me on this panel. So let me just share my screen. I have to ask the previous participant to stop sharing its screen, apparently.
I think it's the media tech support. Janet's presentation is not on the screen anymore, so...
Well, my presentation is off currently.
Yes, I know. So it's probably the...
As the mention, you cannot start screen share while the other participant is sharing, and I can still see the other template, the other slide.
Well, I believe that this is what I see at the moment. This is the official slide. It says anti-counterfeiting and unfair competition in Kazakhstan and countries of Central Asia.
Okay, can you just be sure then that I'm co-host or whatever, because it still doesn't work. I can't share. Otherwise, I will do without the slides, but that's unfortunate. Yeah. Now it should work. Yes, now it should work. Let me see. Okay, can you see my slides?
Yes.
Yes,
they're all good.
All right, just a second. Okay, can you see I'm not sure that you see. Can you see the whole slide or my slides with the notes?
It's the whole slide.
Okay, all right, good.
Without
thank you.
Notes,
okay, thank you very much. Thank you very much, and sorry for this technical hiccup. Those things happen. So I will be very brief, 15 minutes max, as agreed with the organizers, and I will briefly touch upon what WIPO, the World Intellectual Property Organization, that I don't have to present, I suppose, is doing specifically in the fight against, the infringements to IP rights, and in particular trademark counterfeiting. Just as a reminder, because we have had previous presentation on what is in the laws in Kazakhstan, in Italy, etc. Of course, as you know, the benchmark is the TRIPS agreement, the agreement on trade-related aspect of intellectual property rights, because so far it's the only multilateral treaty that contains a whole set of provisions on the enforcement of intellectual property rights. And so the TRIPS agreement, which has, of course, to be implemented in the national or regional laws of the members of the World Trade Organization, the TRIPS agreement offers basically a template with minimum standards in terms of the enforcement of IP rights, and that include, of course, as you can see on the slide, the civil procedures, criminal procedures, at least for trademark counterfeiting, border measures, provision measures, etc. So it's just a reminder. I don't have to spend too much time on the fact that when we discuss IP infringements, trademark counterfeiting is a big issue. Ivan previously showed the statistics provided by the OECD in terms of in terms of the size of trademark counterfeiting, and those estimates were based mainly on the seizures made at the customs. On the slide, you can see another statistics that is brought in by a study we did on the criminal side in 27 member states of WIPO, wherein it appears that on the criminal side again, the type of IP rights infringement that are the most persecuted are trademarks. So now, I think this is certainly something important, both for the public authorities and for private right holders to keep in mind. It is important to have a strategy to build respect for IP, building respect for IP. And actually, I am working in the Building Respect for IP division of WIPO. What does that mean? Well, it encompasses, of course, the enforcement, the pure enforcement aspects, because the enforcement are basically the way to act against the supply of IP infringing goods, and in particular, trademark counterfeit goods. Whenever that happens, well, the enforcement mechanisms will apply. But basically, it's even more important to have a strategy in place to build a sustainable environment of respect for IP. Enforcement is a part thereof to tackle the offer, but what about the initiatives aimed at reducing the supply? And that's what we can see throughout the world with the development of soft law, of voluntary agreements between right holders and intermediate service providers, for example. And besides, if we speak about the supply of IP infringing goods, such as trademark counterfeit goods, there's also a demand. And so it's also important to act on the demand, on the fact that customers are buying counterfeit goods. And that's all the role of the awareness raising side. So the awareness raising is very important. And for that reason, I'm particularly glad to see the initiative of INTA in the awareness raising side, such as shown earlier by Ivan. Now, within WIPO and within the Building Respect for IP division, this is on this slide, this is what we are doing. There are various aspects. First and foremost, there is a policy dialogue between the member states of WIPO, and that takes place within the Advisory Committee on Enforcement. Important, as its name indicates, it's an advisory committee, so it has no normative power. There are no new treaties on enforcement that are going to be drafted within the framework of WIPO. But this advisory committee on enforcement is the forum of the WIPO member states to discuss practices in terms of enforcement and in terms of strategies to build respect for IP. And I draw your attention on that because the work of the ACE, the Advisory Committee on Enforcement, is based on written contribution, usually around 30 contributions per year. And those contributions are, of course, freely available on our website. And that's important because we discuss, as I said, all issues pertaining to IP enforcement. I know that in another panel, you discussed about the disposal of IP infringing goods. Well, those were also a topic of discussion in the ACE, and you will find relevant material, documents on that site. I add very briefly that the ACE, that's for the member states, but of course, there are observers and INTA of the observer at the ACE, at the Advisory Committee on Enforcement. Next to that, of course, we provide technical assistance, and basically technical assistance, that means on the one hand, capacity building activities for requesting member states, capacity building activity on enforcement for law enforcement officials, members of the judiciary, etc. And for those capacity building activities, we usually partner and we ask the support of the private right holders as well. So from time to time, we have the cooperation of INTA, for example. That's important. We also provide legislative assistance to requesting member states to ensure that their laws or draft laws are in compliance with their international obligation, in particular, Part 3 of the TRIPS agreement. Of course, this legislative assistance is provided on a confidential basis, but this is a big part of our work. We, of course, international cooperation with other IGOs, international governmental organizations, and such as WCO. We have a representative of WCO today. That's important, as well as cooperation with NGOs, non-governmental organizations, association representing right holders, such as INTA. And for that matter, for instance, we have now on an annual basis a meeting with the private stakeholders associations, including INTA. The next one will be in a few weeks' time. So that is important for us to align the vision in the fight against counterfeiting. Awareness raising, of course, is also a key element. We are also active in that side. I will not develop that now for the sake of time. And then there are the strategic systems that we have developed or are or are going to launch very soon. So first and foremost, WIPO Alert. So WIPO Alert is a specific tool targeting copyright piracy. So you might wonder, why am I speaking about that, whereas we're supposed to speak about trademark counterfeiting? Yes, it's a tool to combat copyright piracy, but it has a direct interest for the trademark owners, you will see. Because what is WIPO Alert? It's basically a kind of initiative within the framework of what we call the follow the money approach, and basically it replicates at international level what exists in various countries already. It's a list of copyright infringing websites put at the disposal of WIPO, basically, first by public authorities of the participating member states. And for the moment, we have 15 member states participating, including Uzbekistan, for instance. And this list of IP infringing websites is then put at the disposal of authorized users being representatives of the advertising industry. And we have many users, including big players in the field of advertising, such as Omnicom, Group M, Publicis, etc. Now, and of course, what is the purpose? The purpose is to incite, to encourage the advertising industry to avoid placing ads for legitimate brands, basically. So that's where the interest of the trademark owners is, to avoid placing legitimate ads on copyright infringing websites, and therefore cutting the financial flow to the pirates. Now, it's important for you, for the private, for right holders, the trademark owners, because that avoids also, by avoiding the placing of legitimate ads on copyright infringing websites, it also avoids tarnishing the reputation of the brand owners who don't want, I suppose, to see their legitimate brands associated with pirates. So this is also important. This is something going on, and you will, of course, have access to this presentation, and you can get more information on the link which is provided there. And very briefly, in the last 4 minutes that I still have, I think, maximum, we are still working on two new concepts. The first one, WIPO Alert Pay. So it's basically a way for us to build on our experience with WIPO Alert. And once again, we are seeing the potential of cooperation mechanisms. And we are developing now WIPO Alert, which is a system that will aim at facilitate cooperation to combat the online sale of counterfeit goods, as well as subscription-based services of pirated content. And the online sale of counterfeit goods, those kind of transactional services, well, are not so much supported by advertising, but they do rely on online payment services. And WIPO Alert Pay would therefore enable the sharing of information between the right holders on one side, who are best placed to identify and flag the websites that trade in counterfeit goods, and the payment service providers on the other side, who can use information to assess whether to permit a merchant, a trader, to use their payment services. So this is something we are currently developing. At the moment, we are preparing to conduct a pilot phase together with a small number of right holders and payment service providers. And once the system will have been tested and waterproofed, then we hope to launch it for membership and for use very soon. So that's something for the next year, most probably. The second point, the second concept we are working on, that's the CRIS, the Customs Recordation Information System. So that's on the side of the customs and a tool to help the customs authorities around the globe, especially in the developing countries. We know the importance of customs recordation, of course, in allowing customs authorities to more effectively, to more efficiently identify, detain, seize counterfeit goods. The member states of WIPO currently have a range of different systems for customs recordation. And we are aiming actually to offer a software that can be easily implemented by countries to create a national customs recordation and information system that can better meet their enforcement needs. And our system, without getting into the detail, our system will be based on the currently existing WIPO's Industrial Property Administration System, the EPAS, which is already used by 90 member states of WIPO. And that basically, we will link this database with the new custom recordation system, and that will allow the participating customs authorities to access and to check the validity of the IP rights, etc., etc. So that's also something we are in the phase of developing. We are going also to launch a pilot very soon, and so this is also an initiative on which we will report later, but that I will certainly invite you to follow closely in the month ahead. I will stop here, Ivan. I hope I remained within my 15 minutes time. I know it's a lot of information that I provided, but of course, I am happy to answer any question you may have now, or of course, also in the future, you have my contact details here. And so feel free to contact me also in the future. Thank you very much.
Thank you.
Thank you.
Thank you.
Thank you very much, Xavier. Yes, you managed to get everything done. We are a bit. We should move faster. Sorry. Thanks again for taking the time to deliver the presentation on WIPO and fighting fakes at this policy dialogue. We move on. We will now hear from Ms. Rumi Hashimoto from World Customs Organization, Belgium. Ms. Hashimoto is a technical attaché in the IPR Health and Safety Program of the Compliance Subdirectorate at the World Customs Organization. The title of her presentation is Cross-Border Enforcement at the International Level, and she will speak about the role of WCO, World Customs Organization, in fighting counterfeits. Rumi, thanks for coming, and you have the floor.
Thank you, Ivan, for the introduction and for touching a lot of information on WCO during the presentation. And thank you for the INTA and Waldorf and partners for the invitation and giving me the floor to share our recent activity on cross-border enforcement at international level. I hope the screen is fine. You can see this. So if there's any issue, please let me know.
It's good.
Yep. So since the time is running short, so I'd like to quickly focus on briefly explain about our activity in the fight against counterfeiting and piracy. First, just let me quickly explain about the World Customs Organization. So now the World Customs Organization represents 186 members. And the mission of the World Customs Organization is to enhance the effectiveness and efficiency of the customs administrations. The World Customs Organization annually published the illicit trade report. In 2023 edition, 19.8 million pieces of IPR-related goods with more than 48,000 seizures.
Excuse me,
yeah.
We do not see a presentation right now. Could you relaunch it, please?
Sorry?
We see only you, but not the presentation.
Oh, I actually saw the presentation, but...
Should I?
Maybe try to relaunch, restart it.
How about this?
Yes,
Yeah.
now you can see, yeah.
Okay. So the trade report relies on the data from voluntary input from members administrations, and the medicine reports includes IP infringement, but not limited to IP infringement. And this is also the graph from the illicit trade report. Counterfeiting and piracy prevalent in every country, and with the fake goods proliferating across all industries. And all all means of transport are affected. According to the illicit trade report, in terms of number of IPR seizures, accessory, clothing, and footwear ranks in top 3, followed by the watches. Regarding the conveyance, mail and express courier accounted for more than 70% of all means of transport reported by the members. So this situation might highlight the challenge in e-commerce and small packages in the fight against IPR infringements. So in order to tackle this situation, while the Customs Organization has been conducting various activity under the name of IPR Health and Safety Program. The program has 5 pillars, and capturing the attention of customs officer is at the heart of the IPR Health and Safety Program. Since customs cover expansive area, not only the IP, but also the revenues, security, environment, and so on. So in order to raise awareness of customs officers, WCO provides its tool to customs officer. The contents include the theoretical contents as well as practical contents. And the importance of awareness raising were already touched by many speakers, so I would like to skip. But what I would like to say is that it is critical to reduce the demand for counterfeits. So most often the public is the victim of fake, cheap, and substandard products, so which they unwittingly use even at the cost of their lives. So it is important to sensitize the public to address the demand side of counterfeits. And combating counterfeiting and piracy cannot be achieved in isolation. So WCO, in close cooperation with international organizations, private sector right holders, and conduct various activities. This organization organized the counterfeiting and piracy meeting annually. And this year we will have next year we will have a conference next month, and where we discuss the way forward and the certain topic related to IP, or share the best practice, learn expertise from the participating members, right holders, private sectors, academias, and so on. And the capacity, providing appropriate training to customs officer is really critical. So we coordinate a national workshop based on the request from members. As you may aware that IP situation vary from one country to another. So we offer a tailored workshop for each members. During the capacity building, we encourage members to invite the national stakeholders, such as IP agencies, police, and prosecutors, and so on, to discuss the national strategy in the fight against counterfeiting and piracies. We also invite the right holders to support the capacity building during the national workshops. So we one day usually dedicate to the right holder session, where they share the expertise on how to distinguish genuine and fake, and so on. With the high volume of the international trade, risk management has become more and more important. So WCO provides the communication platform called the Sencon, which is a secured platform, and the customs officer can exchange information, report the seizure in a real-time manner. So the customs officer can utilize the information for their risk analysis and targeting. This platform also allows the access from the right holder in a trial basis so that they can deliver the intelligence to the customs officers. And enforcement is at the heart of customs. World Customs Organization, in close cooperation with the customs, organize an IP operation, changing the target scope, the regions, and the period. The stop operation was initially started in the fight against the COVID-19 pandemic. And in 2022, WCO completed the Stop 2 operation, which targeted the medicine, medical devices, vaccine related to COVID-19 pandemic, COVID-19. After the analysis of data, we realized that the challenge of the e-commerce and small packages. So in response to the Stop 2 outcome, WCO organized a Stop 3 operation with a special focus on e-commerce. And also WCO expanded the scope of the operation, not limited to medicine, medical devices, vaccine, but also the consumer products, in particular affecting citizen health and safety. Before the operation, we conducted online webinars, 2 days online webinars, and the second days were dedicated to the right holder session, where they share the best practice in the field of the e-commerce. With the support of the customs administration and international organization, as well as the private sectors, Stop 3 resulted in a total of more than 45 million pieces of seizures. We conducted analysis of the Stop 3 operation and reaffirmed further addressing the challenge of e-commerce in the fight against counterfeiting and piracies. So we conducted a symposium with the theme, Removing Counterfeit from E-commerce. And we are discussing to have another symposium with the focus of e-commerce. So lastly, before I'd like to touch a little bit about our activity in Kazakhstan. WCO conducted the IPR diagnosis mission for the Kazakhstan State Revenue Committee in 2022. Two WCO accredited experts visited the Kazakhstan, discussed the IP issue with the Kazakhstan customs, as well as the agency related to IP in Kazakhstan. And they submit the non-binding recommendation to the Kazakhstan State Revenue Committees. And in order to follow up these activities, we've been discussing to have a national workshop in Kazakhstan in near future. So when it realized, I appreciate if we could get the support from today's participants, so that in order to improve the IP situation and discuss together on the way forward in Kazakhstan IP situation. Thank you very much.
Thank you.
Thank you
so much. Thank you so much, Umi, for delivering this presentation. It was very interesting and informing the attendees about the role of WCO. I'm sure that it will be good to have the dialogue open about the situation in Kazakhstan with the help of today's attendees and organizations. Moving on, we do not have too much time. Our last speaker of this panel will be Mr. Timur Berokmoinov, Union of Patent Attorneys Kazakhstan. His presentation is practice of combating counterfeiting and parallel imports in the Republic of Kazakhstan, and he will discuss the barriers faced by trademark owners in the administrative procedures as well as in court proceedings. Timur will also give recommendations on how to successfully handle administrative and civil cases involving counterfeit goods. Thank you, Timur. Please, you have the word.
Ivan, thank you for the introduction. Good afternoon to all participants of the round table. Всем добрый день, всем слушателям данного круглого стола.
Dear friends, I want to say hello to you. INTA Association, thank you very much. And Bolotov and Partners, thanks to you too for the invitation. And I have an opportunity to share my experience in practice of combating counterfeiting and parallel imports in Kazakhstan. Now, counterfeit products spread is actual problem for right owners and for users, and share of these fake products is significant, and it grows every year. With the growth of counterfeit, there are a lot of cases where violators avoid liability by many ways. And there is a work of improving legislation, and at the same time there are different problems you can solve easily. In my presentation, I want to tell about practice of combating counterfeiting and parallel imports in Kazakhstan. In a law I faced it, and during these cases in the court. I'm sorry, I apologize if I read something now. So
Да, хотел бы отметить, что,
I'd
как
like
вам известно,
to highlight there are several kinds of violations of the law when the third party imports counterfeit products that is introduced on the screen. You can see it now. Is it a fake product or
либо это
it is establishing identity or similarity to the point of confusion, or its parallel import, which is prohibited in Kazakhstan. I mean, the third party imports original product with consent of right owner, with a counterfeiting of exclusive rights. We try to struggle with it online marketplaces in place of selling counterfeit products, and the given norm allows to avoid accountability of informative mediators who provide data on their accounts in the market. For instance, you can see well-known one of the Kaspi magazine, one of the sellers of products. Why do I highlight it? There is a trend, and a lot of right owners apply to prohibit counterfeit product selling. We applied for the prohibition in Kaspi shop, and we pointed out authoritative sellers which use our trade market legally, and the shop said that the Kaspi shop doesn't take part in information of these kind of sellers. They just helps to calculate, process the data, and they, if in our opinion we that some publications violated our law, then they recommend to apply directly to the sellers. Moreover, I want to highlight that we need to stimulate marketplaces to help to right owners. For instance, we need changes in the conditions of user agreement. For instance, seller need to type such different information about the person and about seller, because a lot of data you cannot understand. For instance, you come to a part where there is a description about a seller and there is only a name, magazine and mobile phone number. That's all we have. Moreover, there is an option to exclude, for instance, this kind of fact, providing of conclusion of establishing identity or similarity to the point of confusion, casting and block and not to choose and use a long procedure, and as a conclusion they would block a seller and so forth and so on. On problems of administrative procedure, many times Jana told about given problem, and I'd like to notice we had such problems or barriers called infringement liable. I mean, absence of counterfeit goods during a check of entity. And we applied to the department and they told us that our board billboard with an inscription and the good weren't detected during the raid. For instance, if we gather all the documents and we file the submit the application, but there is no goods on the spot. Secondly, it's an inconvenience of application with the goods, and authoritative agency told us that this individual entrepreneur does not work on this marketplace, and the given subject is not the same person and the object of the raid. And there are more cases. You have a check and you have identification number. All the data is identified by authoritative body checks, and this kind of individual entrepreneur works with the help of QR, and if there is agreement of rent or sub-rent, and it's written that the secondary party sells the goods, and the marketplace there is a third party, and if this authority organ cannot find the person, it closes the check process. An absence of authority from the agency after procedure documents of creating. We submitted an application when the good was stopped on the custom clearance. They wrote down special documents, and a person wasn't notified when protocol was written down, and they didn't explain his rights and obligations. In this case, the court seized administrative ruling because of non-compliance of the administrative code. One more detail is the main specialist who was part of making the protocol, and there was a private document because of negligence during the making the document. Moreover, there is some of pharmaceuticals, and these pharmaceuticals can be fake products. Among measurements provided by legislation, the owner can defend himself and
especially when there is no registration certificate or the term of the provision of the equipment expire. Here you can also file the application to the subordinate bodies under the Minister of Healthcare for this product to be seized or destroyed. We also have the legal procedures, legal practice, judicial practice for these cases. We don't have enough time, so I just want to highlight the essence of the judicial practice. So the judicial practice for administrative and civil cases is pretty much positive. The infringers must stop violating the law, stop importing the products, as well as they must delete these products from all other materials and within the administrative gates to bring the importer to criminal liability or to administrative liability to make him paying fines. I just want to highlight one case that was in the end of 2023, where the company was brought to the administrative liability. The company was fined, but the products were not seized. It's a decision of the special district economic court of Almaty. They gave the following thing: given the activity of the limited liability partnership, the product should not be seized because it complies with the use, the personal use, and that's why it must not be seized because it's the product for the personal use. Nevertheless, it was the rude violation of the rules of a good because according to the Article 158, it provides the fines and the seize of the product without no exception. There's no exception. It's also given a scientific and practical comment of the article. It says that the seize is the measure that must be applied in mandatory as a mandatory penalty along with the fine and cannot be applied without the discretion of the body imposing the penalty. After that, we work to the appealing court and for the appealing instance to initiate the proceedings which go through the court of first instance. This court all the materials suggested. So it was a court that are above them, but you're not the witness, you're not the prosecutor in the case, you're not the you are not the person or was damaged after that. But I have to note that this administrative note we sent the petition to attract us as the witnesses and also the claimant person who suffered. And we also had to send the claim on the name of the supervisory court, and then we sent the answer to the prosecution office. And we received the response from the prosecutor's general office, and it was said that because people that are given in the administrative code, you have the right to go to the special district court with administrative violations of October. We were referred to the appellation court of appellation court of Kyrgyzstan region. We sent the claim to the General Prosecutor's Office. General Prosecutor's Office agreed with our reasonings and issued the protest to of this personalized interdisciplinary administrative court, and this case was also reviewed of the prosecutor's office, and the case was issued, and additional administrative charges in the form of product seizing was decided, was ruled. So what are the recommendations, like the guidelines of the right owners, intellectual property owners who act with the infringers in the administrative procedures? First is the check of the terms of limitations days from the day of violation and respect of the rights. There are also the barriers when we implement, when we sell the product number one, but the person who declares as number two, and when we come to the inspection, there is the person number three. So we need to very carefully detect the infringer and very carefully check the information. We should also, provide all the data of the infringers when we want to go with legal proceedings to act engaged in the lawsuit, as well as the link documents should be provided, invoice, the bills, invoice, receipts, consignment notes, etc. Besides that, I also recommend to supervise the process both in the communication phase with the authorized body as well as the phase of the legal judicial proceedings. After passing the claim to the court, there is a human factor to track, because the authorized body may forget about case, and the courts may forget about it. You should be engaged in the court as the person who damaged, because the authorized bodies they not really have competence to consider a certain rule or a certain norm, and to communicate to the court that it fact of the infringement. And well, now I'd like to tell you that the question to amend the regulations is considered which provides for the imposition of criminal liability. That's like the introduction, but the return of this norm, because I remember until 2015, the Department of Justice had the right to act infringers for administrative uh, for administrative that is the right holders complained a lot that the mechanisms for criminal liability or work didn't work, and within others rights there are also fake products, counterfeited products. That's there is an extremely important way to protect your rights within the administrative case, because for the criminal cases there were eight cases, cases to the violation of the but there are some tricks, and but if these amendments will be enforced, it will have a positive impact on the practice of combating counterfeited products. That's it from my side.
Thank you very much, Timur. I'm glad that you managed to deliver the whole presentation, since we are a bit behind the schedule. This is our speaker list of this panel, and now we make a short Q&A session, even though we are a bit behind the schedule. But I'd like to ask you if you have some questions for our speakers.
Ivan, may I start with a short question?
Yes, please.
My question is to Mr. Alessandro Bura. Is he still here?
Yes.
Yeah, I'm here. Sorry,
Alessandro,
I'm just change,
yes,
change
I have
the
a
seat.
short question. You were telling about seizure order in terms of civil protection. you said that it is possible to get the seizure order within the civil protection procedure. And my question is, how long does it usually take to get such kind of an order?
Okay, thanks for your question. Usually, in civil proceedings, the issues of getting a protection in within a short time frame is very critical, in the sense that the IP owner shall gather the evidence of the exhibition or the presence of infringing counterfeited goods in a certain place, and then file a motivated order request application before the court. The court usually takes 1 week, usually, to examine the application together with all the evidences, and then they can issue the order. The order further on for the seizure shall be executed within 30 days after the issuance of the order. So usually the whole process might take 1 week and a half, 2 weeks, because also you have to organize the seizure with the bailiff, which is actually the competent person to carry out the raid after the issuance of the order. So
Alessandro, 2 weeks is
2
quite
weeks.
expensive. Thank you.
Yeah.
У нас есть также еще
We also have
from Telegram addressed to Тимур Берекмаинов. Вопрос к Тимуру Берекмаинову.
So the question to Timur Bekmainov, so the situation when the person is presented as one individual company, but not the company to which the shop belongs to, how we can get the information about the tenant of offline mode, offline shop, or on a pre-judicial phase. The company is registered to one person and the tenant is the other. I think in order to do that, we need to engage the extra investigations that will allow to search the true infringer. And furthermore, I would suggest here to within the civil proceedings, I know that the Department of Justice will say that the seller here is a different person. It's fine. The problem is not there, but within the civil liability of the infringer is. But what I would, if I have no grounds, I would file the lawsuit and will bring two people to the criminal court, to the criminal case. I will the court, two people, and let the court decide who's guilty.
We have no other questions from online or offline speakers.
Yes, I'm checking if anybody raised a hand here, but I think that's it. So with this, I think we can conclude this third panel session of today, issues of protecting trademarks. I would like to thank one more time to the organizers, Molotov and partners of this policy dialogue, speakers, and of course to attendees for taking time to be with us today. Thank you all, and I think that now coffee break should follow.
Thank you, Ivan. We are slightly out of our schedule, but I believe that 15 minutes for coffee break would not change anything majorly. Valentina, if you are here, please excuse us. We will take 10 or 15 minutes extra. I believe we may afford this from our Q&A session, which will follow your panel session as well. Thank you.
Thank you, Donat. See you everyone in 10-15 minutes. Thank you.
Bye, everyone.
Hello, everyone. I'm just doing audio check for the speakers. Can you hear me?
Yes. Hi, Valentina. Yes, I do hear you. Can you hear me? This is Anastasia.
Yes, I can hear you.
We can hear you.
Great.
I believe Mariam is the only one who cannot hear me. Yes, Mariam, we are speaking. Mariam, can you hear us? No? Okay. Let's use these few minutes to solve the technical issue. Okay. I think she's going to disconnect and reconnect again. Juliana and Anastasia, you can hear me? Okay. So
Yes,
everyone else, I'm
Valentina, we
sure.
can.
Thank you. And yes, we need to wait about 10 minutes before we start. And I am also looking for Dimitri Beresnev. Are you on the line?
Valentina, just one
Yes.
thing. And how long will be the session? Because I'm not pretty confident that I can stay for Q&A.
So the session altogether is 1 hour.
With the Q&A session.
Because I'm counting because we're starting a bit late. I think so. The 1 hour, the full 1 hour is just for the speeches, and the Q&A is extra,
Then I will
which
have
will be
to
15
jump.
minutes.
Yeah, I understand, but you know, I'm on the business trip now abroad, and I unfortunately won't be able to make it to the Q&A. Hopefully, no one will ask any questions. What we can do, for example, is that to me, the questions will be posed right after the presentation. If
Yes.
anyone will have any of those, because unfortunately I have limited time. So that
Yes,
would be
so
maybe
you
the
can
option.
also say that, and at the end of your presentation, and
Okay.
so that if there are questions for you, you can take a couple.
Yeah, yes. Thank you very much.
Now I can hear you, Valentina.
Okay, that's good. Okay. Three
It's
out
just
of
I need to
4.
stay, it's just that I need to stay on my laptop, you know, so it's more screen and less convenient than being in the big, on the big one. But when I, you know, try on the big one, I don't have the sound, so I don't have the choice.
Okay. I'm also trying to check if it's all the sound is clear because the translators will. So we have a translator translation at the same time. Therefore, if they cannot hear very much the audio or something, they will have troubles in translating into another Russian. So let's all check the audio for yourselves as well. Mariam, I was hearing a bit of echo for you.
Okay. What about now? Is it better?
I think it's a bit better. Yes.
Okay.
And Juliana?
Yes, hope you can hear me. All good, or is there an echo?
It seems clear for me.
Herb.
And Anastasia, before I could hear you clearly, so I'm assuming it's
Oh,
also.
great.
Mariam, I don't know if you had headphones and you prefer to use it or not. That might help, but I'm not sure.
Okay, I brought them. Maybe I can try something. Give me just a minute, please. I can try something.
And then I'm still looking for our speaker, Dimitri Beresnev, who is confirmed, but I cannot identify him. So if you are on the line, please let us know. Let me know.
Maybe he's just dialing in at 150 because maybe he thinks this is a speaking part. I'm not sure.
Yeah, that could be one possibility, or it could be in the room.
Or yeah,
That's a second possibility.
true that.
Yes, we can. Well, we confirmed the invitation, so eventually.
What about now, Valentina? Is it better?
I think it's better for me. Yes.
Okay, thank you. Okay.
Thank you.
Merci beaucoup.
So this is solved, and merci. And Anastasia, just to ask you, until what time you can be with us?
I think that I can be with you for around 40 minutes.
Okay, so you're the first speaker anyway.
Yeah. Great.
Sorry, I didn't mute myself before talking to you.
Okay. I guess we have to wait. Just wait. So I'll make a very brief introduction of each of you. So when you start your speech, you can also, share, of course, your, position and background, or, what your role is within the organization. Feel free to elaborate as you prefer. That will be, because we are tight on time, I'm making a very short presentation, but you can elaborate as much as you like on yourself before starting. Just remaining in the 15 minutes allocated, as we are taking some of those minutes from the Q&A anyway, but we like to have a Q&A as well. So let's use that time wisely as well.
And I hope that I have some sounds on the background. I hope that it won't interrupt me and everyone will hear me
Don't worry,
properly.
unless it's very, very heavy drilling or something, just ignore it. It's fine.
No, it's not heavy drilling, but I'm at the hotel and people sometimes walk around, especially now the receptionist lady is talking to someone in a very,
Yeah, we understand.
very loud.
And I see Dimitri, you're connected now. Can you hear me? Dimitri, can you hear me?
Hello, everyone. I take part in this event offline.
There is the
I hear a lot of echo, Dimitri. I cannot hear you. Everyone the same? Okay, yes. Can you help us solve the audio problem from your side?
No.
There's a lot of echo. I'm not sure if you're using some headphones. Maybe it will be better if you can use your headphones. We have few minutes. Okay, now I hear myself. So our panel is entirely online. So I suggest once each of us is speaking, we mute all of us to make sure that we minimize echo or problems. And that should solve the issue. And we speak one by one anyway, because it's a list of presentations. And then when we take questions, we'll try to make sure that we mute and unmute on time. I know that the room is really full. So unfortunately, our angle is that we see only the chair, one chair there. But I know for sure that, we're not speaking at a small group. I know the room is full. So that could be, I hope it's a more motivation and incentive for all of you. Dimitri, can you give us some information on your side? How is it going? I think he's disconnected now and try to reconnect. It worked for Mariam, so it can work.
Yeah, actually, I've only it only worked from when I connected for the second time. It didn't work from the first time. Okay, I guess that we're kicking off with my presentation. Hello, Zana.
Hi to all. People are gathering slowly. It's almost the end of the day here. Yes, I'll give a last call.
Yes, thank you.
Okay, Valentina, shall we kick off with my presentation?
Valentina, yes, we may proceed.
Yes, perfect. Okay, then good morning and good afternoon also to everyone, to all the participants for this policy dialogue. This is the last panel of the event of the day, we understand, but I promise it will be certainly a very interesting one, as we will have the opportunity to hear more on the brand owner's perspective. My name is Valentina Salmeraghi. I'm the Anti-Counterfeiting Senior Advisor at the International Trademark Association, or in short, INTA, and I am the moderator for this panel today. My role at INTA is to support the work and the initiatives of the Anti-Counterfeiting Committee, including events like the one today, and also to provide inputs and implement the INTA anti-counterfeiting strategy and identify priorities. I'm pleased to welcome you to today's panel discussion, where we will be diving into some of the most pressing issues surrounding brand protection and intellectual property enforcement across diverse industries. Each of our panelists today will bring a wealth of experience and expertise. I can hear a bit of my background. Can you mute, please? So I was saying each of our panelists today will bring a wealth of experience and expertise in tackling the challenges I mentioned, and I'm excited to introduce them to you. Just a kind reminder for each speaker is to use 15 minutes for your presentations, and then we will have a Q&A at the end of the discussion. To start setting the stage, I'll provide a brief description of all the speakers just to start. So first we have Anastasia Kunetsova from the Lego Group, who will be discussing the topic of destruction of counterfeit goods. Anastasia plays a critical role in protecting one of the world's most iconic brands, ensuring that counterfeit products are identified and destroyed to maintain the integrity, of course, of the products and the Lego name. Next, we will have Dmitry Bereznev from Syngenta, who will be addressing the topic of fighting illegal products in the agrochemical sector. And with his extensive background in combating counterfeit in agrochemical products, he's well positioned to shed light on these unique challenges for this industry, protecting the products, consumers, and the farmers worldwide. Our third panelist is Juliana Fuchs from Puma, who will be sharing insights on the challenges in enforcement of intellectual property rights. And with the global brand like Puma, Juliana is at the forefront of dealing with infringements and the complexity of IP rights that today fast-paced and interconnected market for the sector. And finally, we have Mariam Burhala Ludi from Servier, who will be discussing brand protection strategy as an expert in the pharmaceutical sector. Mariam will offer perspective on how the organization safeguards its brand in one of the most highly also regulated industry in the world. So I'm really thrilled to have such experienced panel today, and I look forward to these valuable insights that they will provide. So we will start the discussion with Anastasia Kunetsova from the Lego Group. Anastasia, the floor is yours.
Hello, everyone, and thank you, Inta, for providing this platform, allowing us to discuss the difficulties of the brand protection and the various issues that major brand owners come across in different jurisdictions. While we're now going to be speaking of Kazakhstan, I think the complexity of the issue is the same across the Central Asian countries. Дорогие друзья, теперь я позволю себе переключиться на
Now, ladies and gentlemen, let me switch into Russian. And unfortunately, I didn't have chance to travel to Kazakhstan. Apologies if there would be some side noises, because I'm broadcasting from the area where there are some noises, and there is a receptionist that makes noise in the hotel, but finally she left, and now I'd like to tell you a few words. I'm the legal expert of intellectual property rights. I'm residing in the Russian Federation, represent the legal group in the matters of counterfeit, fighting, and brand protection. I'm in charge of the region.
And there's a Russian-speaking regions. Company I've been working for 4 years, and within these 4 years, the Republic of Kazakhstan and neighboring Kyrgyzstan were very important for Lego company because Kazakhstan is a very high intensive growing market. Our sales are growing very rapidly in Kazakhstan, and correspondingly, the second reason for being in this region is for 10 years it's a development territories and development and situation of these territories near the China. It makes these territories, so to say, vulnerable to appearance of counterfeit products because of its territory and their location. And I wanted to talk about it today. Being right owners, we've managed to work with Kazakhstan, particularly at the most effective appearances when you put low, the less efforts and you gain the best results. We delete, terminate counterfeit products. At the same time, we faced other problem. Being a right owner, it's an issue of difficulty to what to do with these counterfeit products. Let me turn on my presentation. 1 second, please. I suppose I need to share my screen. That's good. I want to share the concrete data. Wait a second, please. Now I feel I need to do like this. Dear colleagues, do you see my presentation now? Say yes, we can see it. Thank you. Okay, I'll go to my presentation. First of all, I would like to tell you, as a representative of brand logo, that problems Lego brand faces. There are different kinds of counterfeits. There's a copy in the scale 1 to 1. It's more manufacturers of in the area of jelly or different chemistry. What about Lego problems? It's a trend racing. Trend racing, it's an imitation of a package. It's a look-alike. It's other constructors where there's no inscription Lego, but which imitate completely or partially our design. Correspondingly, this object of intellectual property, like trend racing, it does not exist in Kazakhstan. So we search for other ways to struggle with this problem. We register our name and we checked manufacturers of counterfeit products. They don't call their counterfeit products as Lego. They have a other red logotype on their things, and they are inspired by our lines of products. We register names of these lines, and on the basis of these registered names, to claim against these guys. We don't work with this kind of construction rights on the package and goods, and we need to be efficient. And in this case, they work better during our collaboration with legal experts of Kazakhstan. We raided 30 raids in 2023. In 2024, we organized 18 raids, and we have taken 9,000 units of goods. On some outlets, we take away 3 construction toys, and it's our expenses, of course. And with the help of mass media, we send a certain message. We don't agree with this, and rate its administrative procedure along with the Department of Justice. And this rate presupposes that we are owners and we have right to take part in this rate. And these representatives of Justice Department have authority to look at the goods and to take away all these goods and have a suit with these infringements, and then the court will rule what the destiny of these goods in order to take out these goods. We prepared 15 expertise, establishing identity or similarity to the point of the confusion with the most spread counterfeit goods. Now you will understand what I'm talking about with the help of other slides. Look at this slide. There is a package. It's difficult to work with a copyright in this case because of high standards of proofs. And these cities are our original line. If they typed with the same font, we have it's registered in the Republic of Kazakhstan. We prepared an expertise which analyzes whether they have establishing identity or similarity to the point of confusion. And Ninjago products has the same case, and there is they imitated font of our trademark Ninjago. They slightly changed our trademark, and we have expertise on this occasion. We have other options. Lego has a famous lineage of technique, and Chinese manufacturer didn't copy out our design, but they used the title. And there is a trade racing example. It's our line for the girls, the same font and the design of the package. You can see it here. On this trades, we made expertise too. And there is an interesting part. You see the picture where is one of our raids, and we have taken this a number of goods. It's not the biggest raids, but it's a large. It's look like this. We take away the goods and we calculate them. Then we write documents on the basis of these goods we have available. Sometimes there is unpacked and packed goods, and on the trading point, the collectors they distribute parts. We take away these goods, and then Department of Justice submit application to the court, and that's it. And there is an administrative case, and the infringer is confessed as guilty person because of this labeled goods as, and there is a penalty which it needs to pay. And according to sanction of Administrative Code of the Republic of Kazakhstan, it's confiscated. It's confiscated, and I will stop here, and I will I will have comments on this slide. With the participation of LEGO Group, there were held 5 measurements for withdrawal of goods. We were direct participants of these measurements for destroying these goods. For us, it's important to these goods be destroyed in order to can put back product into circulation. It will be damage for us economically. Maybe these products are hazardous for the children.
Не все товары, скажем так, были
not all products were seized or destroyed. So as you can see here, we as the company that tries to minimize our environmental footprint, we choose such meals to destroy the product that drills this products and this plastic used for the manufacturing of other plastic materials where the quality of the plastic is not that high. So here you can see the example how the product is destroyed with no involvement of the right holder. Just the car is drying against the products. So the plastic is very hard, the details are very small, and only the pack is spoiled. But the plastic itself, nothing happens to the plastic. And this is not the right way of destroying plastic that the right holder wanted to see. Then now about the problems. So when I said that the court decides, and the decision of the court provides the fact that the products must be seized. What's the problem of it? So now you can see the sanction of the Article 158 of the Code of Administrative Offenses, which says that the sanction is a fine with confiscation of goods containing an illegal image of a trade, or the or the image with a certain point of confusion. After the product is seized, the Article 158 provides for it. However, what we can see here is the extract from the decision that an individual entrepreneur should be brought to the administrative liability in line with Administrative Code 150. Kazakhstan with the fine of 110,760 tenge with the confiscation of products. The Lego constructor that consists of the real image of Minecraft. Yeah, so it says confiscation or resist, and after some time, the official trade platform that allows to do the public auction, the products that were seized appear all of a sudden in this public auction, and they are turned over in they are brought into turnover again. So you as a right holder, so you found the local experts, you found the infringer, you found the experts who believe that you paid for this, and the product should have been destroyed. Even the products were stored sometime, and you also borne the cost to keep that. And then it appears all of a sudden on the auction, on the official side. How come the ministry, I think the right holders don't need it, and those right holders who work with counterfeited products will agree with me that it is too much. So you can also see that in one of the article of the media here, the news appears that the officials sell these seized products. And now more about it. There is an article 158, and there is a descriptive note to 158 article of the code that counterfeit goods are confiscated in accordance with the article and subject to disruption when prescribed by Article 795 of this code, except for the cases where the introduction of such goods into circulation is necessary in the public interest and does not violate the requirements of the legislation of the Republic of Kazakhstan. Subject to the removal from the goods and their packaging of the illegal used trademarks or the designation similar to the print of confusion. What it means? It means that they have an enormous load, and we don't want to blame them. We feel compassion for them, but not all judges have this chance, and not all of them know the part of the section of Article 158 that prescribes the destruction of the product. That's why when the ruling is made, there is no direct indication for the need of the destruction. That's why sometimes our representatives must recourse to the court for further explanation and judicial ruling where the judges would disclose what will be after the confiscation or the seize of the product. What we need that the decision reflects that the products are destroyed. If it's not the case, then there must be an extra note about it. Judges do not pay attention to the note, but only to the main part of the section of Article 158 of the Code of Administrative Law of the Republic. What we offer, not to create the extra law that looks to burden judges, because it takes their time and the time of their assistance that extra documents for the verification that the document must be destroyed. We just want to amend the sanction of Article 158 of the Code of Administrative Offenses of the Republic of Kazakhstan relating to boards and destruction of counterfeit goods, that the goods after confiscated must be destroyed. Friends, so actually this is it from my side. I just wanted to be concise, and I will be happy if before we start the Q&A session, we will be able to ask your questions now, because as I told you, so I'm out and I will not be able to stay with you until the end.
Thank you, Anastasia. Thank you for sharing
Welcome.
the challenges of Lego and also the vivid pictures that actually show reality of counterfeiting. As you said, if there are questions from the for Anastasia at the moment, as she has to leave a bit earlier, we're happy to take one or two now. I checked, there's no questions in the chat, but Zanat, if you have any questions there.
Yes, there is one question in Telegram. I will proceed in Russian. You will hear the just.
Okay.
Anastasia.
Anastasia. So the question is from Roman. Roman Bryukhov says, how do you initiate the destruction of the product after seizing, and how do you choose the destroyers? How do you initiate the destruction after seizure? Well, after the products are confiscated, once they are seized, they are stored on the territory of the warehouse premises that belong to the Department of Justice. Well,
Мы эти товары до определенного момента, пока помещения позволяют,
until the premise facilities allow us to store them because our batch of products take place, and as long as it is allowed, we keep them there. But when these products are accumulated, every decision provides that these products must be destroyed, and they are brought somewhere and destroyed. Yet the premises of a certain contractor, there are not so many contractors that destroy it in Kazakhstan. And together with the Ministry of Justice, we travel to the place of seizure just to control that this amount of the constructor that is to be destroyed would be in line with protocols. This is it.
Anastasia, thank you. There are no other questions right now.
Thank you. So hearing there are no further questions, we shall move to the second speaker for our panel, Dmitry Bereznev from Syngenta. I understand he is there in person, so let's hear from Dmitry. I don't see him here from the windows.
Добрый день, уважаемые коллеги.
Good afternoon, dear colleagues. Good evening. I'm Dmitry Bereznev, manager of counterfeit products. I would like, in the countries of Central Asia and Kazakhstan, I'd like to introduce to you in these parts in the chemical industry and highlight some aspects we face now. Please start the presentation. Next slide, please. Syngenta company is one of the leading world manufacturers of pesticides, which include fungicide pesticides and nutrition for seeds, biopharmaceuticals, and seeds of different field cultures and flowers. Next slide, please. We observe that last the growth level of illegal trade in our area, according to data of official sources in the Russian Federation, share of counterfeit products is from 15 to 30%. On the basis of our research, and share of counterfeit products share is more than 50%. It's a chemical defense of plants. It's a high demand on agricultural products, and it's a growth of prices of the products and means that are used during the crop planting. The second factor is political instability in the world, growing conflicts in different regions of our globe. And it's a problem, it's a broken chain of supplement because of COVID-19. And one of the main factors, it's a transfer to online mode. Next slide, please. Apologies for the presentation problem. There is a one mistake. Okay, I will describe you without slides, risks and threats which are in our area. We can divide it in three sections. First of all, risks for manufacturer, company, and reputational risk threatens to trademark. Secondly, it's a growth of illegal products, counterfeit products, which is a threat for our business. And the third one is direct damage, because we don't get money from the sales for protection of agricultural products. For some of for rural subjects, it's important to use some pharmaceuticals which weren't tested. And secondly, this kind of production is packed and it provides, it has a risk, it's dangerous for the users. According to the research, we can come to conclusion that growth of hard metals, it's dangerous, and products made from dough and other eatable products has a consistency which is far away from a consistency of normal products, and there is a risk of loss of crops for farmers with the use of these kind of pharmaceuticals, because these pharmaceuticals destroy the plants. And the third one, economical problem, because the pesticides go to underground water, and the following risk to people's health. The range of our work is divided into several sections. It's any products which is not manufactured for Syngenta, but looks like Syngenta, and it's a counterfeit because it's confused people. The second section of our products, it's any manufacturing things which is given to the provided to market with the problems of registration, and which has to do with interest of Syngenta company. It's illegal delivery of pesticides. And the third section is any products with the infringement of intellectual rights, patent science, intellectual property, and so forth and so on. In the context of struggle with the counterfeit products, we use a complex approach. Next slide, please. On this slide, you can see that we have a complex approach to struggle with fake products in the context with the work with the Eurasian business. We have investigations with the leading companies, multi-brand, and we have complex solutions, and we research the marketplace. We research level of UB with governmental agencies. The second important part is interaction with the team of sales. It's a mutual work. We organize trainings to train workers in order to identify fake products, and from them we get actual relevant information of counterfeit products and shadow providers which are not identified. One of our main areas, it's interaction with marketplaces. In the framework of this interaction with manufacturing product and with law enforcement organs and the companies, and I can say that we work with marketplace, Ozon marketplace, through account of a brand. Let me highlight this option. I agreed with all you said before. In this work with bread, we have an option where all statistics on all sellers and all products they sell with our brand, we can get in data and have an investigation, and then we can deliver this data to law enforcement agencies law, it is on the base of exchange of information, and we take part in investigations and court cases. We have organized trainings for the law enforcement specialists, and we keep and utilize with drone products. It's based on the getting of the data from the customers. It's a hotline. It helps us to get the data. As a response to requests of clients, we provide answers. We take part in the cases from in the court, and we have part when the party which suffered takes part in our work. It's ongoing improvements, ultraviolet logotypes, different protection stickers on the seeds of the vegetables and sunflower, and the change of graphical design. On a regular basis, we take part in the workshops and seminars for the best practices in this area. Next slide, please. Next slide, please. And next one more time. Let us study some cases which were implemented our Department of Corporate Safety. On this slide, you can see a large-scale case. It was started in Russia from inner investigation. The investigation was started from the studying of suspicious on the different advertisement on the Russian marketplace. We made some procurements, and it showed is identified counterfeit products. Later, it was identified that initially these products were manufactured in China. All the data was collected and delivered by Shanghai policemen. As a result, they organized a raid. And there are 3 manufacturers and 2 firms, and the last 2 were worked legally. On the first shift, they produced illegal goods, and on the second shift, they produced a lot of illegal products, double tax. Russian Federation received a lot of these illegal products. Tajikistan, Uzbekistan got it too. We continued this case. It was a implementation of we organized raids against the large distributors of this gang in Dagestan. We seized 100 tons of this kind of products. On this slide, you can see a recent raid which was carried out by policy experts of Syngenta Corporate Safety Department. We saw manufacture of counterfeit products. A lot of brands were there, and the segment was the main part. There were more 65 tons of seeds of plants, and raw material was prepared. Printing presses were there, and the productive capacity for packing of these fake products. Trademarks of Syngenta company. The following, please show the following slide.
So in the Republic of Kazakhstan, we also have experience that you can see in 2023 the batch of sunflower seeds were seized of Syngenta brand 100 bags. So we started our investigation from the ads on the marketplace. The investigation was done and the information was analyzed by the law enforcement agencies of the Republic of Kazakhstan. Along with the successful cases, our portfolio has some failure cases. So in 2023, we received the information from the Republic of Kazakhstan on selling the sunflower corn seeds, and the data of the sellers were detected, as well as the information on the transport that was used for the transportation was detected. 194 million tenge was the volume, and all this information was gathered and passed to the law enforcement agencies. But unfortunately, this case was not fully implemented, as was explained by the difficulty in detecting the reasons, the wishes of the manufacturers, and we came to the distributor, and there are certain difficulties in proving our fault, proving their fault with the help of distributors. And in the next slide, you can see the key issues that we face within the activities of our counterfeited products. This is the last cases because of the specificity of our industry and the seasonality, because every drug, every city cultures, they are linked to a specific season of the year. In the next slide, the use of every drug is used on a specific phase of the plant. So if the case is prepared for a long time by the law enforcement agencies, and if this period is gone, which takes 2 to 3 months, the relevance of further sales is lost until the next season, as the practice shows. The relevance of further actions is lost, because the ones who are engaged in the illegal activities, they don't sit still, but they check how the situation evolves. After that, the situation spread across the borders. It's difficult to control the physical points. Those points don't have the documentation or documents, and you can never get the receipts or any documents, and it's difficult to initiate the raid. In many cases, it's not practical, but sometimes impossible. So we also encounter the problem of using this product in a small jar. So it's difficult not only to initiate the raid, but also to explain this information to the law enforcement agencies, because in any case, any official investigation starts with the exploration of the trademarks, if the products have trademarks on it. But if the small jar has no trademarks, you cannot do the raid, even administrative one. Unfortunately, to Dmitry, we are running out of time. Just like one phrase after, the key issue is that this is the issue of the trial purchases, because the buyers must be well knowledgeable about the product that can be used in agriculture, as well as he should know what the situation looks like among the entities of agricultural entities where they buy product. That's why we have certain problems, because we don't have experienced people in the agricultural among the ones who engage in procurement. If you have questions, please ask. That's it from our side. Thank you.
Thank you, Dimitri, for sharing the challenges of company as well as global cases and also local cases. We will take questions later, and now we move to our third speaker, Juliana Fuchs from Puma. Hello, Juliana.
Hello, hello. So also quick introduction from my end, although Valentina already introduced us very well. So I'm Juliana. I'm based in Germany, working for Puma for 8 years now. So I'm responsible for the north and eastern part and West and Central Asia when it comes to brand protection and enforcement of our IPRs. So when I started, I had only Europe as field of responsibility. So I have quite an insight now in like most of especially Europe and Central Asian parts. So I'm just gonna try to share, but I just saw that I can't share because there is still a presentation being shared.
Yes, Juliana, we had these issues in the previous panel. So if we can remove the slide that we see on Zoom, then Juliana can share her screen for her presentation. Could you please remove the slide? I'm asking for the technical support.
Just a second.
Thank you so much. Brilliant. Okay. I know due to COVID we should be good with it now, but I'm not so good with techniques. So okay, I hope it's working. Can you see it? Perfect. I see Valentina nodding. Brilliant. Okay. So my topic's gonna be challenges in the enforcement of IPRs. And I mean, lots of things I'm going to talk about. We have already heard in also my colleagues' presentations from the other brands, because I think like the challenges in general is something we all face, nevertheless, in which industry we are. But please bear in mind, everything I say, it's not speaking for every single industry, but solely speaking for the clothing and sporting goods industry. So there might be some differences when it comes to challenges for other industries and those other brand owners. So to start with, and we used to use it as a little icebreaker, but by now it's just not an icebreaker for me anymore because it just is a very scarying picture and it just reflects my daily work. So actually I hate looking at this. No, but this is just an overview of the cases we had in the last 3 years. So it's not even for decades, it's just 3 years of work. And for the specific or the areas where you can't see any red highlights or roots or anything, this doesn't mean that there are not counterfeit existing. The only reason for that might be that they have not yet been reported to us, because law enforcement's maybe not cooperating there, but sorry? Okay. Yeah, so it has different reasons why there hasn't been any cases, but to me already this looks enough. So it just gives you a little overview of what the issue is we are dealing with, and also to show that it's not only an issue of Central Asia and or Kazakhstan, but a global issue. So just to give you a little overview, because I said I'm mainly in the enforcement team, so I'm not taking care of any portfolio work, so trademark registrations, design registrations, and the like. So we only focus on enforcement, so both offline and online. So when it comes to the offline enforcement, of course, we rely on different vendors to let us know of any infringements, because obviously we can't be in the markets. But still, what we see quite often is retailers and wholesalers, stores, street vendors selling fakes, but it's becoming less. So what is now a bit bigger of a deal is online enforcement, but still, and especially speaking of Central Asia, we see still a lot of offline markets, such as wholesalers, retailers, or stores in general. And then also we very much rely on police, custom seizures, so the work of law enforcement in general. So what we do then, once we've been reported a counterfeit product, is, as some of you might also know and might be familiar with, we check the products. either physically, if we have the chance to be in the country, in the spot where it has been seized, or we just check the product pictures that have been shared with us through law enforcement, and then we decide the way forward. When it comes on the way forward, obviously we have different options. And for us, speaking of Puma, we always decide which way we want to go when checking the product. So it really depends on the case. So there is no procedure we're following. We really decide on a case by case. On case by case. So for instance, if we see 5 products being imported, but they are of brilliant quality and they're scarily good, faked our security features, then we might initiate civil proceedings. Whereas sometimes if there is 5 products being imported, we just use the administrative proceedings or just go with the destruction of the products. So it really depends on what products we're dealing with, how the quality of the product is, how the security features of ours have been faked or copied, and how many products it is. So the value also really, really counts. And of course, if we see if this infringer is repetitive. And then, of course, and which also brings me to one of the challenges we are facing, sometimes we definitely also try to initiate criminal proceedings. But, and once again, I want to highlight that I'm only speaking about the clothing and sporting goods industry. We rarely see any criminal charges. Sometimes it happens, but especially when it comes to the sanctions on imprisonment or anything the like, we don't see it that much. So what we see mainly is that the counterfeiters have to pay a fee, which is most of the times, unfortunately, compared to what they gained out of the sale of the products, a lump fee. But apart from that, unfortunately, criminal charges in our field is quite difficult to get. And then, of course, what we want, because it's not enough for us to just do proceedings and then we don't care what the outcome is. Of course, we want the products to be removed from the market, from the sale. We don't want them in the market anymore. They have to destroy the products, of course, and then at best, we also would, of course, like to have some compensation for them dealing with counterfeited and infringing products. But again, when it comes to compensation and damages paid by infringers, this is kind of tricky for us to achieve because, as I said, especially sporting goods and clothing industry is quite hard to get damages because usually courts and also infringers and law enforcement in general doesn't see the harm that such a product could potentially do to a human being. And those also compensation are usually quite low. So food for thought. Of course, those panels are not only for us to just speak to you and bore you with some presentations. We also like with you to interact a little. So what I would like to give you for food of thought is just how we can support law enforcement a bit better, especially also in Central Asia, where it's sometimes a bit difficult to take legal actions. Like specialized courts or specialized law enforcement. There is an echo. Okay. There is an echo. So we all have to discuss about what we can do. When it comes to the changes in enforcement, there has been tremendous changes throughout the last years. So when I started, most of the time I got echo. what I saw mostly was containers at seaports. So back at 2018, 2015, it was still containers. We saw a lot of stuff in the internal markets, such as market stalls, counterfeit products being sold in retail stores or at flea markets. And we saw barely any online crime. So most of the products were sold offline in the market. Also, top seizure products were like accessories, apparel, and not speaking of Puma, but in general, also when it comes to the global statistics, it was toys, games, and sporting goods. And the countries of origin were China, Vietnam, Taiwan, Thailand, Cambodia, although that has not much changed in the last couple of years. For us back then, it was three of us dealing globally with brand protection. Now, luckily, we're a bit more. Back then, we also had no case management system, so it was kind of hard for us to have all the cases reviewed by everyone. It was mainly customs, cease and desist letters or criminal cases, so there was not many options for proceedings, court proceedings. And for us, most fake products were footwear and apparel. But frankly speaking, also this hasn't changed much in the last years. Still the most famous counterfeited products of ours. So what happened on the way to this year or to nowadays? Of course, economic boom next to COVID, allowing the single shipments to hit and flood the market. And also counterfeiters understood how easy it is to do counterfeiting and to not get any sanctions on it. Because, I mean, as I said, especially in sporting goods industry, they have low sanctions on counterfeiters. So they understood how beneficial it is for them to sell them without getting punished. Also, China got a lot of shares on major international ports, and we got GDPR, which is, of course, also something good. But when it comes to our work and where the information about infringers is the most important thing, GDPR can also be a bit challenging. So that happened on the way. Also for Puma, we got bigger. We invested a lot of money in a brand image, quality design. So we a lot to grow big, to get more famous. And the counterfeiters obviously hopped on this free ride train and just joined our success and thought, well, then let's sell more Puma products. So what we did as an answer to that, we got more brand protection managers. So nowadays we're 10 brand protection managers globally. We changed the strategy from offline to a bit more online to really make sure that the counterfeits are removed from the source, because unfortunately nowadays a lot of products are being sold online. So we rather focus on the removal of online listings and online offers other than going to market stalls and have the products removed there. We have also had to deal with a lot of leaks, so products that have not been launched by us yet, but have still been already published through third parties, and those also counterfeiters counterfeited those items that were not yet launched by us. So this is also something we had to struggle with nowadays, or we have to struggle with nowadays, especially with, as I said, online world growing bigger and bigger and getting more important. And then also domain squatting became an issue. On the global side, or not speaking of Puma, but in general speaking of the counterfeiting issue, what we saw is mainly small parcels coming in, which makes it even harder for customs to check them. We all know that, and to have them seized. So what has been containers with let's say 10,000 of parcels, which was seized at one time, are now 10,000 single shipments, which is impossible for customs and police to check. Also, internal market, not so present anymore. So there are still some retail stores, as I said, still some markets, stall markets or anything they like, but it's getting less and less. And also, as I said, online counterfeiting became bigger and bigger. So quickly, going through online enforcement, and I know you've had the topic already today in the morning, but just also as a practical view from a brand's perspective, what we see in online enforcement is mainly websites. So I don't know if any brand has so many issues as Puma with online, with standalone websites. It's terrible. So what they do is they just copy the website one-to-one, the layout, and then either sell counterfeits there or don't sell anything and just try to scam people. So if you're lucky, you'll get a counterfeit. If you're not lucky, you don't get anything. So both options are not good at all. Also, we see a lot of sales on social media, such as Instagram or Facebook, but that hasn't changed in, let's say, the last 4 years. So it's been just an increase other than a decrease of numbers. And the same is also for marketplaces. So basically, whatever option you can think of, and whatever option there is online, there are counterfeits. We even had counterfeited apps in the App Store of Apple and Google. So there is everything out there. And as you all might know or can perhaps imagine, it's really difficult to get rid of all of them. Also, what we have been facing lately is live videos on TikTok.
หรือซื้อแพงไปแล้วฮะ แซวนะไหนๆก็ขอริเวอร์ด้วยแมนยูบอกเดี๋ยวกูจะ
So what we learned is, I don't know if you could hear it, with every bing you heard, there was one product sold. So this lovely and somewhat annoying voice sound came every single minute. And they had quite a huge offer on jerseys, not only for Puma, but also for Adidas and Nike and some other brands. And especially when it comes to those live videos, it's really challenging for us to tackle them because they're only online for a certain time. We can't immediately take them down. We have to get the evidence. So it's really challenging. There's always something new coming up, not dealt with, and have to read ourselves into in order to find the best strategy to tackle those issues.
หรือซื้อแพง
Okay. Actually, the sound's on. So lastly, why we do what we do. So this is just December last year, and I think it's just quite interesting to tell the case. And I did tell the case in other conferences as well, because mostly when I talk about sporting goods or clothing faked, a lot of people understand why it should be necessary to increase the sanctions on counterfeiting of clothing as well and make it more important and make people aware of what's behind. So what we've seen, it was in South Africa. There was a police seizure of bullets, diamonds, jewelry, guns, and weirdly enough, fake Puma products. So I don't know how this all fits together, but it was all within one shipment or within one. So we have traveled there, or my colleague Ulla better said, she traveled there to South Africa to inspect the product that has been confiscated and also went before court. We have luckily received a positive ruling of court, And when she came back to Germany, she just Googled infringers that were involved in this seizure or in counterfeiting, and she found out that those two guys were members and even the heads of the Islamic State, so ISIS terrorist organization in South Africa. So seeing that they have not only traded with Puma products, but also with bullets, diamonds, guns, this is also already the first indicator of the direct connection between counterfeits and terrorism or terrorist organizations, organized crime, and it highlights the importance of also seizing IPR infringements, and not only what seems at first really, really important and is also important, drugs and weapons, but it goes hand in hand. And both things are really, really important to look out for and to deem necessary enough to have them seized and removed from the market, not only for the sake of a brand, but also for the sake of the people in a country. So in this specific case, and this is also a bit sad to hear, so the two brothers, they were sentenced, but only to a fine of approximately 32,000 US dollars and a 5-year probationary prison term, which is, considering the connection to terroristic activities, not much. But there again, you see the downside of taking action and seeing the sanctions for counterfeited products. So with this little down message, I'm gonna leave you to it and to digest it, because that was basically it from my side. If you have any questions, as we've discussed earlier and Valentina said, please feel free to say them or type them in the chat, and we're gonna answer them after Mariam has also had her presentation. Thank you so much.
Juliana. Thank you. I understand that Mariam has unfortunately has to leave for another internal meeting, so maybe just a few words on actually the importance on the messaging of fake medicine, and then we will let her go.
Yes, thank you very much, Valentin. I'm really sorry. Yes, as I said, I should have maybe spoken like before. But anyway, first of all, I would like to thank INTA for this opportunity, this invitation. Yes, I wanted to say a few words, and I always take the opportunity when I have to raise awareness on the dangers of fake medicines and to strengthen, how important it is to collaborate between private sector, public sector, and obviously public and private. So to partner and exchange and collaborate with law enforcement authorities. This is really, really key for us. And maybe before leaving, I could just try to share my screen and show just a few slides very quickly. The main important ones, probably. I guess you can see my screen.
Yes.
So I'm the director of the Trademarks and Fight Against Falsification department within Servier. We handle both all the soft IP, meaning trademarks, non-industrial designs, copyright matters, domain names, but also the fight against falsification. And in that regard, one of our most challenges is to be present in 150 countries, including Kazakhstan. And yes, just to remind you of the fact that of course, every counterfeit product is dangerous, but obviously when we talk about fake medicines, it's a public health issue and it can be very, very harmful for patients. And the reason why it is really challenging and dangerous for the patient is the fact that it's very difficult to detect the fakes and to see the difference. And as you can see on this screen, the only difference between these two products remains in the fact that in the fake product, the circle surrounding the R is in bold, while it's not in the genuine one, meaning that once the product is in the patient's hands, obviously, it's impossible for the patient to see that that the product is a counterfeit one. So this is why all our aim, our goal is to try to avoid that the product reaches the patient's hands, because obviously when it's the case, it's too late. And this is why it is crucial for us to partner with law enforcement authorities, especially customs, police, and all other authorities, in order to make sure that we partner together again to seize the products, to try to make sure that it does not reach again the patients. If I had the time, I wanted to go through a few definitions, because of course, as many other industries and other brand owners, we will leverage our IP rights to fight against counterfeits, as I said, as in other industries. But when it comes to the pharmaceutical area and sector, there are some specificities, and we can also leverage actually healthcare legislations, and use other grounds of action. And we also have to deal with other realities, which is why actually our activity is more about fighting every illicit sales, not only the sale of counterfeit per se, because in that category you can find theft, especially in the oncology area, fake prescriptions, and many other different realities that also represent a risk for the patient. I'm going to go very quickly on the online. Juliana just explained their enforcement strategy when it comes to the online. And actually, it's quite surprisingly, even when it comes to pharmaceutical products, everything almost starts online. So counterfeiters will attract actually the patients through social media mainly, and then finalize the transaction offline, whether it is on Telegram or WhatsApp or whatever. But yes, raising a concern about the online illicit sales of medicines. I'm not going to detail our 3-pillar strategy, because I really need to leave for an internal presentation. But basically, we do whatever we can, whether it is internally or externally, whether it is for our own company only or in collaboration with other pharmaceutical companies, whether it is by partnering, as I said, in the frame of associations with marketplaces, platforms, with law enforcement authorities. So many different actions taking place. And yes, of course, the most important one is really collaboration. And that's why I initially wanted to have a chance to also discuss with you how we can leverage that. And yes, with the help, with our help, to try to tackle this big issue for patients. And unfortunately, let me getting back, try to stop my screen and getting back here to say goodbye, and my apologize for not being able to stay for the Q&A sessions. But as discussed with Valentina, you could feel free to send some questions in writing, and I would be more than happy to answer later. Thank you very much.
Thank you, Mariam. Thank you. And for, still sharing a very important message in such a short time. So certainly, and also very clearly. So we appreciate that very much. Bye, Mariam. And well, I should thank all the speakers, for the panels. For this panel, we've been a bit over time because we also inherited some delay of the past panels, but I'm sure that this presentation have been very focused and share the specific inputs as food for thoughts, and also raising more awareness on the challenges. So I don't see questions on the chat. I ask you, Zanat, if you have any questions from the audience.
No, there are no questions that I see. Currently, there are no questions to the speakers. Thank you.
So thank you all, and we move to the final conclusions. Bye.
Мы действительно немножко выбились.
Yes, indeed, we are a little bit far from the schedule now. It is 6 a.m. and our conference is coming to the end, as well as the renting of this premise is coming to the end. I'd like to thank all the participants and listeners, and first and foremost, the speakers, the presenters themselves, because we have heard many interesting presentations, both in the first and in the second half of the day. We used to have very interesting discussions. Unfortunately, we are running out of time, and we are still waiting the questions in the chat box. We will check all these questions. We will analyze all your questions, and we will not answer the questions that have to do with some particular situations, but we will try to outline all the issues and, that were raised today. This is the second event we hold together with the International Association of the Trademarks, INTA, and I believe that we used to have a very interesting presentation that set as the basis for similar events in the future, which hold every year, once a year, unfortunately, and we will be waiting for your friends from your side, partners, opponents as well, because opponents are also important for us, because we would like to consider the issues and problems from all the aspects, because we don't have only the right holders, those who are engaged in the IP rights protection, and also the people who have been dealing with these matters from the public sector too. We cannot say that they support either party, but these are the neutral organizations that respect the laws and help those whose rights were violated and to restore these rights. So the more opinions will be expressed, the better and more constructive our dialogue will be. And monologue or dialogue, it doesn't matter. It depends on the number of the parties and multi-log as well. So it's so difficult for me to tell me what the next format of the event will be. But the format is expanding. Last year, the topics were only had to do with counterfeited products. So this year, this is on not only combating counterfeiting products as well as unfair competition. It depends on the expansion of interest on topics, and this expansion of interest on topics will condition and will define the topic of the next events. Probably we will have 1 day or 2 days format of the conference. It was a great pleasure for me to see all of you here today, to talk to each other, and hope that you enjoy this meeting with each other. We will be waiting to see you in the same composition. By the way, the geography is also expanding. This year we have the speakers and participants from a greater number of states, from far and from abroad and former Soviet Union countries, and we will be happy to see the presentations in different languages. And it represents the global coverage of our Central Asian event, but it allows us to think about the outlooks and further expansion of such events. And so far, thank you very much for joining us so long. For the ones who went from far abroad, I wish you a very good trip back home. So I wish you to have a very good flight back to those places where you work or you feel home. And I wish you yourself to overcome these traffic jams in a good